makan. Halo, sound. Halo. Good morning to all. Students, please sit down. Please sit down. Now today this second day, fourth technical session. There are 5 themes are there. In these themes, 7 participants are there. Ramesh Chandra Behra, if available, sir, are you available? Okay, right, please. Come and sit here, sir. Then next, Rahul Parvatel Chumi. Is he available? Okay. Then Haripriya is available. Then Dr. Ramachandra. Then Professor A.S. Srikant Babu. Murali Mohan Raju. D. Sonia. Sonia is there. Okay. Dilip Kumar Mahapatra. Dilip Kumar is available. Now Ramesh Chandra Behra is there. Rahul is available. You are only, no? Right. Now your PPTs you please check up. PPTs. Haripriya, PPTs you please check up. Dr. A. Ramachandra. Srikant Babu is here. Sonia is here. Dilip Kumar Mahapatra. Check your PPT. Now there is one more announcement, please. R. Surya is available? Okay. Lawn social change, you want to present a paper? Okay, if time permits, I will call, be ready. Then Kanduru Jnani, you also be available. Then Kartika, huh? Okay. Akhila is available. Then KL Bhargavi, you be ready because after these regular participants, then you will be allowed. Sheikh Azhar Ahmad, then Swagatika is Meghana Mariam, then Akshay. Okay, you are also presenting. Jnane. Guganeshwaran is there. Then Prabhakaran, Mana Prabhakaran. Okay, this we will allow. Right. After this session, we will allow. Yes, in this only. Ipude cheddam. Takku unnaru.
Can you please call last technical session presenters so that if there are more 16 presenters are there now.
Eppudu? Next, 5th?
Sixth.
No problem, that we can do.
We can have a next parallel session also. I'll call.
వద్దు చేసేద్దాం ఇప్పుడు అయిపోతుంది నేను చేపిస్తాను
16 అంటే 2 hours
ఏం కాదు కొంచెం తగ్గిద్దాం అందులో
అక్షయ్ని ఒక 5 members తర్వాత అక్షయ్ని పంపించేయండి. He will be rapport here in another room.
ఓకే రైట్.
Not now, after.
ఈయన శేషాద్రి నాయుడు ఏది? ఈయన శేషాద్రి నాయుడు వచ్చిందా?
వచ్చి జాయిన్ అవుతారు.
స్టార్ట్ చేయనా? ఓకే, టైమింగ్ యూస్ ఊరు పక్కన కూర్చోండి. Ramesh Chandra Behera sir, please ready. Good morning to all. All of you sit down, please. Students, please sit down. Now today's fourth technical session, please silent. Fourth technical session, the topics are innovative access to justice initiatives, pro bono and social responsibility, restorative justice, a shift in judicial approach, new criminal laws, a justice oriented approach, bail reforms and the decriminalization. For this technical session, Chairperson Justice Dama Sheshadri Naidu garu, he will join with us shortly. And now the co-chairperson, Professor Meena Saketan sir is there. And this, I will read this CV of the Sahu sir. Dr. Meena Ketan Sahu is presently working as a professor, PG Department of Law, Sambal University, Odisha. Dr. Sahu has had an outstanding career with LLB, LLM and PhD from Berhampur University, Odisha. He has worked as a lecturer in Odisha and West Bengal, as assistant professor in Hidayatullah National Law University, Raipur, Chhattisgarh. He is having 21 years of teaching experience. Dr. Sahu is presently pursuing LLD under Sambalpur University. Dr. M.K. Sahu has been taking keen interest in criminal law, criminology, penology and victimology, intellectual property law, women and law, constitutional law, international law, Dean Faculty of Legal Studies, twice as Public Information Officer, Deputy Registrar SV, Director, IQAC and Nodal Officer, PM Usha and Resource Person of Academic Staff College, Sambalpur University. Like this, there are so many credentials are there. I welcome you, sir, for this technical session 4. And now we start. And now this Damu Sheshadri Naidu sir will come and join with us. Now today's the first speaker is Dr. Ramesh Chandra Behera. I request Dr. Ramesh Chandra Behera. His topic is on voice of the poor and the pro bono. I request the paper presenters to be brief within 5 to 7 minutes only. Because of the many participants are there, you please kindly restrict to this 5 to 7 minutes. Thank you.
Right, sir, for next slide.
What?
This slide button for next slide.
Oh, okay.
Good morning to you all. Myself, Dr. Ramesh Chandra Behra, working here in Dr. Ambedkar Global Law Institute as Associate Professor. And my respected co-chairman, convener madam, and faculties and presenters, and my dear students. Today, my topic is voice of war and pro bono. The thrust area of this pro bono legal service. What is the prospect and what the present scenario in India and how it came to take the historical background also. Something I have to give you a glimpse on it. Pro bono, the word is Latin word, pro bono publico, which means for the good of the public good, purpose. So how it related with your legal paternity and legal aspects? We have to go through the matters here. You find pro bono publico, service provides for public good. Basically, before independence, our life was under the control of the British rule. Torture was going on there. Various aspects by which Indian people were suffering. Poor's voice was not raised in any forum. After independence, we have our enactment of, that is our Constitution of India. Even after enactment, no provision was there. What is that? Lower public service, because the Britishers has left the system of adjudication of justice that now we are following. The same procedure is that, but there was no provision for the voice of the poor. Those who are deprived, marginalized, vulnerables, SC, ST, women, and disadvantaged groups also have no probability of representation themselves in proper forum, in particular area, particular to get administration of justice. So justice was a dream for them, for number of deprived groups. So what happened? Last half of the 20th century, however, revolution became revolution, and definition of pro bono increasingly meant free legal representation for indigent persons and public service by lawyers simply meant uncompensated legal work. That is a definition given by Gray, Munne, Mellon. Ethics of practice, Professor Deva wrote, she calls lawyers to formalize an ethical duty for to provide legal service to individuals in a limited means. That means all the lawyers and advocates, those who are in practice, they have to contribute some of their time for the public good. That is the USA law firms, US that is bar associations, they have conferred on the all lawyers 50-hour services should give for the public good per year. Compulsory they have interested on these groups. So what is this? The order society and giving an accessible shape to the justice administration system. This is a pro bono legal work. So lawyers how can give, how they are useful to society because they are the elites, they are the leading persons of society, they are guiding persons of society. For that say they have a better role for perform. And where, that is another thing, due to financial barrier, no one should be deprived to get justice. Under Article 22, provision is there on the Indian Constitution. And then 74th Amendment, 1976, 39A article is added to the Constitution of India, where provision is there for legal aid, legal assistance. Then in the year 1987, our NALSA, National Legal Services Authority, came into existence in India to provide assistance to lawyers, those who are interested to be involved in voluntary service. That is not unpaid service. Some payment is paid by the government, because pro bono means unpaid service. Without payment or little payment, we have to work for the poor. So some example I am telling about where I was working, Bonamasi Sarasram, you will find in UP. 1993 I was working there. A radical change was brought in the India. Thousands of tribal peoples were under cultivating in forest lands. That is Indian Forest Act 1927. The provision is the reserve forest they have been declared. But section 4 of the act is there, where there is the customer right should be given preference. That means hereditary, though they are cultivating, no one is raising voice. This Bonamai Sevasram raised the voice, and one letter was written by Prem Bhai Vasta, that is written petition filed under Article 32. But at that time, Justice P.N. Bhagavati was judge of Supreme Court of India. He take recognizance, and that was filed as a PIL, public interest litigation, by which thousands of people were benefited, and justice was imparted at the doorstep of the people. 5 ADJ courts were settled there, and the additional district judges were the chairman of the court, and assistant record officer were allotted to that court. They visited the field and gave judgment in favor of the people, those who are hereditary cultivator of thousands of years and was harassed by the forest department. So radical change was made. Then the PIL also, another case we will find here, Hasinara Khatun versus State of Bihar, 1979. Thousands of under trial prisoners were there, no one was hearing. Number of years they are languishing in the custody. But this case was filed by a group of lawyers. The lawyers, in the name of Hasinara Khatun though, but the lawyers filed the case, and the judgment was given by Justice P.N. Bhagavati, and this case is the guiding case by which the public interest litigation came into existence. But that means any public matter which is not redressed properly, that can be redressed through your public interest litigation. That's the Supreme Court guideline, Supreme Court or High Court, where you can also file all those things. I am not taking much time. Number of cases, MC Mehta, Union of India, State of Uttar Pradesh, Rajkumar, legal aid. Regarding legal aid, that those who are deprived, those who are underprivileged, those who are not able to get justice to raise their voice in the proper forum, they are getting benefit out of this. Number of judgments are Khatriwal others, State of Bihar, Raju and Ramaganj State of Madhya Pradesh also. All these things are there for the protection of the right of the deprived, poor and vulnerable groups. Now in India, in 2017, shortly I am telling my article is a long article of 2017 Government of India, they introduced 3 schemes, pro bono, legal service, tele-legal law service and Naidu. Now any lawyer, advocate, he desires to be a pro bono lawyer, he can register in this portal that is called your tele-law service. Then also National Legal Services Authority of India and State Legal Services Authority of India, they have opened their portal. You can register your name to be in the panel of the pro bono lawyer and to give justice to the poor, deprived and other communities. Another is Naidu scheme. In that scheme, they also have appointed some, that is your,
Hello, Dr. Behra.
yes sir.
It's a nice presentation, but come to the findings of your research paper, please.
That conclusion I am going to that. That is, pro bono is the speech for speechless, voice for voiceless, and word for wordless. Those unrepented group, that is a pro bono good legal service by which their voice can be raised at the proper forum. This is the finding, and it is a good service. Number of NGO, iPorno India, and others they are working in this field, and any deprived group can take the assistance of this service. Thank you, sir. Thank you very much for my
Dr. Behra, wait. The topic selected by you really praiseworthy, but let me know what type of research paper it is, whether it's you have pursued the doctrinal study or the empirical study on the specific area of research.
This is how legal aid service can be imparted in India, and also how can people take the advantage. Even Ajmal Kasab, who was the only accused, surviving accused in Mumbai attack case, also give him the pro bono service to him in all spheres, in the trial court, appeal court, Supreme Court of India. That means no one should be deprived to get justice due to lack of economic inability. This is the.
Okay, okay, okay. But, okay, fine. Thank you.
Thank you very much, Behra sir. And now there is a small break. Now our
Okay.
guest has come. Justice Dama Sheshadri Naidu is going to join with us, and there is a small brief of that Justice Dama Sheshadri Naidu garu.
How many from that side? Yes. Okay. Save it like one. Sure. I will give you my number. I listen to during presentation. Presenter during the case. Both audience. That's what. I'll do the yeah.
All other paper presenters be ready. So after this program, then you have to present your papers. All of you sit down, please. The chief guest has come. Welcome, sir. Welcome. Good morning, sir. Sit down, please. Sit down, please. Good morning, all of you. Today is the second day session, the fourth technical session. Today's chief guest is Honorable Justice Dama Sheshadri Naidu, sir. We are holding the second day. The technical section 4 is going to start. The subtopics in this session are innovative access to justice innovatives, pro bono and social responsibility, restorative justice and a shift in judicial approach, new criminal laws, a justice-oriented approach, bail reforms and decriminalization. So this is the technical session today. In this regard, I request Honorable Justice Sri Dama Sheshadri Naidu, sir, kindly come on to the dais. I request the student to present a bouquet to sir. Welcome you, sir, Dama Sheshadri Naidu, Honorable Justice, High Court of Bombay, retired. Thank you, sir. Thank you very much. I request Honorable Justice Dr. V.R.K. Kupasagar, sir, High Court of Andhra Pradesh, Justice, retired. I request you, sir, please come on to the dais. I request the student to present a bouquet. I request Dr. A. Ramireddy Garu, advocate. No. Okay, sir will join later. Then I request Professor S.V. Pullareddy Garu, retired professor, SK University Anantapur, to come on to the dais. I request the student to present a bouquet to our guest. Pullareddy, sir. Thank you, sir. Thank you very much. I request Dr. R. Tippareddy Garu, Chairman, Dragli, Tirupati, please come on to the dais. Student, please present a bouquet to our chairman, sir. Thank you, sir. Thank you very much. I request Dr. Professor Vijay Kumar Behera, sir, Principal, Dragli, come on to the dais. Thank you, sir. Thank you very much. I request the student to present the bouquet. I request Dr. Ashwini, convener of this seminar, national seminar, please come on to the dais. I request the student to present the bouquet to the convener. Thank you very much, madam. Now today's inaugural program, this is
complete. First and second session. Inaugural.
ఇదే కదా Welcome you all dignitaries, sirs, judges and the professors. Regarding other dignitaries, we have already introduced Now today's new dignitary is Honorable Justice Sri Dama Sheshadri Naidu sir. He is a distinguished retired High Court judge, High Court of Bombay, and scholar, a senior advocate now, known for his prolific legal writing and insights, having served as a judge in the High Court of Andhra Pradesh, Kerala, and also Bombay. Before resigning to return to private practice, where he was later designated as a senior advocate by the Supreme Court of India. He is recognized for his expertise in constitutional, civil, and criminal law, authored several law books, and is a popular guest faculty at judicial academies. Also known for his passion for literature and neuroplasticity. So, sir have many other qualities are also be there. Sir, this is the technical session we are going to start, and in this regard, I request Honorable Justice So because today is the second day special session, regarding this, I request Honorable Justice Sri Dama Sheshadri Naidu Garu, Judge, to deliver a address to our faculty, research scholars, paper presenters, and also the students. I request you, sir, please kindly address this session.
Thank you very much. My dear brother, Dr. Justice Kripa Sagar, a friend of mine, Professor S.V. Pulla Reddy, and the closest to my heart, Dr. Tippa Reddy, and Dr. Vijay Kumar Behra, if I wonder whether I've correctly pronounced it, and Madam Dr. Ashwini, all the dignitaries here, the faculty, the students, and everyone else included. Thank you very much for having me here. A couple of weeks ago, my friend, my mentor, Dr. Tippa Reddy, told me that I should come to Tirupati and visit the college and participate in this seminar. Earlier too, a couple of years ago, I came over here, and this is my, I believe, second visit. And I belong to this place. My village is about 7-8 kilometers precisely from this place. So I studied in Tirupati, got employed in Tirupati as a bank employee. Then I did my law as well, then evening college in Tirupati. Later, I resigned, and then I started my practice in Tirupati courts. 4 to 5 years I practiced here, then I moved over to Hyderabad, then the combined state. Of course, then later I became a judge. And again, as I'm used to resigning, once again I resigned. And now I'm an advocate where I can't resign any further. I can only stop practicing or else practice continuously. That's my background as far as I am concerned. You know, when I had my college here in 1993-94, I passed out in 1997. I enrolled in 98. By then, Ambedkar Law College was a sapling just growing. I used to hear about it. Now, it's become a massive banyan tree. And I have seen the tireless efforts put in initially by Dr. Tippareddy and Madam Tippareddy. They are the two eyes, or perhaps the heart and lungs of this institution. Now the whole family business it's become, including their beloved daughters. You can imagine the quality once something is close to your heart. That's what this institution is as far as Dr. Tippareddy's family is concerned. And all through, I always took an opportunity to go to any college and share my thoughts perhaps or ideas for the simple reason I've never had any formal education. So I thought the way I try to come up in profession may serve as some sort of a guidance to young minds, because there are two ways to reach a destination. Have a proper plan and then reach your destination. Still sometimes start off somewhere, but you have that indomitable urge that you should prove yourself. You may as well do it. Please remember an interesting incident. I passed out, then I enrolled. Until my enrollment, I never saw the court physically, only in the movies. So, with enrollment, newly stitched court, I went in search of the court in Tirupati. Somebody guided me, you go this way, this way, this way. I went there. I didn't know that I should join a senior. I thought that I had a degree, I should practice. So I went over there. Then I started watching. Some senior was arguing. I felt impressed. In Junior Civil Judges Court, I saw him arguing. I felt impressed. He must be in his 60s or mid 60s. So I asked another lawyer sitting next to me, he's doing well. What was his experience? I asked him. That advocate told me he has 30 years standing. So I thought, to be like that, I need to wait 30 years. Then, the day I enrolled, I was 35. So I had to wait 30 years, means 65. The life would bypass me. Can I afford to wait that much? Difficult. So I asked the boy, sitting next to me, and a fellow advocate rather, how many hours does he work? He said, he works 10 hours. Oh dear, 10 hours? That means I need to work 10 hours a day, again 30 years. I thought it was impossible. I chose a wrong profession. Then I asked him, no, not that he's coming to the court and doing, actually how many hours he studies. He told me, he must be studying 5 hours a day. Young friends, you know what? Then I thought, if I study 5 hours a day, it takes 30 years. If I study 10 hours a day, it takes 15 years. If I study 15 hours a day, it takes perhaps 5 years. And lo and behold, I studied as a lawyer 15 hours a day. That was simple mathematics. I was no scholar. To tell you a startling fact, when that senior was arguing, he started citing AIR 1982. I'm a radio buff. That means there is a word called the international radio stations, and you can as well listen to them, and it's a hobby. And I'm an avid radio listener. Even in my smartphone, you can see about 15, 16 internet radio stations. Always I listen to them. It's a hobby. Good or bad, it doesn't matter. It's a hobby. So I told him, I listen to radio every day. I have never heard in AIR any cases discussed. He said, within himself he must have said, idiot, you didn't know that, you became a lawyer. But true, I became a lawyer without knowing what AIR stands for or stood for. Then he said, AIR means All India Reporter. That's my knowledge. That was my knowledge. So friends, it never matters where you started off. Right? You know, I always used to tell, if you access YouTube, there are about more than a dozen of my lectures where I shared my ideas. And in one of the lectures I said, any of you could answer me that one. The sky is very clear at night, no clouds. It is totally starry. That means all stars are visible as far as your eye could see. When that's been the case, if you start counting each star, how much time does it take? A decade, 100 years, 1,000, or impossible? Could anybody tell, please? Have a wildest guess possible and let me know the answer. If you can, please. Whatever answer you want, please remember, as a lawyer, you should remember one thing. There are no right answers, there are no wrong answers. This binary thinking, white and black, right or wrong. No, every answer has its own shades. There can be more than one correct answer. So never get bogged down as a lawyer whether you are doing right or wrong. What matters is you should be doing it and do it. So I said answer. I've never said right answer. Give me an answer, whatever you feel like. They're all subjective, you know that one. Please, anybody could give me an answer? 1,000 years. Thank you very much. Thank you very much. Anybody else? You can have your own perspective. It can be 1 minute. Can you count all of them in 1 minute and tell the number? I'll wait. I'll cancel my flight. I'll wait tonight. Let's do that one. Thank you. Thank you. Yes, madam. Infinity. Thank you very much. Well, a mathematician has counted. He has said it takes 4.5 years. You imagine the night never ends. It continues, clear, starry. You start counting. A mathematician has said 4.5 years. Why I said that is, most of the things in life appear 1,000 years or infinity, but they're all achievable. Right? The power of incremental learning. You know, one lady in Lucknow studied her MA in Hindi medium. Nirja Chaudhary, her name. And she studied, her family migrated to Delhi. And she tried for a job in Delhi, not to be a burden to her family. She went everywhere. They all said, it's the national capital. You should be proficient in English. With your Hindi, I don't think one can accommodate you. So she was dejected because she was not that good enough in English. She studied all through in Hindi medium. So she came back home. She started learning English. No, she got a crazy idea. What if I learn the whole dictionary by memory? She developed her own mnemonic techniques or memory techniques and learned the whole dictionary of 1,200 pages, Oxford English Hindi Dictionary. She is the only person in the world who has memorized the whole dictionary. And she wrote a book, Superb Memory, by Nirja Chaudhary. Any of you can read. There is another guy, that is Joshua Fire. He wrote a book, Moonwalking with Einstein. Why I said, as lawyers, you'd better develop this skill of remembering things. They are very simple, and you read either of these books, you can surprise or amaze every one of your friends with the array of your knowledge. Well, let me come back to the topic. The topic, as I understand, is navigating the future of law, innovation, ethics and excellence. But the moment I saw this one, of course, Tipareddy sir told me, sir, you can talk on anything. You need not confine yourself. You know, I've been a faculty in judicial academies. I always choose a topic which is not the subject. For example, I never teach Transfer of Property Act. I never teach IPC because you can catch hold of me when I make a mistake. I talk about, say, ethics. I talk about future of law because I don't think you will find fault with me whatever I say. So I play safe. So this is also a safe subject for me because there's nothing like statute here to say that I've said something wrong. No, navigating the future. Are we going to navigate the future or future is going to navigate us? I think it's the other way around. Future is going to navigate us. How? You know, in every profession, say for example a doctor, he studies and he starts his practice. You have faith in him, they'll have a board, you are in safe hands. We can't write as lawyers. They'll say you are in safe hands. You go to him, you get treated for whatever problem you have. Well, you don't get the relief. You go next time, he changes the prescription. It goes on like that. Nobody is going to touch him and say, no doctor, you're wrong. Right? We just implicitly trust him. And take an engineer. An engineer, he has had his education, he builds, he does many things. Nobody is going to say he's right or wrong. But a lawyer, when he stands, he has to perform. His opponent counsel always ready to pounce on him saying you are wrong. Even if he doesn't, the judge is there to take care of him, to correct him. So a lawyer faces battle every day. My degree, my marks, my gold medal, I've never had, I passed in second class. Whatever that is, that will never help us. Because you have to stand and you have to deliver. And you have to pass the test of your opponent, the test of the judge. Many people used to advise me when I started off, saying, as a lawyer, you should have good public relations. And you should have network. Please remember, you'll have good public relations, you'll have network. What is that going to happen? A friend will come to you, or somebody will get impressed with your public relationship, and he gives you a case. He waits when you do it. If you can't perform, he will never come back to you. Instead of wasting our time in socializing, better be with the books where we can deliver. So this is one profession where your reputation will not come to your rescue. Your connections will not come to your rescue. You just have to perform. One more thing. If a doctor studies, whether he upgrades his knowledge or not, doesn't matter much. An engineer doesn't matter much. When it comes to law, it's something like a river. Law flows like a river. You can never step into the same river twice. Every time the river changes. There's a beautiful book on that, A Foot in the River. Please read that one if you want to. You will learn quite a lot, not about law, but please remember why I am telling about these books. The greatest advocates of India, say Palkiwala, and say Servoy, they know more literature than law. Without having exposure to literature, you can never become a great lawyer. When Servoy was invited to adorn the Supreme Court bench, he was an Advocate General in Bombay. He was in his early 50s. Had he accepted that, he would have been the Chief Justice of India for 8 long years. He got the invitation from the then Chief Justice of India. He took it, he went home. And he told his wife that I've got an invitation or an offer to be the Judge of Supreme Court of India. Should we accept? I was told, subject to correction, though he was in his early 50s, he had small school-going children then. And they both said, they just entered from the school into the house. They said, Papa, let's not move, we'll be missing our friends. Then he wrote back to the Chief Justice of India. This letter extract is there in his 3-volume Constitutional Law of India. He wrote to the Chief Justice of India, Dear Chief Justice of India, it's an honor that I've been invited to adorn the bench, but I regret my inability. I couldn't come. I have 3 priorities in my life. 1, family. 2, literature. 3, law. Strictly in that order. That's what he said. He put literature above law. And about Nani Palkiwala, what's been said, had he not been a lawyer, he would have got us the 2nd Nobel in literature. In English literature at that. That was his depth of literature. So he had that praise. For example, have you heard about Charles Dickens? Yes. One of his books, could anybody tell? Charles Dickens is mostly quoted by Supreme Court. Well, one of his books I'll tell, that is Bleak House, A Tale of Two Cities. There are so many other things. Why I've quoted Bleak House? For this reason. If you take Bleak House, it's about law. A novel concerning a case. John Dice versus John Dice. But in that book, you will never see the word versus. You will only see John Dice and John Dice, a family partition dispute that went on for 30-40 years. So he comments about the delay. Why did he comment about the delay? 2 reasons. One is, he was an uneducated, those days self-taught, law clerk. Charles Dickens was a law clerk. And because of his exposure to the courts, he wrote good books. And in that one, I said John Dice and John Dice, not versus. You know why? Initially, these law clerks, not well educated, they were writing John Dice and ampersand and John Dice. John Dice and John Dice. Because they could not write properly, instead of this ampersand, they put V. Later we started reading that as verses. It was not verses. If you read good literature, these are the things you get. Once, have you heard about the doctrine of lateral support? The doctrine of lateral support. Any idea? I'll tell you an example. I never knew, though I became a judge. Once I was reading a novel by Perry Mason. Earl Stanley Gardner is the author. Perry Mason is the character, like Sherlock Holmes. It's an American detective stories. Perry Mason, in that one, what happens? A poor man has a house, modest house, on a plot of land. A rich man buys the rest of the property in the vicinity. So he sends a word to this poor man, look, I wanted to build a big mansion. Please sell that one to me. That man refuses. I've got my emotional attachment to this piece of land and this house. I don't want to sell it. This rich man offers him very good money, but still he refuses. Then what the rich man does, he starts digging on his land to build a house. He dug so deep that that would make the poor man's building fall. Technically, he was digging on his own land. He never trespassed. But that would endanger the neighbors. So the neighbor got startled. He couldn't resist the might of this man. He wanted to have some legal advice. Then he goes to Perry Mason, the character in that one, a lawyer turned detective. And he says, no, I'll fight your case. And he fights on the principle of doctrine of lateral support. That means, even this is elementary principle in a sense. Even when you are doing on your own land, if it endangers something on the neighboring land which had been existing before that one, they would get the protection. Doctrine of lateral support. I came to know only through a novel. And you take Agatha Christie. You know, once a real incident, a patient was admitted in London hospital suspected of poisoning. You know, the problem with treatment of poison is they should know what type of poison that is. Then only they could have the antidote given. Once they know the type of poison, they could give the antidote. The doctors were clueless. The doctors were clueless about the symptoms and the type of poison perhaps administered to that victim. One nurse told the doctor that this must be the so-and-so poison. And they examined, it was found to be correct. They asked her, how did you know when the doctors didn't know that? She said, I read regularly Agatha Christie novels. In that one incident, poisoning, the symptoms are similar, that's why I've come to know. Right? I'm only telling, it's another facet. You know, as Lord Denning said, we need not be master of all, or rather master of anything. We should be jack of all trades. Because you may have to deal with medical cases, you may have to deal with engineering problems, you may have to deal matrimonial problems where psychology is involved. You have to deal as a lawyer with every facet of human failure or success for that matter. So your eclectic or widespread reading makes you a better lawyer. And let me come to this innovative part. You know, earlier you are appreciated for the performance you have made. Now in my office, apart from my office colleagues, I have a few interns as well. They come, they sit, and I give them some research. Initially, they always come with their laptops or iPads or cell phones. I give them the work. Before they leave the door, they come back and give the answer. Thanks to smartphone. But the problem is, this is called Google illusion. Have you heard about this word? Google illusion. You know what happens? If you don't know the answer to a question, there is a possibility that we feel ashamed that I didn't know. I had to betray my ignorance. So we tend to learn. But now, our extended personality, phone. So what happens the moment I ask a question, you can search and you give it. You never feel it is a machine that gave. But as you want it, as you navigated to the answer, you feel you gave the answer. So you never had the urge of learning. Now I have started this technique. The moment any intern comes, I ask them to surrender their phones and laptops to me. And I tell them, here is the library. I boast of one of the biggest libraries. And go through the books and then give me the answer. Why? I tell you the reason. The reason is, when you take, which is the best AI for legal answers? Can anybody? You must all be access to AI. I will come to that one in a minute. Which is the one you love to? Perplexity. Perplexity by whom? By an Indian. There's a reason why you must have been loving it. Perplexity by an Indian engineer in his 30s. Well, any other thing? ChatGPT. ChatGPT is jack of all trades. It does everything in bits. Never specializing. Yes? What else? Sorry? Copilot. Copilot, all right, because Microsoft, it crashes 100 times, it survives one time. Next one. Have you heard about Grok? G-R-O-K. Grok by whom? Elon Musk. Grok was developed by his company, Elon Musk. Anything else? Claude. Claude. Claude is good for drafting. See, all these AIs have their own specialization. But let me come back to this one. You know what happens when you take recourse to, for example, any artificial intelligence, it straight away gives an answer. perfect. But when you read a book, see, for example, I have asked my colleagues, when it comes to compromise decrees, please listen to this one. When it comes to compromise decrees, should they be registered? Section 17 of Registration Act says, if the subject matter of the compromise happens to be the suit schedule property, it doesn't require. But if at all it is beyond the suit, new property has been brought in, it requires registration. Then judicial interpretation has said, if it concerns any pre-existing interest of the party in the property, it doesn't require registration. If it creates right for the first time, it requires registration. This is what the law is. In one of the cases I've been arguing, I'm arguing in Supreme Court. Somebody had part performance under Section 53A of Transfer of Property Act. Possession was delivered based on an agreement, and later they did not execute the sale deed. He files a suit for space performance. In that one, they got compromised. A compromise was decree drawn. In that one, though it was a mere agreement of sale, title was given to the agreement holder. Now the matter reached Supreme Court. Other side argues that is void for the reason of non-registration, which is an incurable defect. Because it conferred title on him, can there be a title by way of a compromise? Admission or compromise will never confer title, is their argument. I have asked my interns to examine 53A. Does 53A amount to creating pre-existing interest? They came with answers within 2 minutes. I said, don't. Take Mullah's Transfer of Property Act, or at least Avatar Singh's Transfer of Property Act, and read. Why I say read? To look for a point, you have to read many things, and collaterally, you will come to know other things also. So in some other case, you may need some other point. Because of your exposure to the commentary, you are better placed. But if you zero in on an artificial intelligence aided answer, you know only to that one. And also I advised, and I still advise, the best way to learn law is not to read commentaries. The best way is to read law journals. Why? You know, when you read a commentary, law is quite abstract, without any backdrop to that one. But when you read a judgment, it is like a story. Facts are set out, the rival arguments have been set out, and you will come to know how in that conflicting scenario, a judge marshals the fact, applies the law and gives you. It is something like a story which sticks in your mind so that you don't forget. So the best way is, please subscribe to, or even online, any one journal, try to read it cover to cover, you will become unstoppable. And finally, artificial intelligence. Of course, the cliche or something like hackneyed or quite often repeated way is, it is a good servant but a bad master. All right, but problem is, it has become inevitable. It has become inevitable. I'll tell you, in London, there are about 32,000 streets. London has 32,000 streets. To be a cab driver in London, you need to know all 32,000 streets. What these Asian boys of Asian origin, India, Bangladesh, Pakistan, they may have migrated there. Those boys, they take a motorbike when they were about 18 years and they navigate next 2 years every street. It takes 2 years for them. Thereafterwards, they write the exam, they get selected. That's why most of the cab drivers earlier were of Asian origin, because they take the trouble of going through and remembering. One, since at the time of introduction, my passion or pet subject was neuroplasticity. That's why I'm telling this one. You know what happens? The frontal lobe, the front part of your brain, remembers spatial things. Anything related to space, it stores here. You know, one neurosurgeon examined these cab drivers whether they have anything special in their brain. Because of 32,000 streets, they remember their frontal lobe is slightly bigger than the normal. Literally, your memory has expanded your brain. And later, GPS has come. Now they have stopped this and they simply have GPS. The same set of drivers that neurosurgeon examined later down the line 10 years, it shrunk. So technology more than half an hour a day makes or leads to brain atrophy or shrinking of brain. Please remember this. If you want proof for that one, please read an author called Daniel Amen. He has entered into Guinness Book of Records as well for having studied millions of brains and evaluated them with regard to how they perform. He is Daniel Amen. He has written half a dozen books. You can read any one of them, where he says the narcotic drug and internet trigger the same part of the brain. Please remember, the narcotic drugs and internet trigger the same. So they become addictive, first thing. Because it's called dopamine rush. And the second thing is, the more you expose, the smaller your brain becomes. If you want to be really sharp, touch the books, not your smartphone. Because that is smart, not we. So my friends, I only say one thing. When Einstein had his schooling, he wanted to do polytechnic. Those days there was no engineering. It was only polytechnic. He wanted to do his polytechnic. And he went to Munich in United Germany then. He wrote entrance. And Latin was one of the compulsory subjects. He was very weak in Latin. He failed. He failed. Then he has come back home dejected. His father was a successful Jewish businessman. He told, son, why do you struggle with that one? Instead, come to my trade, my business. You can learn the tricks of the trade, you can flourish. So Einstein was caught in the haunts of dilemma. He was in two minds, whether to choose his father's path or again make an attempt and become whatever he could after completing his polytechnic. Then he came across a sentence from a book by Jefferson, an American scholar. That sentence is, if you indomitably stick to your instincts, one day the world will come round to you. If you indomitably stick to your instincts, one day the world will come round to you. So whatever your faith, whatever your belief, whatever your dream, stick to that one. Let people laugh. Right? And one day the world will come round to you telling that you are right. If you want to read a wonderful book on that topic, I recommend Bounce, B-O-U-N-C-E, by Matthew Syed. Please read it. It will change your life. Bounce by Matthew Syed. Please remember, there's nothing like intelligence. There's nothing like knowledge. We are all equally endowed with absolutely fine faculties, including our brain. Nobody has a superior brain. Nobody has a superior memory. We're all equal. It only depends how we approach, how we adapt ourselves. So, in American schools they say, your thumb is unique and you must be also unique. You are not somebody, you are thumbody. Right? That way, never accept in our profession to be the second best. Why can't you be the best? Try for that. Thank you very much.
Thank you very much, sir. for giving insightful information to the audience. Okay. How to become a successful lawyer? Sir advised, read books, novels and also journals thoroughly. And regarding the power of incremental learning also told, and give importance to family, literature and also law, and the role of that is artificial intelligence and also its impact, and what is the doctrine of lateral support, and how lawyers face battle with many during their practice. Thank you, sir. The insight you have given, so that is very excellent and useful to our students as well as all scholars sitting here. And thank you very much, sir. Now there is a felicitation. Felicitation to our Honorable Justice Dama Sheshadri Naidu garu. Here a small facilitation by the chairman of our college, Dr. R. Tipareddy garu. Our founder, Vice President Sharadamma garu, the wife of Chairman Sir R. Tipareddy garu. A small felicitation to our Honorable Justice Dama Sheshadri Naidu garu. Big claps, big hand claps, 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 claps. Thank you very much, sir, for advising our students and also giving a wonderful presentation and to our students. Thank you, sir. Thank you very much for sparing with us. Please come, all the faculty members. Madam Sita Kumari Madam and also Behra sir, please come. Sahu sir, please come. Meena Ketan Sahu sir, please come.
Madam, please, madam.
Faculty, please come. Faculty members of Dragli. Madam kuda ramman type hoyi kada. Madam. ఏంగా తీస్తారు దేవి. Yes. No, this lady is there. After that, okay, you have no session is no Akshay. Okay.
Sir, now we will start the technical session.
Continue చేద్దాం.
Yes. And we will divide the participants also, sir. In physical గా కూడా.
Okay.
Anyways, other rooms లో PPT ఉంది కాబట్టి
Ah.
PPT presentation.
ఈ వీళ్ళది ఈ కొత్త వాళ్ళు మనోళ్ళు ఉన్నారు కదా. Thank you very much, sir. Now we will continue our session. ఉండనియండి ఇట్లనే. ఓకే చైర్లు తీసి
There is 2 minutes.
పిలవండి స్టూడెంట్స్. अरे कम यार.
Student volunteers, extend your assistance here. Student volunteers.
Come fast. You continue. ఇవన్నీ తీయబా అలా పెట్టండి. దిస్ ఫోన్ ఎవరిదమ్మా ఇది? అరే కమ్ దిస్ ఏం చేస్తాండి అక్కడ? రిమూవ్ దిస్ చైర్స్. ఓగన్ చుట్టూ ఒకటి తిరుగుతూ ఉంటారు. Now we continue our session. The next speaker is Akshay. He is going to present a paper. Akshay from the Dragli. I request Akshay sir to present his paper.
Good morning, all of us. My respected professors, Honorable Chairman sir in his absence, and chief guest also, and my dear students. I'm Barrister Akshay Shara Middleton, presenting a paper related to bail reforms and decriminalization in India. Okay, first of all, one core article I mentioned about, that is in Constitution of India, fundamental rights conferred under Part 3 of the Indian Constitution. That is, no person shall be deprived of his personal life and liberty. But exception would be there. There is this procedural law established by the government, by the law, by lawfully. This is also suspended. Personal liberty suspended. But there is one thing is to be retain these rights, that is bail reforms. So in India, that is freedoms price not innocence but income, Indian corruption, a silent barrier that is to be facing in growing economy in India. Okay, that is one of the whatever evil we are facing nowadays. If you can pay money, I'm not just questioning about the courts, any of the legislature, any of the organs of India, they have working as fine as possible. But some of us, corruption is there. In India, freedom often depends not on innocence, but on income. Sometimes, not for every time, but on sometimes. A real life story, an under trial imprisoned for months for a petty offences due to inability to afford bail, and then sets the tone for exploring bail reforms as a path to equality. Nowadays, under trial prisoners, Husainara cartoon case, one of the important precedent we are applying every time. Under trial prisoners are very high nowadays. But as per records, 77% of the under trial prisoners, they were in prison. Under trial, near unaccused, but 23%, maybe few. If you are checking the another report, maybe few. So convicted persons became very few nowadays, but a lot of under trial prisoners, they were facing their traumas after they were coming out from the jail. Okay, and then nearly 77% of the Indian prison population are under trial under National Crime Records Bureau's report in 2023. Pre-trial incarceration, pre-trial detention, incarceration must be the problem. So bail reforms is needed. Especially after drafting of the BNSS also, Bharatiya Nagarika Suraksha Sanhita also, the bail reforms is needed. And my objectives of my study is to examine the evolution of the bail jurisprudence in India, to evaluate decriminalization as a policy tool for justice reform, to align bail reforms with constitutional values of liberty and equality. Also, no person shall be illegally detained, Article 22 definition, and also read with Article 21. I'm using three methodologies at a time for collection of information: doctrinal research method, empirical research, and comparative insights. Evolution of bail reforms. Clear legislation had been there, CRPC 1973. After the enactment of 2023's new code, BNSS, it's become changed some of the reforms, and then zero FIR concepts, some of the new concepts were introduced, and 3 laws were changed at that time: BSA, BNSS, BNS. Even in some of the laws, just like even the topic is nowadays, if you are looking for the topic of navigating the future of law, even Sir James Stephen, Evidence Act, father of Evidence Act, James Stephen, even McCullough, Lord McCullough for IPC, even if they can predict, nowadays there is that much of information technological advancement happening in India, even if we were need to replace or alter any of the provisions. So basically, my topic has relevance in also the title of the seminar. And the changing legal philosophy focus on removing imprisonment for minor or technical offences, some if it's called summary trial offences, 3 months or nearly up to 1 year, and summons trial offences also to be minor offences, bail reforms is needed, especially in serious offenses, heinous offenses, rape or POXO cases. There is no need for, I'm not arguing for these kinds of reforms. It is needed, must need it. Challenges, judicial backlogs and delay, discretionary misuse, arbitrary forces misuses. Limited access to legal aid, 39A of the Indian Constitution, there is limited. Recommendations, what are my recommendations for the study is mandatory bail for minor, and especially for 15 years. Especially rehabilitation is needed. Not for that much of cruel punishments or Hammurabi's codes for eye for eyes, teeth for teeth, so that kinds of things. Rehabilitation. Non-violent, some kinds of offenses if you have committed. Encourage personal bonds over surety-based bail. 485 BNS is also mentioned about some of provisions, but 485 also needs some kinds of bail bonds, whatever. Some more recommendations, some more amendments in as per the section mentioned 485. Digitalize bail management and promote legal literacy. Everything is to be electronized, digitalized. But why, if we are using the primitive method, if any person granting for the magistrate or any competent judge granting the bail, if you are getting the bail bonds, bail bond execution, bail bond orders, and then this can be give it to the jail prisoner, whatever jail superintendent, and then to execute and then to release the person. Why it should not be electronized, digitalized? Justice system on Dr. Ambedkar vision, liberty, equality, fraternity, and prioritize human and accessible pre-trial justice, even if the post-trial, and then pre-trial also having justice. 396 victim compensation schemes nowadays introduced in BNSS, but nobody can execute the 396 also. Embed compassion and constitutional morality in reform. And finally, my conclusion is bail reforms and decriminalization are pathway to a fairer justice. Fair trial is also needed. And then liberty should never depend on wealth or privilege. It's for two truths. True justice is measured by how a nation treats its powerless. That's all for my presentation. Thank you so much.
Okay, one thing I would like to highlight here, Akshay, you are very much concerned regarding the bail jurisprudence specifically, yeah.
Pardon, sir?
Bail jurisprudence.
Yes, yes.
And during your presentation, I have gone through the slide and I found that in a particular slide, you have highlighted that there should be mandatory bail provision for the minor and non-violent offenses. Are you not concerned regarding the new provisions which are incorporated under the BNS with special reference to the punishment, with special reference to community service there for the minor offenses? Why you are concerned regarding the bail for the minor non-violent offenses there?
Sir, especially for Juvenile Justice Act has been there, but I have more concern about these kinds of things because of, even if they haven't got any maturity, decriminalization, if sometimes minors become
that's something, decriminalization is something different. Your research paper, you concentrate on the bail, and somewhere you have rightly pointed out that bail is a rule and jail is an exception.
So many cases.
But now under the new criminal laws, you must have gone through it, that there are certain new provisions that has already been incorporated to expedite the process of criminal justice system, as well as to provide the relief to the persons who have committed the non-violent and minor offenses.
Reliefs is there, but nobody can file any petition for this relief. That is real case. It's happening nowadays.
Okay.
Thank you so much.
Dear participants, here is an announcement for fifth technical session. I mean to say environmental law and maritime law participants. I just read out the names who are all here. Just raise. And we will go to room number 4, fourth floor, 3, third room. Okay. Sedhu Ramachandran, Yuvashree, Reddy Purnima, Swarupa Rani, Kirtana Dasari, Dheeraj, Sherin, Kumkum Harini, Akila, Bhargavi, K.L. Bhargavi, Sheikh Azhar Ahmad, Swagatika, Mega Mariam. Yes. We will assemble in fourth floor, room number 3 for the next technical session, fifth technical session. And with regard to few other participants of fifth technical session, they'll continue here. After this first technical session, they'll continue. Thank you, sir.
Thank you, Akshay sir. Now this session continues. The other paper presenter is B. Parvata Lakshmi. I request B. Parvata Lakshmi to present her paper. Due to shortage of time, it is restricted to only 5 minutes only.
Honorable jury members and respected faculties and dear participants and students, good morning to all. My name is Parvata Lakshmi from Dragli. My seminar theme was Innovative Access to Justice Initiatives. First, India, we are having pride and constitutional safeguards in our society, but we does not having any pride to justice gap in our India. The painful gap between law in books and law in courts does not excluded. This is the justice gap in our India. So our topic concluded that India is trying to bridge the gap to gap in constitutional way to technology and social innovation. The first one, in our India, 15 million plus cases are pending in across all India levels, and then 15 to 20 years to average delay for the case delay levels, and they are physical distance and lack of infrastructural availabilities. They are economically disadvantaged. People who from rural cities, they are having to travel for 200 kilometers away to see a lawyer to get a legal advice. This is a lack of physical advance and economically disadvantaged. And then these are having some methods to reimagining access to justice in 4 mechanisms. The first one, e-courts, Telila, and then Lok Adalat, and then ODR. The first one, Telila, is the bridging the digital divide. It's enabling video conferencing facilities to rural peoples with urban lawyers. It bridging the partnership collaboration between Ministry of Electronics and NALSA and IT. NALSA means National Legal Service Authority Act. It uses at the CSEs at the Panchayat levels to enabling the video conferences, and the paralegal volunteers are enabling the video conference for the rural peoples to access the justice, and it created grateful impact, and it was a successful innovation in our India. The next one, it reaches 75,000 panchayat at all the levels and 36 states and union territories. In Citizen Mobile app was enabling 6 languages like Tamil, English, Marathi, Telugu, Punjabi. The Section 12 of the Legal Services Authority Act 1987 ensured the free services to women and children and marginalized communities. And the next one, Lok Adalat, it's also officially called as the People Courts or the People Choice. It's established under 1987 Legal Service Authority Act to compromise the situation with disputes. It enabled in matrimonial disputes, minor civil cases, and consumer complaints and labor disputes. Recently, e-Lokadat have resolved millions of cases remotely without sacrificing the fundamental character. And then Gramanayala typically called as justice at the doorstep. It's also called as the village court, and established in 2008 to provide a sub-district level of infrastructure, and it empowers to simple procedures with lower filing fees, and it hears both civil and criminal cases within territorial scope. And it also many challenges. Then we go to the e-courts machine. It has 3 phases. The phase 1 was expounded on the sub-district level. The phase 2 expanded high courts and supreme courts, and the phase 3 was the most ambitious digital transformation in our India. The phase 3 aims was AI translation, universal filing, and then e-seva kendras. E-seva kendras means universal accessible points to get the rural internet connectivity, and then smart records also. And then we go to the ODR. The ODR is frontier justice. It includes the platforms such as Sama, and then Pre-Solve 360 and CDR. And it has 3 mechanisms: online negotiation, online mediation, and online arbitration. I would like to highlight the case Trimax International versus Vedanta 2010. The Supreme Court held that the supports digital evidence in court proceedings. And ODR also having a critical gaps and challenges. They are having severe responsibilities. Only 38% of the people only having a regular internet activity, highly in urban areas, and then they does not have a data privacy. So we have to provide cyber security management, and then they have a lack of infrastructure facilities. And in India, we are having 18,000 courts. The only 3,400 courts only having a hardware, software, and cyber security management. ODR also needs a uniform and statutory clarity. And next one, we go for the future directions. The future directions is accessible to the infrastructural access works to provide broadband connectivity to the public to private internship, and then universal access frameworks to disability peoples, and then process innovation. The straightforward
Kindly try to wind up. And before concluding, I would like to ask one question to you. Is it, what methodology adopted by you in preparing this research paper?
Sir,
What research methodology is adopted by you in preparing this particular research paper? All the informations are available in website. So far the NCRB report is concerned, so far the data is concerned, Government of India in different locations in portals, all the informations are available. What is your contribution through this research paper?
so justice are distant millions of people. All the people cannot accessible to justice. So we are regulating.
How can you, unless and until you go through an empirical study, how can you know that the people are deprived of getting their getting the justice properly, so far the timely justice, speedy justice is concerned, unless and until go for an empirical study?
So in empirical evidence, the Brazil's labor courts observed that in using of these it's like ODR platforms, they are getting more resolution to resolve disputes. In 2022, Supreme Court, the digital transformation in 2022, Justice of D.H. Chandrachud, sir, 17.9 million cases are heard from virtually. They are resolved, sir. The people can easily go to
Agree.
that.
I fully agree with your statement. There are Himalayan peak of cases, the backlog of cases, beginning from lower court to higher court in the apex court of India is concerned. We are we are suffering for that. But what's your suggestion in the present day context to expedite the process and to streamline the justice system, justice delivery system now?
No, sir, I didn't tell to the physical filing also having an advantage and disadvantage.
Okay.
The online filing also having advantage and disadvantage. We are telling whatever, if it is straightforward cases means you can go to the ODR. The formal interpretation cases means you can go to the formal courts.
Okay, it's fine. Thank you.
And finally, conclusion, in India, the technology is no longer
It's okay.
optional.
Yes, it's okay. Your time is over.
Thank you very much. And the next presenter is Professor K. Haripriya. Her topic is on new criminal laws, a justice-oriented approach.
So, respected chairperson, esteemed resource persons, honorable staff, dear participants and students, a very good morning. See, I am K. Haripriya from Ambedkar Global Law Institute and my topic is New Criminal Laws, a Justice-Oriented Approach. First of all, I want to discuss the overview from offense to judgment, what happens in criminal cases. It starts with an offense. In case of cognizable offenses, we will be filing FIR, that is first information report. After, in case of non-cognizable offenses, we will be giving complaint to the magistrate. So after filing FIR, the police officers will start their investigation. There is time limit for completing the investigation and I will come to that point as well. In the investigation, they will be collecting the evidences from the witnesses as well as evidences, material evidences. And after that, police officers, if they feel that prima facie evidence is there against the accused, then they will file the charge sheet. And after filing the charge sheet, the magistrate will take the cognizance of the offense. That is, they will start inquiry. And after completing the inquiry, that is, the magistrates are well aware that prima facie case has been made out against the accused. Then they will start, they will frame the charges against the accused. Means framing the charges means giving the notice to the accused that charges are ready against you. So you have to be ready for taking the trial. And then trial starts. So in the trial, prosecution will start giving the evidence. And after that, 313 examination in CRPC, when it comes to Bharatiya Nagarik Suraksha Sanhita, it is 351. So here accused will be examined. So after that, defense counsel starts giving their evidence, and after that, judgment will be pronounced. So why I discussed is that in CRPC there are no time limits when it comes to trial exclusively committed, so trial will be committed to the court of sessions when they court of sessions. So in the court, when we have to submit, like when it has to be submitted to the trial court for starting of the trial, this time limit has not been said in the CRPC, and also for giving the judgment, how much of time a judge can take. So these time limits have not at all been discussed in CRPC, but in DNSS everywhere, if you see so many provisions in DNSS, there will be time stamps within which what can be done. So these are all there, and also a provision of EFIR. See, whenever an offense has been committed, it is very necessary that we have to give the first information to the police officer immediately. But whether it is possible, why? Because, and another thing, zero FIR was not there in CRPC. So in finding the place where to give FIR, where to file FIR is very difficult. But now zero FIR has been introduced. Means zero FIR means see, if an offense has been committed in the police station, in the jurisdiction of the police station, there only we have to give the FIR. But now, according to Bharatiya Nagarik Suraksha Sanhita, it is not necessary that wherever the offense has been committed in that jurisdiction only we have to give the FIR. We can file it anywhere possible, but that again will be sent to the concerned police station, and there it will be given a number to it. So that is called as zero FIR. In the beginning it will be numbered as 0, and in the concerned police station it will be numbered accordingly. And also EFIR. So as I have discussed earlier, filing an FIR is very important. Why? Because see, soon of the offense, the credibility of the information is very true, but as the time proceeds, the credibility will be missed. So that is why immediate filing of FIR is necessary. So now through electronic FIR, we can inform it electronically also, and within 3 days we can get it signed. So these are the changes which have been made in Bharatiya Nagarik Suraksha Sanhita. Everywhere times have been kept, and also when we see Bharatiya Nyaya Sanhita, community service punishment has been introduced. See, ours is reformative theory, which we are practicing in India. Means our main objective is to make the accused to realize his mistake and become a law-abiding citizen. So community service is more in parallels with this reformative scheme. So see, when it is more like not punishing the accused, it is more like making the accused a law-abiding citizen. So it is more in parallels with community service. And also when we take Bharatiya Saksha Adhiniyam also, before there was so many confusion between whether we can convict the accused based on the statement given by accomplice.
Haripriya. It's a really wonderful presentation. You have highlighted different, new provisions which has been incorporated under the BNS and BNSS, with special reference to what administration of criminal justice is concerned.
Yes, sir.
But as the topic you says, the new criminal laws a justice-oriented approach.
Sir, yes, sir. When these time limits are not there, justice gets delayed. So justice delayed is justice denied.
And justice hurried is justice worried.
Sir, if these time limits are not there, the judges will prolong the
Then
cases.
are you only concerned regarding time limits?
No.
Besides the time limits mentioned in the BNSS, what are the other provisions of law
Other provisions?
that has been incorporated to have the justice-oriented approach?
Yes, sir, all are there, but I am talking about this justice delayed and justice denied.
That's
So why? Because if it is delayed,
I fully agree for that. Besides the time limit, timelines.
digitalized transparency is there. We can call the witnesses by issuing summons digitally, and also all the information has been digitalized. So transparency is there. There cannot be any misuse of the files.
What about the trial relating to the case of Nirav Modi, Vijay Mallya, and the Mumbai bomb blast case mastermind who is hiding in Pakistan? What about their cases? How far the justice will be provided to the victims, those who are they have been waiting for getting the justice? What about the trial of that particular case?
Yes, sir.
What about have you gone through the trial in absentia concept?
Yes, sir. I have gone through the trial in absentia case.
That must be mentioned here.
Yes, sir. Sorry, sir.
As a rigorous researcher, you must, besides these timelines, the trial in absentia as far as the Nirav Modi case is concerned, Vijay Mallya case is concerned,
Yes, sir, trial.
regarding proclaimed offender,
Yes,
when
sir.
a person is
Absconded, we can
somewhere.
complete his trial, then whenever we find that
As
person,
a
we
result,
can-
the victims are waiting for the justice. So let the trial start, and the judgment should be pronounced, and the relief should be
Sir,
provided. to the
yes,
justice.
sir, it will be done, sir. But the thing is that, but if we have times, the work also will be done in the time. But if in the legislation itself, if no time is mentioned, then the judges will take so much time.
You are also you are having also time constraint
Yes, sir.
in
Thank.
presentation. That's another problem.
Okay, sir. Thank you for giving me this opportunity.
Thank you, Haripriya. And the next presenter is Professor A.S. Srikant Babu Garu. His topic is a study of digital transformation in India's criminal justice system by way of new criminal laws.
Yeah, good morning to one and all. Good morning to our President Madam, respected Chairman Sir, co-person, and our polarity Sir. Thanking you for giving this opportunity. My topic is digital transformation in India's criminal justice system by way of new criminal laws. Right. In fact, we have transformed this only in law, but not in true spirits, first of all. In fact, we are having pre-British laws. We are following Civil Procedure Code 1908, still we are following. Then previously, before this advent of this new criminal laws, we are following Indian Penal Code, then Criminal Procedure Code, and Indian Evidence Act. Right. Now, we have there is a paradigm shift in these laws. Now, with respect to Indian Evidence Act, we have enacted Bharatiya Saksha Adhiniyam. But practically, only 2 sections has been added in Bharatiya Saksha Adhiniyam. Remaining everything content is one and the same. Now, with coming to BNS and BNSS, there is little bit of changes. So, colonial era criminal laws unable to address modern crimes. Now we are having so much of modern crimes. For example, white collar crime. Now digital arrest has been enacted. For example, a person's money has been what is called these defrauders have taken away. Previously, the police has to personally go, they have to verify, they have to catch hold. Recovery is very much impossible now. Now what happening is now is because of this rapid growth of cyber crime and digital evidence, immediately if you call the toll-free number, they will freeze their accounts. There is a provision in this, right? So we are positioning technology as an enabler of justice delivery. Now we are examining digital provisions. Previously, electronic evidence was not there in the Bharatiya Saksha Adhiniyam. Now we have introduced electronic evidence, even serving of notices by way of WhatsApp, by way of email. It has been permitted under Bharatiya Saksha Adhiniyam. So the basic procedural requirement that has been what is called bridged by these new enactments. Now we are accessing justice-oriented outcomes of digital transformation. As our resource person has rightly pointed out, Vijay Mallya case, the Nirav Modi case, now new acts has been enacted. Now we don't need the accused to be present here physically, right? We are freezing his properties by following the appropriate laws, technology. Now recently, criminal networking system is also there. Previously, we have to go toward the thief. We have to catch hold the thief. Now, we can easily track the persons who are there. So, we are evaluating constitutional and procedural implications, and basically, my paper, it proposes a citizen-centric implementation roadmap. Everything should be what is called citizen-centric. No delay should be there. The new act has been given a time frame for everything. Now, my methodology is doctrinal legal research approach, and I am analyzing statutory analysis of BNS, BNSS and BSA, review of policy documents, reports, case studies and analytical comparative perspective. Right. Now we are overviewing new criminal laws. Right. As you already know, new acts has been come. Now, this is the substantive justice reform, recognition of cyber crimes. Immediately, you are going to call toll-free number, they are freezing your account. So much of digital crimes has been taken. Ethical hacking, unethical hacking, now terrorism and digital fraud. So we are concentrating on victim-centric and gender-sensitive provisions. So no need to be accused, no need to be present in the court. We are going for trials. Subsequently, judgments will be pronounced. We are introducing reformative punishments, as there is one provision in BNS, community service is there. It's a reformative. In spite of going for small offences, we are not imposing punishment of what is called sentences, everything. We are asking him to do some service. Even sometimes, sometimes traffic, what is called a violation of traffic rules, they should stand near the traffic post and they have to do the duty of the traffic police. So people-centric and constitutional language. Now, this is mandatory timelines for investigations and trials. Previously, it was not in earlier CRPC. Now, for everything, there is a timeline prescribed for every offences, filing of charge sheet, filing of what is called everything. Certain timelines has been framed by this new act. EFIR, straight away you can go and file EFIRs, 0 FIRs, electronic summons. We can send summons, but subsequently this electronic summons has been overruled by the Supreme Court. Supreme Court in recent judgment told you cannot serve the summons electronically. Again, the BNS legislative intent is something different. Straight away you cannot serve electronic summons. It should be by way of only BNSS following the appropriate procedure, and everything is digitally documented. Repositories will be there. Whatever you are filing, it is digitally in repository form. Audio visual recording of searches and statements. Now video conferencing is there.
Kindly conclude.
Yeah, yes. My conclusion is technology as an enabler but not a substitute. Let me quote one example in this matter. It cannot be a substitute. As our Lordship has rightly pointed out, I have faced one case practically. One person filed a eviction suit in the court of the law. He asked AI, artificial intelligence, what I should do. It told everything. He went and filed certain documents. Even the judge has given decree and judgment. In fact, the basic document, the tenancy agreement has not been told by the AI. It has not filed in the court. So advocate has not filed tenancy documents. Subsequently, the learned judge also decreed the same. That's what, this is another way of artificial intelligence. It will mislead you. What our Lordship has correctly told, if you go through artificial intelligence, you will become artificial. Right.
It's okay.
Sir.
But during your presentation,
Sir.
Somewhere you pointed out that there was no comprehensive provisions of law under the Indian Evidence Act with regard to the admissibility of electronic evidence. Are you not concerned?
No, sir.
Let me complete. Are you not concerned regarding Section 65B, capital
Yes.
B of Indian Evidence Act?
Yes. Previously,
What it says?
Previously, Evidence Act should be read in correlation with Information Technology Act. Now a specific provision has been added, 65B,
That's
sir.
fine. That's
Yes.
fine. That's
Yes.
fine.
Yes.
The digital transformation, it's a boon for this society and to streamline the existing criminal justice system. It's fine.
Sir, every coin has two sides.
But Section 65B of
Yes.
Indian Evidence Act
Yes.
and subsection 4,
Yes.
subsection 4 of Section 65B
Yes.
clearly speaks that
Yes.
a digital signature certificate should be issued by the competent authority
Yes.
to make it admissible before the court of law.
Yes.
And then it will be considered by the honorable court in deciding particular matter.
Yes. Yes.
Just little bit reformation has been made,
Yes.
because earlier it was secondary evidence.
Yes.
Now it is considered a primary
Evidence.
So for Section 62 and 63
Yes.
63
Yes.
of
Yes.
PSA is concerned.
Yes. Sir, coming to practicality, even certain courts, unless and until you file an application under this, they are not accepting digital. For everything, we have to file an application, sir. Straight away, they are not taking in the right perspective. Practically, sir. This is what happening, sir.
And also you said that there must be, the need of citizen-centric and victim-centric
Yes,
approach.
yes.
In BNS, a new chapter has been added.
Yes, sir.
That is offences against women and children.
Yes.
And
Even senior citizens, they need not come to the court. Straight away, they can be what is called audio-visual conferencing. They can hold the trial. That's what citizen-centric, sir. Small children, minors, and senior citizens, certain what is called, they have given some relaxations in this provision, sir.
Okay. Thank you.
Thank you for giving me this opportunity.
Thank you very much for Srikant Babu Garu. And the next presenter is Ganta Vasavi. Law and Society, a study of mutual adaptation.
Respected dignitaries who are all present here, academicians and other participants who are going to present these seminars, and last but not least, my dear students, very good morning to one and all. Myself, Ganta Vasavi, working as an assistant professor in Dr. Ambedkar Global Law Institute, and today I am going to present my topic on Law and Society, a study of mutual adaptation. So here I'll be dealing with introduction, methodology, objectives, how law drives society and how society drives law, and some suggestions and conclusions. And first of all, law and society both are correlated with each other. You all know that society needs to adjust with laws and law needs to adjust with society sometimes. So this is my main topic, that law maintains orders, ensures justice and promotes social change, And society, through changing norms, beliefs and movements, demands new laws and reforms. This is the main context in my paper. Next, actually I have adopted a doctrinal research methodology relying on the analysis of primary and secondary legal sources such as statutes, case laws, commentaries and scholarly articles to examine the relationship between law and society. And law is a system of rules that regulates the conduct. You all know this and all things, and law preserves, prevents decriminalization and promotes equality, helping people to live happily in the society. And examples of social changes, we have abolition of sati and decriminalization of homosexuality, Hindu Succession Act 1956, Dowry Prohibition Act 1961, child labor laws, and right to free and compulsory education. These and all the examples of social changes. Next, social problems are the cause of social change. When we have any social problem, then only we will try to make a law on it to eradicate those problems. So this is the interlinkage between law and society. Whatever the laws may be, whether it is civil, criminal, family law, whatever it may be, we need a change. Then only we will make legislations. So those are the amendments we may call changes. So main problems we have like poverty, unemployment, communalism and communal violence, child abuse, child labor, illiteracy, drug abuse and addiction, crime and criminals, urbanization, alcoholism. These are the few what are the main problems that we are facing. And objectives of my study: to understand how law and society influence each other, to see how laws are connected with each other, to study how society adjusts to laws. So these are the main objectives. And mainly I have taken constitution and society, criminal law and society, family law and society, how they both were interchanging with each other. First, the constitution, you all know, mother of all laws, how it drives all laws must conform the constitution, otherwise they become ultra virus. So constitution drives, how constitution drives society, fundamental rights, directives and amendments under article 368 are tools of social change. Constitution has been amended 106 times to meet changing societal needs. Socialistic reforms implemented: abolition of zamindari system, land reforms and sealing, welfare measures for women, elderly, disabled workers. And how society drives constitution: public opinion, social movements and crisis push constitutional reforms, and social demands become rights and duties in the constitution. Reservations for SC and ST and amendments, new interpretations, and social demands become constitutional principles. These are public needs, values, expectations, and which shape what is written. And example, equality, reservations, welfare were added because society demands for it. Next, social movements in India and constitutional impact: Dalit movement by Dr. B.R. Ambedkar sir, anti-corruption movement by Anna Hazare, environmental movement CHIPCO, which is Article 17, Lokpal and Lokayuktas Act, Article 21 respectively. And women empowerment and education, some constitutional amendments, right to education, Article 21A, women's rights strengthened, and public interest litigation, which relaxed the locus standi. So with these societal changes, we were trying to add some changes in our law. So that's the relation between law and society. And judicial interpretation, you all know, Indian Young Lawyers Association versus State of Kerala, which is Sabarimala case. So Supreme Court held exclusion of women into Sabarimala temple is unconstitutional. Still they are not allowing, this is the burdening issue we have to touch actually, still they are not allowing women into Sabarimala temple, that is another context. But Justice K.S. Puttaswamy and another versus Union of India, in this case right to privacy has been identified as a fundamental right under Article 21. Criminal law and society. So Blackstone defined the crime. You all know that relationship, criminal law and society are closely connected. So it defines prohibited conducts, regulates the public order, as you all well aware of the functions of criminal law, and how criminal law drives society, how society drives criminal law.
Hello,
Okay?
Basavi.
Yes. Yes, sir.
It's nice you have collected so much of, the plethora of laws
Yes, sir.
in preparing this particular research paper. But I want to know what's the crux of the research. What actually you want to say?
Yes, sir.
Don't you think that the multiple laws, the plethora of laws, the catenary of judgments, Supreme Court judgment, and the different cases you have cited,
Yes, sir.
is it not necessary to adapt the changing society, or there is a need of something?
Yes, sir. Still, after making several changes based on societal change, we are making laws, but still some are not enforceable in the society. Like Young Lawyers Bar Association case, Supreme Court delivered that they can allow women into Sabarmala temple, but still they are not allowing women. Actually, my research is like both are interlinked with each other. We have to follow. But still, after making changes also through law, society is not in a position to accept. When law is adopting according to societal needs, but society is not at all ready to accept some laws. But ultimately, both are interlinked. But we have to, my suggestion is that we have to follow laws. So society needs to adjust with laws. So whenever any conflict arises between law and custom, nowadays definitely we have to give priority to customs, sometimes law, sometimes custom. So that differentiation people needs to adopt in their daily lives. So that is the main context, sir.
Okay.
Okay. So
Okay, but-
this is criminal law. These are the changes.
But I suggest
Yes, sir.
you are faculty of law, no?
Yes, sir.
Okay. I suggest better you please go through the. You raised a very, very pertinent question before this August gathering, and you said that there is enforceability of the law is concerned.
Yes, sir.
Laws are there, guidelines of the different
Yes,
courts
sir.
are there, but there is a need of proper enforceability and the adequate implementation of the laws.
Yes, sir.
But you could have gone for a empirical study.
Yes,
You
sir.
could have collected data from the different stakeholders of the justice system,
sir.
and you can bring it to the limelight, and you can address. You can show the. It would be a better contribution to the society. As a
Yes, sir.
faculty of law,
Definitely, sir.
It would be a better contribution.
Yes, sir. I
If we will
definitely
go through
choose,
the,
sir.
where the lacuna, where lies,
Yes,
and
sir.
why the law, why there is a need of implementation, who is responsible, how far the enforcing agencies are responsible, where the reality, where the drawbacks and what the barriers are there, that need to be highlighted, that need to be explored. And,
Yes, sir.
and you should suggest that these are the ways and means to proper, adequate implementation of the laws and the what recommendation of the various courts.
Yes, sir. I have given some recommendations. Definitely, I'll be taking your suggestions for my empirical research. But the most, my conclusion is like when law is adjusting according to societal needs, society also needs to understand the law and the necessity of law, and people needs to recognize it. For this time, I have gone through doctrinal research. In future, definitely, I'll be trying to give my empirical research on this topic. So
It's fine. We the intellectual mass, we can understand better on this aspect.
Yes,
what about
sir.
the downtrodden people? Whatever the persons who is totally illiterate,
Yes,
who are
sir.
residing in the weaker sections of the society specifically, and the persons who are socio-economically, they are disadvantaged and marginalized sections of the society, they should be helped.
yes,
By
sir.
dint of your effort, it would be a great effort on your part to address such issues. Okay,
Definitely, sir.
fine. Thank you.
Okay, sir. Okay. So next, family law in society. These are all the some changes.
It's over. Your presentation
And next,
is over.
these are the suggestions, and I have given. We need more coordination between. Thank you, everyone, for your support.
Thank you very much, Vasavi. And the last participant is, because the time is not there, MSD Sonia. I request Sonia to present her topic, Emerging Trends in the New Criminal Laws.
एक छोटा सा ये है, ये लड़की जो है ना,
Who?
Good morning to all. I am Sonia, currently studying 4th year BLLB in Government Law College, Namakkal in Tamil Nadu. Today I will be presenting on emerging trends in new. Today I will be presenting on emerging trends in new criminal laws. First of all, introductions. Now we gonna see the new laws which replaced the old colonial laws, the BNS, BNSS and BSA. These three laws replaced the IPC, CRPC and IEA. These all three laws got presidential assent on 25/12/2023 and got enforcement of 1st July of 2024. The main goal of the laws are to protect the citizens' right, uphold the rule of law, and savings justice for all. And the three laws mark the first major overhaul of India criminal justice system in more than 163 years. Now we're gonna see why needed these new criminal laws. Because the old laws were colonial laws, the IPC 8060, CRPC 1973, IEA 8072 were drafted by British government. They just drafted these three laws not to protect Indian citizen rights, but to maintain colonial control. Their purpose was discipline and not for justice. All of we question that why we need new criminal laws. At first is contemporary aspiration. Second one is citizen-centric approach. And third, rearrangement and streamlining. And fourth one is addressing new crimes. And final one is justice over a punishment. Let's move on to what is new BNSS. Our focus now shifts to the procedural backbone of the new criminal justice system. Our first act of the Bharatiya Nagarik Suraksha Sankita 2023. This act is a transformative replacement for the colonial era code of criminal procedure 1973. It moves the system from one of the police control to one of the citizen protection, speed and transparency. The BNSS introduced a structure with a total of 531 sections. Here, 9 sections has been added and 14 sections got replaced. This act explains about the hierarchy of courts, use of electronic mode, and a new kind of punishment called as a community service has been introduced, and a proper for delivering justice and law fixed. The act has introduced various provisions regarding police custody, zero FIR, mandatory bail of first offenders, and also about medical treatment. Now we're gonna see about the new changes that occurred in BNS 2023 Act. In this act, a lot of new kind of offences has been added. Such offences are attempt to outside India for offence in India, sexual intercourse by employing deceitful, hearing, employing or engaging a child to commit a offence, organized crime, petty organized crime, terrorist act, any endangering sovereignty, unity and integrity of India, attempt to commit suicide, to compel or restrain exercise of lawful power, snatching, mob lynching, and final section is repeal and savings. However, certain offences has been removed. In this act. Those offences are sedition, adulterous, unnatural offences. And the last act, we're gonna see the BSA, Bharatiya Sakshi Adhinayam 2023. This act, BSA has 170 sections, whereas the old IEA, Indian Evidence Act, had 167 sections. The definition of document is expanded explicitly, include electronic or digital record such as emails, server loggers, cloud storage, files, voicemails, and etc. And evidence under BSA also include information given electronic. This key changes makes mode form of evidence legally valid, helping court in dealing cybercrime and digital fraud. So these are new changes in the new laws. These changes make a major shift toward more efficient and technology driven justice system. and the conclusion of the former Supreme Court Chief Justice of India, Chandrasud, he defined the new criminal laws are praised the laws for improving victim protection, investigation efficiency, and safeguarding civil liberties through measures like audio-video recordings of searches. Thank you all for your time.
MSP,
Sir,
you have gone through the Bharatiya Nagarik Suraksha Samhita, BNSS,
BSc,
BNSS.
Bharatiya Nagarik Suraksha Sankita.
Why Suraksha is used there? Why the word Suraksha is used there? Why it is added?
Adults,
What type of Suraksha is required, and why the word is added in the new code? Have you an idea?
Sir,
Have you an idea?
sir, repeat the question.
Now, what is the significance of a BNSS?
Significant BNSS.
Okay, fine.
Thank you.
Thank you.
Thank you very much. Now this technical session 4 is completed. We are lagging behind. Now the next technical session is going to start. I request
It's over.
Sahu sir, if you want to say a few words, then it is okay, sir.
Okay.
Can you please? 2-3 minutes, please.
Definitely. A very good afternoon to all of you. Esteemed dignitaries on the dais in absentia, honorable guests, faculty members, research scholars, dignitaries from other colleges, staffs, and students. At the outset, I would like to extend my thanks for inviting me to chair the technical sessions, which is very, according to me, it's a stupendous task. At the same time, I extend my thanks to the organizing team, to the college and the faculty members of this premier institution for selecting the most pertinent topic having the contemporary relevance. I also appreciate the effort in designing and organizing this particular program by dint of the constant effort of the staffs and the student team. And I have observed, I have witnessed personally, I will say, beautiful arrangement, timely response, good organization, accommodation, and the technical sessions which are being chaired by the different persons and the presenters, those who are presenting the papers. Yesterday, I was chairing a session online mode. And today I was given a session in offline mode. It's fine. It's a blended one. That is what it is. We should say that digital ka kamal. But whatever I have observed, I will address this August gathering. I will say one thing, that it's news and message for the presenters. It's suggestion for the paper presenters how to improve and how to make it a more quality paper. As far as the research is concerned, as far as the collection of data is concerned, as far as the methodology adopted, either it is the doctrinal method or empirical method or the quality research or quantitative research or the theoretical research or the practical research, doesn't matter. When the researcher is going to collect some data and while a person is going through the review of literature, one should have the fundamental idea with regard to the concept first. The topic selected by the candidate, he or she must have the comprehensive idea on that, the fundamental idea on that first. Then research, he or she should start the research. And the second most important component of research is that critical thinking. Few papers I was going through a critical analysis. Now what happened that you are criticizing? What happened to the existing laws? As earlier I was telling that there are a plethora of laws, catching up judgment. We have, this country is full of laws only. Some laws are being implemented, some laws we don't have any idea on that. Some laws that has already been repealed, and the glaring example we have at our hand that the new BNSS and BSA, newly the criminal justice system that has been revamped and reformed by introducing these 3 criminal laws. What I mean to say, when a person or a researcher is pursuing research, must mention that what type of research paper he or she is going to address the gathering. And at the same time, whatever information, the data is available in website, need to be acknowledged. Or when a person is reading the article written by someone else, who is the original author, it must be acknowledged the credit should go to the original creator of the content. And the most pertinent thing is that what is your finding? What is the result of your research? And contribution to the society. A quality paper always will be appreciated, will be published when it has some distinct characteristics, when it has some novelty, when it has some new things, which is newly created and added a new flavor in the original writing, in the article itself. So it's my request to all the researchers, the budding researchers, the rigorous researchers here, in future if you are going to start the research and while you are preparing a paper for presenting in a particular conference or seminar, you must go through the concept first, the conceptual analysis. It must be very clear. And whenever you are having some doubt that this data is little bit, you are confused, don't bring that particular data. Don't make it, add in your research paper there. And last but not least, I really appreciate the effort taken by the students of this college and the paper presenter from various parts of the country in presenting their paper in offline and online mode. Definitely they are the guiding force towards the next generation and in creating the original content, and especially when the question of the research is concerned. I would like to conclude my speech here. As earlier the speakers, the predecessors, they have highlighted, so far the ChatGPT is concerned, artificial intelligence is concerned, as the Gemini app is concerned, which is the easiest method to collect the data and to go through the, but try to be natural, not artificial. Natural and will lead you towards a better direction, better destination. Don't depend upon this particular device. You may take little bit help of the device that is the, may it be mobile, the smartphone, the chat GPT, artificial intelligence. Those devices and those mechanisms that has been developed by this human, the brain of this human being only. We are the creator. Before concluding my statement here, I would like to say one thing. Think original, write original, and contribute original to the society. Thank you. Thank you so much.
Thank you very much, sir, for your suggestion to all the research scholars, teachers, and the students. Now, this fourth session we are closing. There is a 10 minutes break. I request the resource persons as well as the teaching faculty, please have tea for 10 minutes. After 10 minutes, we will start again. 12:30, sir? No, they are asking, sir, please. Just 10 minutes. 10 minutes, please. Arey, why are you sitting? Come, take them to out. Madam, please, please, please. Tea arranged outside. Please have. Then I request participants, the paper presenters are requested to be present. In the next session, I will read the names. Professor Vivek Vital Rao Javale. Then Srujana, Vignesh, Kalaimagal, Trilochan, Tarun, Mahima. If they are available, please be available here. Other students, you may go and have tea and come back within 10 minutes. Students, go one after the other, one after the other. Ladies first. Ladies first. Girl students first. Go and have tea and then come back immediately. Line by line, go in a line. Okay, one after the other, go in line. I request the students to go online. Volunteers, please cooperate. Volunteers. Students, please go online. Now the presenters are Professor Vivek Vital Rao. Is he available? The next is Srujana. Srujana is available. Then Vignesh. No. Dinesh Kumar. Kalai Magal. Srivardhini. Your name? Which name? Last session. After this we start. Not now. This is fifth session. Your name? Yes. Yes. All the students have to come back within 10 minutes only. 6 after this it starts. What is your name? Yes, it is there. Okay, we will see. Name? Bharti? Is here? Sorry? Ethical use of AI. But whether it is possible or not, we will see. Time factor is there, no? Okay, we will see. Okay. No, okay, we will see. Try to accommodate. Ah. We will see. We will see.
So is it your paper? What you understand? What? My name is not in the list. Which list? My name. Already it's there now. You just saw it on this one, huh? In last session, Pura last session is this. You said your name is there, this one. I'll take, sir, don't worry. Ganta Vasavi. Previous session, this is previous one. Fine. You go and ask Ashwini ma'am. No. You ask Ashwini ma'am, not this. Convener. Ashwini ma'am is the convener. No. Second, done. I'll ask him to guide. Ashwini ma'am ni చూపించరా ఈ అమ్మాయి పేరు ఉంది ఇక్కడ లిస్ట్ లో ఇచ్చిన దాంట్లో ఇక్కడ ఎక్కడ పెట్టడం లేదు ఐ వాంట్ టు ప్రెజెంట్ Some my eyes Ashwini madam they back to everything okay is fine. Don't worry. Shall I start, ma'am? Shall I start the session? Please write the name at least you please write the name. Where? Saw written, you 6, 7, like that one. This should come now. Your PPT should come. Your PPT should come. Next, na? With me. PPT is with me, ma'am. Okay, after last I'll try, huh? No, you please write the name, at least you could remind that yes. This session is different. Okay. Another session is there. No, that list is with you, ma'am. Yes, ma. Yes, I'll write afterwards. Okay. Definitely. Sure. Thank you. Good afternoon. Starting the technical session. I take this opportunity for inviting the chairperson of today's occasion, dealing with environment law and sustainability, technology and future maritime, Dr. S.V. Pullareddy sir, who is known to every one of us, such an eloquent speaker, a beautiful orator, and presenter of many papers, who has shared already a lot of knowledge with the college. And sir hails from SK University, Anantapur. He's a retired professor, having 36 years of experience in teaching. Sir has a member of state committees, and he has teaching experience, research, and also administrative experience, and has publications and notable papers and seminars. And I invite you, sir, to accept our humble request to be the chairperson of today's occasion. I also humbly request Sita Kumari Madam. She is head of the Department of Mahila University Law Department. She is the embodiment of kindness, generosity, and also the helping nature. And always, I used to call ma'am with a smiling face. She wipes off all the troubles and fears what is there in others. I request ma'am, and ma'am is the member of BOS, and also she is the member who is the nodal department, nodal officer of SV University, coordinating with the legal matters. Ma'am has 70 publications and also has many journal publications. And she received recently as the Best Teacher Award in the year 2024, 11/11/2024 at Vijayawada. Ma'am has many achievements, as ma'am doesn't like too much of boasting of herself. So I humbly request you, ma'am, to be the co-chairperson of today's occasion. I invite the first participant, Dr. Trilochan Lenka.
Hello. Hello. Before you make the presentation, one small reminder.
Sir.
Please make note of the time limit. You will
Okay,
be
sir.
given 5 minutes.
Okay, sir.
At the end of 4 minutes, we will give a bell.
Okay,
You
sir.
have to conclude in 1 minute. Okay?
Okay, sir.
This is not only for you, for all the presenters. Because we have another technical session before we go for lunch. I think it's not functioning.
Respected dignitaries, law participants, and dear students. I am Dr. Trilochan Lenka from Ganjam Law College, Odisha, and my topic is circular economy and sustainability, legal reforms needed in India. उपभोग्यम वस्तु यत् किंचितम न त्यजम तत् कदाचन पुनः प्रयोगो एवस्ति भारतस्य परंपरा. Everything that is still useful should never be thrown away. Reusing things is the tradition of India. Purchase a sari, use it. If it is torn, then repair it. After that, if it becomes old, then redesign it. If it becomes unusable, then recycle it and repeat it. And my topic is based upon this philosophy. Circular economy. Circular economy is a new production and consumption model that ensures sustainability. It includes sharing, leasing, reusing, refurbishing, and recycling. And in this way, it extends the life of the product. And it is contrary to the traditional linear method. The traditional linear method says that use and throw the product. But circular economy says that after purchase, use the product and recycle it, reuse it, refurbish it, recycle it, and continue this process, so that there shall be the reduction of natural resources. And come to the next, circularity, sustainability. So sustainability in circular economy means meeting the present need without compromising the future, without compromising the future ability of the coming generations to use for their own use. And this means sustainability implies that use the things according to your need, but not according to your greed. And imagine a village has a mango tree, and you can pluck the ripe mangoes in this season, and in this way, the mango tree can be protected, and in every year it will provide you mangoes. If you cut the mango trees by greed and quick profit, then your future generation, your children will not get any fruit. And if they, it is this protection of the tree is sustainability while using the fruits. So this nature is given us not, we have inherited this nature not from our forefathers, but we have borrowed this nature from our children. So we are not the owners of the nature, but we are the caretakers of the nature. And I have applied doctrinal method in my research, and I have explored the concept of circular economy, sustainability, and I have analyzed the legal gaps and proposed the required suggestions. And need for circular economy. You know that India is a vast country and it has 140 billion crore people, and the resources are limited and the waste generation is high. So the circular economy helps to save the natural resources, it controls going waste, it protects environment and health, it supports sustainable development, it creates jobs and new industries, it fulfills constitutional duties under Article 48A, 51AG and under Article 21. Legal framework. So the legal framework is built through constitutional provisions, through environmental laws and waste specific rules. And Environmental Protection Act of 1986 says that there is provisions in this act for the management of the waste and control of pollution. And the National Green Tribunal Act 2010 that has ensured enforcement of environmental laws and sustainable development principles. Then E-Waste Management Rule 2022. So E-Waste Management Rule 2022 targets and management of our products. The E-Waste rules makes producer responsible for the collection and channeling of E-Waste for recycling. Then the Plastic Waste Management Rule 2016 have banned certain single-use plastics and strengthened EPR for plastic packaging. The 2022 amendment mandates a minimum level of recycling of plastic packaging and the use of recycling content. The Battery Waste Management Rule 2022 that mandates the producers, the manufacturers and the importers of the battery for the collection of old batteries and used batteries and for recycling them. Then gaps. What are the gaps in circular economy? The India does not have any umbrella legislation. The provisions relating to circular economy is scattered in various environmental laws, but there is no umbrella rule. As a result, there is conflict among different definitions, like the definitions of waste, recycle. So there is no concrete and absolute definition of some environmental terms, and there is also not a single authority. As a result, there is a confusion among the jurisdiction of different authorities. And another gap is that weaker enforcement of EPR. Although EPR is legally mandated, but producers often they reproduce, they show underproduction as a to avoid the EPR guidelines. Then lack of infrastructure for recycling and recovery. The government lacks proper infrastructure for the recycling, and the local bodies, they also lack the technicians and adequate fund for recycling. And I will take 1 minute. So my suggestion is enact a comprehensive circular economy law and strengthen and standardize EPR and introduce a right to repair legislation. There must be a right to repair legislation, and it must contain the right to repair legislation must involve availability of spare parts, repair manuals for consumers, and ban on planned obsolescence. And make eco-design and sustainable packaging standards, and formalize and integrate the informal waste sector, strengthen and penalize and enforcement mechanisms. So thank you very much for giving me an opportunity to present my paper.
Next speaker, Ms. J. Srujana and Ms. K. Manasa.
Reminding the presenters once again, please mindful of your time.
Yes, sir.
Take only 5 minutes.
Yes, sir.
Today's discussion is on the navigating the future of law, innovation, ethics and excellence. We all know that legal landscape is undergoing a profound transformation. In this era of rapid change, we are here to adapt, innovate and uphold the maximum standards of ethics and excellence.
Respected dignitaries presented here and professors from various institutions, participants and students, myself J. Srujana of Sri Padmavati Mahila Vishwavidyalayam.
Myself K. Manasa, pursuing BA LLB 4th year in SPMBB.
We are here to share our thoughts on environmental law and sustainability with this esteemed gathering. So firstly, environmental law that consists of rules and statutes that aims to protect the environment and to ensure that a responsible use of natural resources to be available for both present and future generations. And sustainability is interconnected to the environment. It is about integrating environmental care, social justice and economic responsibility. And The history for environmental law can be traced back to the ancient civilizations, and as we have also heard and witnessed about Chipko movement, Narmada Bachao Andolan, etc., and also later rapid industrialization and increase of ecocide crimes in the society have also made reason for enacting the environmental laws.
Environmental sustainability is about using natural resources responsibility to meet present needs without compromising the future needs. It mainly focuses on to take mindful choices that protect our planet for long term.
So, the main objective is to highlight the principles of environmental law and its relevant cases. So, the first one, polluter case principle, it addresses the person who pollutes the environment has the obligation of not only to compensate for the loss occurred, but also has the responsibility to repair the environment what was damaged by him. And the next one, precautionary principle, as the name suggests, and it is a very well known fact that prevention is better than cure. In similar, taking preventive measures before any ecological destruction can safeguard the environment. Later, public trust doctrine, since the natural resources are held under trust by the public, it needs much more public participation for making to safeguard the environment. Later, sustainable development, it balances both economic growth and environmental protection.
Major environmental laws in India. India has many legislations to protect environment and promote sustainability, such as Wildlife Protection Act, which was introduced to protect endangered species. Water Prevention and Control of Pollution Act, which created a pollution control board with the authority to protect water bodies. Forest Conservation Act, which restricts the state from diversion of forests for non-forest usages such as mining, construction of dams without central government's approval. Environmental Protection Act. It can be considered as the umbrella law for environmental protection, which came after the Bhopal gas tragedy. It aims for India's environmental control from hazardous activities of human behavior. National Green Tribunal Act 2010. This act created a special forum to deal exclusive cases of environmental laws.
Some of the key international agreements which played a key role in enacting environmental laws, which shaped the key role. So, Basel Convention, which reduced the movement of hazardous substances from beyond the borders, which means to stop the transformation of the waste management, and which means to protect the efforts of hazardous waste. And later, Rio Declaration, which was the foundation for sustainable development. It is the first to start the sustainable development as a key program that emphasizes balance between environmental protection and economic growth. And it is a foundation for Kyoto Protocol. Kyoto Protocol, this is the first international treaty which reduces the greenhouse gases emissions and distincted between the developed countries have mainly made gas emissions, and the developing countries have focused on the poverty and growth. Later, Stockholm Convention, it is a global treaty, and it stopped the uses of toxic chemicals released from persistent organic pollutants like DDT, dichlorodiphenyl trichloroethane, to the atmosphere, because this lasts in the environment for a long time.
Sustainable Development Goals play a crucial role in environmental protection. This was introduced by the UN in 2015, which can be called as Universal Call to Action to build a fairer, greener, and safer, sustainable world by 2030. The Sustainable Development Goals mainly focuses on poverty, food security, and providing quality education into one global framework. So, sustainability is not only just about protecting nature, but also about integrating environmental care, economic responsibility, and social justice into every decision.
So these are the landmark cases. Due to lack of time, we are mentioning only two cases specifically. That is MC Mehta case and Belur Citizens Welfare Forum case. MC Mehta case, which made provisions. MC Mehta case. It was the case which resulted for. And emphasized the polluting causing principles to be stopped and made economic development with environmental protection, which means here the court directed not only to compensate the victims but also to take the strict measures if they want to reopen the company. And Belur Citizens Welfare Forum case, here the Supreme Court of India directed that industries and tanneries which are releasing the pollutants into Palar River must be stopped and they must take certain pollution control devices. The case firmly established balance between development and sustainability and introduced polluter pays principle and precautionary principle into the environmental jurisprudence.
Challenges.
For protecting the environment and maintaining sustainability, we are facing certain challenges that includes due to rapid industrialization and urbanization, and air pollution also including in metropolitan regions due to vehicle emissions and industrial activities. Climate change adds another layer of complexity. India is highly vulnerable to extreme weather events, including heat waves, floods, etc., which resulted in ecological destruction. To prevent from these challenges, there are few future directions making institutions stronger, using technologies better, and also involving the public participation in awareness programs. And we have few suggestions. Some of the suggestions include to strengthen environmental laws by ensuring strict penalties, to educate environmental literacy in school and ensuring participation of people in awareness campaigns, not only reducing or banning plastics, we should use reusable bags and biodegradable products, and also we should support innovations and rules that promotes renewable rules, and also encourage the business and individuals to adopt eco-friendly technologies. So, in conclusion, environmental and sustainability together are the backbone of our collective responsibility of the planet. Environmental protection cannot remain confined only to statutory provisions. It must become a guiding principle for nations' development. Ultimately, protecting the earth is not just a legal duty but a moral one, reminding us that the health of our environment is inseparable from the health of humanity. Thanking you all for giving us this opportunity, and we are very grateful for your attention and interest for our seminar. Myself, Jay Srijana.
Myself, K. Mansa.
We are from Department of Law, Sri Padmavati Mahila Vishwavidyalayam, Tirupati.
Very sorry to interrupt the technical session, ma'am. I have an announcement for the participants belonging to the last technical session, session 6. And I read out few names. We are planning to have a parallel session because of this time constraint. And I just read out the names and we all can go to 4th floor, room number 5. Okay. So, who are all present here, let me know. Samson Ravi Kumar, yes. Kaushalya K, Kameshwari, yes. Baba Soyab, Fatil Muhammad, Iftakarul Masud, Veda Samhita PVS, Hemalata Muhammad Ismail, A. Raju, Nikita Reddy, Vasanta Kavita, Samyukta Reddy, And Madhavi, Ramachandra, Dr. A. Ramachandra and Latif. Yes. We all go to room number 5 in 4th floor, and the next last technical session we will start there. And the remaining participants of the last technical session kindly remain here. We will continue. Thank you so much. And technical session 5 continues now.
Next speaker, Mr. Vignesh and Mr. T. Dinesh Kumar. Next speaker, Kalaimagal Velu and Mrs. S. Srivaradnidhi.
Good afternoon to respected dignitaries, fellow participants, and my dear student. I am very happy to present our title called Building a Sustainable Future Through Evolving Paradigms and Environment Law. Okay, before starting the session, I want to ask a question to students. What is the main purpose of environment law? Anyone? Yes, correct. Protecting the environment. So previously when we asked the question, everybody will be saying that the main purpose of environment law is to protection of environment, prevention of pollution. But the times have evolved. The times have evolved. Now the environment law have changed a multi-dimensional approach. Not only from protecting the environment, there are many the multi-dimensional approach combining technologies, climate change. For example, now the recent rules, green credit rule, it is an example of that. Now we will see the historical development of environment law. First, in 1972, a Stockholm conference, which was the first one to say that a right to environment is a fundamental right. Next, in 1992, the Rio Earth Summit introduced the concept of sustainable development and precautionary approach. Next, the Paris Agreement, which highlights the need to reduce the global warming. Next, the Sustainable Development Goal. We all know that there are 17 goals in that, which says that the development of a country should not be the cause for depletion of the environment. So there must be a balance. Next, what is the foundational concept of environment law? First, we all know right to healthy environment. Under which article it is incorporated? Article 21A. Right to environment is also included. Next, precautionary principle. We all know that prevention is better than cure. So, we must prevent the environment degradation before it gets worse. Next thing, the Paris Agreement. It is the most ambitious climate change agreement we can say. What is the core concept of the agreement is, every country must give the nationally determined contribution. That is, they have to mention what are the contributions they have made towards the environment. And another concept called common but differentiated responsibility. That is, commonly every country is having a responsibility to protect the environment, but the responsibility changes because some countries have worst environment conditions, some are best. So they have to act accordingly, and then they have to achieve a net zero emission. Next, India's environment governments. We all know that Article 21 and Article 48A and 51A also gives a duty to every citizen and the society to protect the environment. We all know the judicial innovation. Judiciary plays a very important role in environment.
Okay, so there are series of MC Mehta's case and to quote a case like a Velu citizen case, which incorporated the concept of polluter pay principle, which means the polluter is liable to pay the precautionary action. Next, see, despite these developments, what are the global challenges? First is rising temperature. So even though the climatic change is still increasing, so there is a need to regulate it through environment law. Next is biodiversity laws and economic injustice. That is, mostly vulnerable group people and indigenous people are affected through environment changes. Next is weak enforcement of international climatic obligations. So we are not enforcing the international climatic obligations as enough. Now my author will continue the rest of the paper. Thank you.
Thank you, my co-author. And I am Kalaimagal. I am author of the paper, and I am going to continue the next slides. Environmental justice and equity. What is the meaning of the justice and equity means? All the peoples will be treated in equal manner. And in environmental cases, mostly the affecting people will be the vulnerable communities. Say for example, indigenous people and the people who is having the less income of the country, they will be having the burden of the environmental issues. Why? Because they are always having the concern about the future generation. And next slides will be the corporate environment accountability. Brevity of time, I will explain what is the gist of the accountability. We are the human, we should have some concern about the future generation, and the sustainable development goals will be like, I have to, totally it has 17 goals, but I have to note the 3 goals which is related to the environment protection. That is goal number 13, climate action, and goal number 14, life below water, and goal number 15, life on land. And why should I mention the goal number 12 will be below the 13, 14 and 15, which means each and everything, the climate will be supported for the some time, the climate will be affected for some times, but we the citizen, we should have the concern about the future generation. We have the duty to protect the environment. That's why the 12 will be the responsible consumption and the production. And strengthening the environment governments, we have some binding laws for the comparison, always having the comparison between so many countries. Why? Because in before 42nd Amendment, we don't have the environmental law at all. And Madam Prime Minister Indira Gandhi was the Prime Minister of that time. She had the concern about the environmental law. She is the first person to take the environmental issues in the international platform and drafting the 5 policy which is protecting specifically the environment. That's why we have amended the Constitution Act 42nd Amendment. We have inserted Article 51A and 48A Class G that every citizen, we have to protect the environment, and we should have the duty to protect the environment as well as the healthy environment and healthy surroundings, which is added to the Article 21. In this context, we have so many treaties and conventions which is related to the international concept, and how the India should adapt this kind of treaties and conventions with the help of the Article 256, and we are amended the state would amend the new laws and the enactments which is applicable to the particularly the state which is needed to protecting the country as well as the citizens. With your permission, I can conclude my topic. Okay. My conclusion is we should have protect the environment. We should have some laws will be protecting the environment. No, absolutely it is protecting the environment is not depending the ministries or not depending the government and not depending the person who is the councillor of the area. No, it is obviously no. We the citizen, we have to protect the environment, and each and every individual should take the part to protect the environment. Why? Because say for example, in every year floods and cyclones will come and go.
Okay, we the citizen, we should make a promise to buy a water body's lands. Even the real estate people will give the cheaper price for the water body's land. We the citizen, we have to make a promise to, we should not encroach the water body's land. Then only the environment will be protected, the mother earth will be protected. Each and everything. ஈன்ற பெயரில் பெரிதுவக்கும் தன் மகனை சான்றோர் என கேட்ட தாய். தாய் தன்னோட மகனை பெக்கும் போது இருக்கிற சந்தோஷத்தை விட சான்றோர் முன்னாடி அவனை பாராட்டும் போது இருக்கிற மகிழ்ச்சி தான் மிகுதியானது என்பார்கள். So be educated and try to be learner and try to educate and try to protect the mother earth with the fulfillment of the national seminar navigating the future of law. We should always about the concern about the future generation and fulfilling the 17 goals of sustainable development, and we should have the innovation and creating awareness to the people and making the good environment, be the ethics and be an ethical people to practicing the advocate and always be the excellence of your society and as well as your profession. Thank you so much for the opportunity.
Next speaker, R.V. Taruna and Ms. B. Sandhya.
Madam? I think they doesn't belong to us. Only 7, I think we have more than that. 9. Again is they added, huh? They the 7A, but ఈ పక్క వాళ్ళు ఎవరు రాలేదు. మనకి ఇవే ఇంకో లాస్ట్ ఇంకొక అమ్మాయి ఇవి మనవి కాదు. చూడండి 4, 5, 6, 7.
Good morning, everyone. I'm Sandhya. Okay. Good morning, everyone. I'm Sandhya, and this is my author, R.V. Taruna from Bharat Institute of Law, Chennai. Today, we are going to presenting on environmental law and sustainability. The role of climate change litigation in shaping national policies. Our presentation focuses on environmental law, sustainability, and the law courts are influencing climate governance. Climate change is now a global crisis affecting ecosystem health and economic. Environmental law helps a key role in protecting natural resources and ensuring sustainability development. In recent years, climate change litigation has emerged as a major tool demand and accountability from governments and corporations. Courts increasingly rely on scientific evidence and evaluate climate litigation and responsibility and has shaped national policies across the many countries. Next, we move on to the objectives. The objectives of this study are to understand the two climate changes litigation influence the environmental governance, to examine how the courts enforce accountability for climate harm, to access the role of fundamental rights in a climate litigation, to analyze the global Indian legal framework to relate the climate justice, And finally, to show the how litigation relates the strong climate policy, sustainability, and development. Next, move on to methodology. In this research, based on entirely doctrinal methodology, it realized the secondary data resources such as environmental law like the EPA Environmental Protection Act, Air Act, Water Act, and Forest Act, NTGT, National Green Tribunal, national and international judicial and decisions. Report from the UNEP, IPCC, and World Bank, academic journals, books, and online database. Next, my author will continue.
And I move on to the important topic. Excuse me. Climate change litigation. Climate change litigation refers to legal action taken to hold governments and corporations accountable for climate harm, and it is used to challenge weak climate policies to leak of actions. Litigation helps to enforce environmental rights under the constitutional frameworks, and it demands stringent emissions reduction, renewable energy adoption, and such as mining, deforestation, and pollutions. And there are 4 major categories of climate litigation. Litigation based on violation of fundamental rights, and litigation against corporation and environmental harm. Litigation seeking enforcement of international climate obligations, and litigation demanding compensation for climate-related losses. And I move on to the most important part, global and legal framework. Globally, litigation had a strong impact on environmental policy in Argenta versus Netherlands, 2015. In this case, the court ordered the government to reduce the greenhouse emissions by 25%. In India, climate justice is rooted in a constitution. Article 21 says, right to clean environment, and Article 48 states, duty of the state to protect the environment. And Article 51A clause G states that duty of the citizen to safeguard nature. And I move on to the next topic is how climate litigation performs in India. India does not yet have a dedicated climate law. So the government indirectly introduced the climate policies through landmark ruling. In MC Mehta series, court introduced CNG, compressed natural gas, emission control, and stronger air quality measures. In Godavari cases, that the judiciary protected forest and improved monitoring. And I move on to the more important topic is role of NGT and challenges. The National Green Tribunal plays a vital role in India's climate governance. It ensures compliances with environmental law, halt harmful project, and order compensation under the polluter pay principles. And however, it faces several challenges. And the first point is no climate specific statutes and difficulty in proving climate harm significantly, weak enforcement and administrative delays, climate resources for vulnerable communities. These issues restrict the full impact of climate litigation. And my co-author will conclude the session.
To conclude, climate change litigation has become a powerful tool compelling governments and industry to take a meaningful action. For India, stronger climate laws, better enforcement, and active public participation are urgently needed. Ultimately, effective climate action requires the cooperation between courts and governments and the society to ensure the sustainability and resilient future.
Thank you for giving us this opportunity. Thank you, sir.
Next speaker, D. Mahima.
Thank you.
This technical session is completed, and I request chairperson and co-chairperson to give their suggestions.
My respects to Sharda Magaru, who is the key behind the establishment of this institution. Pulla Reddy sir, who is my mentor, and Someshwar sir, and the faculty of this institution, and my dear students. I started my academic journey from this institution, long way. Long way from 1993. So before completion of my LLM, I didn't get my degree also. Tippareddy sir called me and asked me to take classes. So I said, I didn't get the results, sir. He said, it's okay, you start. And he first gave me a book on environmental laws, that is Rosencrantz. And because all the teachers, they were not ready to take up this new subject, as a newcomer, I was given this subject. And I took it with all interest, and I started preparing for that. And it has led me to do PhD on environmental laws. So I'm very grateful to this institution, to sir and madam, who has craved my career, and I'm standing before you as the convener of the Law Set 2025. So environmental laws, coming to the subject, environmental laws is the core subject which is very essential to the human beings, because all the rights can be enjoyed only when you are alive. And for living, you need a good, healthy environment. And this topic, which has been selected by this institution, like navigating the future of law, innovation, ethics, and excellence, it is very apt in case of environmental laws, because the future of law, especially relating to environment, is becoming blindfold. And the youngsters like you have to come up with the papers. We have the policies, of course, but you have to come up with the papers, giving some sort of mechanism which is very concrete, which is very applicable, and not putting your papers just restricting to the policies alone. You have to innovate. And what is the technology to be adopted? And I am suggesting you that your paper should be always multidisciplinary, because you have the legal policies, no doubt about that. India is making the policies, enacting the policies according to the changes in the society. It is very shrewd in making that. But how far it is monitored, it is implemented, and for that, mere legal suggestions is not sufficient, but it has to have technology as its basis. And that's where we have to connect environmental laws with artificial intelligence. And when you talk about this, the so-called suggestions which has to be put forth by you should go by using AI in administering environmental laws. And this, of course, at the beginning needs a multidisciplinary approach, or I can say translational research. And you have to combine yourself with students of technology, so that the correct solution can be brought out. And the papers which has been presented today, it goes with the historical background, and someone has talked about the management policies. And the first presenter, he has said about the management policies, but how far it is being implemented. And we all say that laws are not being implemented. As a student, you have to find out why these laws are unable to be implemented and take the solution from AI, innovate your ideas, incubate your ideas, and then come out with a concrete solution. And this may be, as I said, it can be an empirical study or a doctrinal, but your suggestions should be innovative. And of course, without ethics, nothing can come out. So with the ethical background and with innovation, only then the laws which are made by the government of India can be successfully implemented. Thank you very much for giving me this opportunity.
On behalf of Ambedkar Global Law Institute, Chairman Sir, President Madam, Secretary Madams, staff and students, I humbly take this opportunity to thank Chairperson and Co-Chairperson of today's technical session for rendering the valuable advice as well as being in the midst of us patiently and hearing all the technical representations, whatever has been made. Thank you very much, ma'am. And for all the people, please be seated. There is a small felicitation function. Afterwards, all the hostelates, please go to your hostel. Rest of the lunch will be ready in the open ground. Please wait for a few minutes as there is a small felicitation function.
చేసే వాళ్ళ కోసం వెయిట్ ఇంకొక టెక్నికల్ చూసుకుంటా eager to relinquish the job.
My student in Pondicherry, sir.
Oh,
He is now in DU.
he told everything about every time he's telling about it.
అవును సార్.
ఇట్లాంటి స్టూడెంట్స్ 15 మంది 15 మంది ఒక బ్యాచ్
ఇంకొకటి మంచి రిసోర్స్ త్రూఅవుట్ కంట్రీ ప్రోగ్రామ్ పోయిందంటే
అవును వాట్సాప్
త్రూఅవుట్ కంట్రీ
He's very sound in using this. బ్యాక్గ్రౌండ్ చూసిన వాళ్ళకి అర్జీ ఉంటుంది.
డొమెస్టిక్ హోటల్లో వర్క్ చేశారు. పాండిచేరి నేను ఇక్కడ ఫస్ట్ బస్ ఎక్కాను. ఇంకా 3 గంటలు
మీకు దండాలు మేడం. వాళ్ళ మంచి ఇది అంటే ఐడెంటిఫైయింగ్ ఎ గుడ్ స్టూడెంట్ హెల్పింగ్ దెమ్ ఇస్ ఆల్సో
చైర్మన్ సార్ ఎక్కడ ఉన్నారు? ఎక్కడ ఉన్నారు చైర్మన్ సార్? ఏ మేడం?
I humbly request our Chairman Sir please come to the dais, and also President Madam, please come to the dais. And I request Sita Kumari Madam, Honorable Justice Kripakar Sir Garu, and also Ramakrishna Sir Garu to be their gracious presence in the dais, sir. And also I request Polarity Sir also to have his gracious presence on that stage. First
Madam, రండి పర్వాలేదురా. టైం ఎంత?
Yes. The last technical session 6, and let me know whether the participants are present here. I'll just call the names. Raise your hands. Kaveri Shukla, Kotela Rajeshwari, Prabhati Swar, Vishnu Vandana ma'am, Baba Shoaib, Padil Muhammad Iftikhar ul Masood, yes, I'll give you.
Thank you.
Good afternoon, all of you. Now the last session, 6th session is going to start. Now in this session, the technical session 6th pertains to professional ethics and accountability, the future of legal education and legal profession, ethical use of artificial intelligence in legal education, the risks of artificial intelligence, hallucinations, and the lawyer's duty to verify information. So these are the sub-themes are there, sir. Now for this session, Honorable Justice Dr. V.R.K. Krupasagar Garu and also co-chairperson Professor Dr. Meena Ketan Sahu Garu. Yes, so there is a change here. Professor Ramakrishna Garu acting as a chairperson, okay, co-chairperson, and now this session consisting of this 10 participants are there, sir. Now I call the first Kaveri Shukla is there. Yes, Kaveri Shukla, her topic is legal and ethical challenges to legal education in the age of artificial intelligence. I request Kaveri Shukla to present her paper.
స్టూడెంట్ అనకూడదు అందుకని ఏఐ లీగల్ ఎడ్యుకేషన్లో ఎథిక్స్ మ్యామ్ ఏఐ దానికి ఎందుకు ఏఐ అనకూడదు అని అదే ఎథికల్ ప్రాక్టీస్.
So because some technical problem is there, please Prashant Reddy, Innovation Shaping Legal Education. I request Prashant Reddy to present her paper.
ఎక్కడుంది సార్ ఆ పేరు?
Yes.
ఉంది టైం సరిపోతుంది, 2 గ్రూపులు చేశారన్నారు. లేదు అది లేదు.
Good afternoon, everyone. A warm welcome to the chairperson and co-chairperson, faculty, management of Global, Dr. B.R. Ambedkar Global Law Institute, and the students. I'm Sai Prashant Reddy, representing Mahatma Gandhi Law College from Hyderabad. And the topic that I chose today is innovation shaping legal education and legal careers. So I would want to primarily touch upon how innovation is touching the legal field. And as we see, we have innovation and technology shaping our everyday lives. We have come a long way from asking people for any questions to asking Google and Alexa of what do we need in a day-to-day life. And the same way, these things also touch our legal field. And 2 aspects that I want to explore here are how it is touching the legal education and also legal profession as. So when it comes to legal education, the 2 areas primarily it is touching is online learning platforms and virtual classrooms. And it is very important that we have these tools. It is a fact that nothing can replace manual teaching or in-person teaching. But as we know, a teacher cannot cater to every student in a very specific way. This is where technology plays its role, comes in and tries to help the students to achieve their individual goals by providing a plethora of resources and also individual tools. And this is where AI and other tools also come into place, where they help in structured tutoring for specific students. And these also open a door to a large gallery of resources. Gone are those days where we would wait for a book in a library. Now a book is available to thousands of students at a time. Law journals from across the continents are available at a click of a button. And these are the changes and innovations that we need in legal education, and we also would like to see more and more universities and colleges adopt these changes. And when we look at the changes shaping legal practice, I myself have worked for 3 years in Dow Jones in USA, primarily on finance and legal teams. So we do a lot of commercial contracts, and finding data in those contracts is very difficult. And this was not very long ago. I'm talking about things that happened 6 or 7 years back. And today we have so many tools where we're using AI for research. For example, of late, if you see globally, there are a lot of data privacy regulations that have come into play. For example, GDPR in the Europe, CCPA in California, or the Singapore data regulation, or very recently we have DPDP in India as well. And most of the older contracts do not have this data. And if you want to make amendments to those contracts, we can use things like AI to search for those particular contracts that do not have these facilities, and then try to do amendments or make them in play and ensure that companies are compliant with the latest regulations. And blockchain, we hear this word mostly with cryptocurrencies, but blockchain can be used for a plethora of things. And smart contracts is one place where we can use blockchain effectively and also ensure that it reduces a lot of time on legal professionals, because once you have MSAs in place, the SOWs or the minor contracts can be self-executing with blockchain. And when it comes to the legal, the other side of legal practicing, where when it comes to academicians, we can use machine learning for pattern recognition and trend analysis, and that will help a big time in policy changes documents, and also see how historical doctrines and current precedents are taking changes and help us create new policy changes according to the changing conditions. And of it, we are seeing a very interesting thing where people are actually using predictive analytics to analyze the outcomes of cases and ensure that they have the strategies and also do risk analysis in litigations before picking up a case. This is a very new field, and we are seeing some Western countries and in some places where people are using this, and it will be not much longer where we see all these adopted in the rest of the world as well. And we as legal professionals, and especially you as students, I think should embrace these technologies and get ready for the next generation. And when it comes to changing in curriculum, it is very important that we also have some of these technology subjects embedded within our legal coursework. We could actually have something like a choice-based credit system where students can pick some of the courses, and which will help them in their legal practice or legal profession in future. We are also seeing usage of technology and something like electronic dispute resolution and e-litigation, and these are the things I think students can use them and also practice these on a simulator level. And these are the changes that we want to see in the colleges and the universities that we have in India. And when it comes to legal profession as well, primarily we saw people go into academia or legal practicing or judiciary. These are the three primary things that we saw people after passing out of a law college going in the legal profession. But we have many new roles that are coming up, especially in the corporate world, where you have legal technologists for specific fields. For finance teams, you have specific legal people. You have people for privacy teams. You have privacy cells in the companies. You have dedicated officers called compliance officers who ensure that data privacy and other things are maintained. And these are the roles that are coming up, and we need to be prepared for these roles going forward. And also, when it comes to people who are practicing law, technology has taken some of the existing way. Gone are these days where we would go for in-person interactions between clients and lawyers. We are now using Google Meet and Zoom. We are on a rudimentary level, even in India, we are using Google Drive to upload documents regarding cases and these things. We have courtrooms that have become virtual now. But going forward, we have dedicated software that is coming into play that will completely reshape how the client and lawyer interactions are going to take place. And this is going to happen very soon. Having said that, one very important thing people should keep in mind is the ethical considerations that come with the innovation and technology in place. We still know that AI or any of these innovations are still prone to error. There is an algorithmic bias, and there are also data privacy concerns that happen in this. So it is very important that we as advocates should use professional ethics and code of standards to ensure that we do not, we at least try to minimize the error on our side, and also ensure that we use technology in a very ethical way possible. Having said that, I hope the next generation is going to use technology in a very big way going forward. And I think all the faculty and people who are present here, I wish you take more care and in explaining students about these ethics. And thank you.
Thank you very much, sir. The next presenter is K. Rajeshwari. Her topic is Navigating the Future of Law, Innovation, Ethics and Excellence.
టోటల్ అదే టాపిక్ పెట్టింది ఇబ్బంది లేకుండా నో ట్రేడ్ మార్క్ వైలేషన్ అదే ట్రేడ్ మార్క్
ఎడ్యుకేషన్ పర్పస్ అదే కాన్సెప్ట్.
Navigating the future of law, focusing on professional ethics and accountability. Can a legal system truly deliver justice if its lawyers lack ethics and accountability? If a lawyer wins a case by hiding the truth, is that professional success or a professional failure? A very good afternoon to everyone who all are presented here, respected dignitaries and all the participants. I am K. Rajeshwari from Sri Padmavati Mahila Vishwavidyalayam, Law Department. I am here to present my seminar on the topic of navigating the future, professional ethics and accountability. Ethics and accountability as pillars of lawyers to safeguard client, provide competent service to our clients. Why I am saying to our clients means we all are the legal practitioners. We all belongs to the law and we all are lawyers. The services involves moral, legal responsibilities, promote justice and equality to the clients. Challenges that we are facing is Advocates Act 1961. This act tells us avoiding private communication with the judges and unauthorized law practices. Prevention of Corruption Act 1988. This act tells us to avoid offences like abetting corruption or bribing public servants. Professional ethics means following the moral principles like integrity, honesty, fairness, and confidentiality. These builds trust to clients on each lawyer. Each lawyer means that everyone who are studying law in India, we all are responsible for our professional ethics and accountability. The accountability is being answerable for our actions in the courts, admitting mistakes and transparency. The objectives related to professional ethics and accountability are upholding the integrity and honesty, maintaining the public trust towards us, ensuring the accountability within us. This prevents unethical actions. We can protect our clients by doing justice to our clients. We can enhance our reputation in the public by being an answerable lawyer and a legal practitioner. Professional ethics and accountability supports us in continuous legal analysis, professional practices, and ethical leadership. The relationship between lawyer and a client maintains trust and prevents corruption. My suggestions are to not to violate the trust between client and a lawyer and following the integrity, all the ethical and moral values that belongs to the lawyers to strengthen our career in the law fields. Cases that related to the professional ethics and accountability. State of Punjab and others versus Ram Singh in the year of 1992 and R.K. Anand versus Delhi Registrar in 2009. P.D. Gupta versus State of UP in 1995. In these three cases, the professional ethics has been infringed. When the professionals follow strong ethical principle, it improves the culture of the whole organization. The whole organization means the whole law system in India. Finally, I conclude with the words of Dr. B.R. Ambedkar sir, law and order are the medicine of the body politic. And when body politic gets sick, medicine must be administered. What is the administered? We, the lawyers, has to administer the medicine in law system. It's my great privilege to thank Dr. B.R. Ambedkar Global Institute for the wonderful opportunity to present my seminar. My special thanks to Dr. Tippareddy sir and respected dignitaries who all are presented here. Thank you, one and all.
Thank you very much, Rajeshwari, for your nice presentation. And our next paper presenter is Professor Vishnu Vandana Garu. Her topic is Professional Ethics and Accountability in Legal Profession. I request Madam to present her paper.
Respected Chairman, sir, President, Madam, and Chairperson and Co-Chairperson, thank you for giving me this opportunity. My paper for today is Professional Ethics and Accountability in Legal Profession. A jurisprudential and institutional analysis. Professional ethics gives that moral compass. Accountability supplies the instrumental framework that sustains public trust. Professional ethics denotes moral standards that distinguish a professional characterized by specialized knowledge and public responsibility from mere commercial enterprise. In legal context, it is a body of norms ensuring that lawyers and judges act with honesty, fairness, and fidelity to the law. Ethical regulation serves multiple objects like preservation of public confidence, protection of vulnerable claims, maintenance of professional dignity, and promotion of justice and rule of law. Professional ethics for lawyers and judges can be grouped into 4 categories like duty to court and to client, opponents and colleagues, and to the society. Ethics as a soul of accountability. These professional ethics and accountability are 2 sides of the same coin. Ethics provides internal compass and accountability ensures external verification. Without ethics, regulation becomes coercive, and without accountability, ethics become an empty idealism. Coming to the regulatory framework, all of these advocacy and all of the system of advocacy, they are dependent on this Advocates Act of 1961. The Advocates Act of 1961 is the cornerstone of professional regulation for Indian lawyers. The Act also establishes autonomous bodies like the Bar Council of India at the national level and State Bar Council at the state level. This council performs a dual function. They safeguard the rights, privileges, and interests of advocates while also enforcing discipline through the prescribed standards. The Supreme Court observed in Harish Chandra Tiwari versus Beju, disciplinary powers are not punitive but corrective. They protect the profession's integrity while allowing reform of the errant member. The Bar Council Indian rules have 49(1)(c) And part 6 of chapter 2 enumerates various obligations which the courts and duties have to perform. That is, duty towards the court, duty towards the client, and duty towards the appellant, and duty towards the colleagues. Breach of these duties amounts to professional misconduct. Examples include misleading of court, accepting conflicting briefs, and using improper influence. In Naratmanal Choraria versus M. Admiralty, the court reaffirmed that the profession must remain a beacon of rectitude, not an area for unscrupulous advantage. Duties of advocates, as we already seen, it combines the 3 roles of officer of court, representative of claims, and the guardian of justice. Balancing these roles demands adherence to specific ethical norms. And the judges, that is independence and impartiality, integrity and propriety, equality and sensitivity, accountability through this reasoned judgments. Coming to the recommendations, various recommendations are put forward in order to bring this ethics and morality to be followed either by the advocates or by the judges, like bar and bench. Certain standards has to be included in the educational system as well as in the curriculum. They include, drawing from foregoing analysis, several reforms have been reinstituted, like institutional reforms. An independent ethics commission, various commissions for the ethics development has to be instituted. Digital transparency, where everything has to be, transparency should be there so that it should be known to each and everyone what has been committed. Judicial ethics commission has to be established in order to eradicate whatever the evils that happen in the systems. Educational preventive reforms. Various reforms have been advocated in the educational institution in order to bring transparency among the people to have the knowledge of ethics, not only the law, ethics also has to be followed with regard to the educational basis. Mandatory counseling legal education, that is, we have this free legal aid by which even the students are taking various camps in villages with regard to the legal education. Law school curriculum reform, where various subjects have to be included in order to inculcate in them the habit of this ethics following. Ethical literacy campaigns, and also technological and procedural reforms like ethics guidelines in the digital form, bound disciplinary hearings, which is time-bound disciplinary hearings, and also annual ethics audit. Social and psychological dimensions to be taken into, various reforms should be brought with regard to sensitive chambers and courts, and health support systems and public engagements. The boards of Supreme Court of Bar Council, in one of the cases of Bar Council of Maharashtra versus M.V. Dabalkar, remain the professional guiding light. The bar is not a private guild, but a public institution committed to public justice. Strengthening ethics and accountability, therefore, is not a bureaucratic exercise, but a moral renewal. It reaffirms that the practice of law is a trust for the common good, anchored into, sustained by discipline, and justified only by service to justice. Thank you, one and all.
Thank you, madam. And the next presenter is Kaveri Shukla. Her topic is legal and ethical challenges to legal education in the age of artificial intelligence. I request madam to present her paper.
A very good afternoon to the respected dignitaries present here, fellow participants, and everyone else here. This is Kaveri Shukla, research scholar from Sri Padmavati Mahila Vishwavidyalayam, going to present my seminar on the topic legal and ethical challenges to legal education in the age of AI. As we all know, a society cannot exist without education. A child's education actually begins even much before he learns how to speak or how to say him or express himself. These are not my words, but the words of eminent sociologist Rousseau, who actually said them, that education of a man commences at his birth before he can speak, before he can understand, he is already being instructed. Education plays a very key role in everyone's life. From the past era, we have seen the education system where it was a prevalence of Gurukul system to later on ages change, where we have witnessed the schoolings where the students go and learn the things. And now in the modern era, the era has changed with bringing the concept of modern education, online educational contents which are being easily available. And one among them is your open educational resources, commonly known as OER. These are the contents which are very easily available in the form of open access. The contents of the authors are openly can be accessed very easily. As every side has 2 points, this has enabled a situation where anyone without any financial barriers, traditional barriers, or even without physically attending to the schools, he can learn the things of very basic nature. But this has even, and this form of open educational systems is actually possible by, in the form of that Creative Commons licenses are being granted by the authors to the others, stating that how their content can be actually used. This has raised a popular place where the content which are now being available on online in open access, they are, even by the Creative Commons licenses, they are being used without actually acknowledging them. The contents which are so available on online education system has transformed actually the society, but it even poses the challenge to the copyright protection of the contents which are so available when it comes to the content which are of the original creators. The original creators' contents, when they are being so taken even without acknowledging them for what they have actually mentioned there. This has created a challenge even of, as we have mentioned, I have mentioned about that copyright infringement of such original creators. The open educational resources, as in the section 30 of Copyright Act, the owner of a copyright in any existing work or the prospective owner of the copyright may grant any interest of his work. Creative Commons licenses is one of the best things through which this kind of rights are being granted. One of the major case laws, or one of the landmark case law in this particular case, was with regard to Chancellor, Master and Scholars of Oxford versus Rameshwari Photocopy Services. This case was actually filed against Delhi University and Rameshwari Photocopies, who have used the content of 3 major presses. One among them was your Oxford Press. They have used the content, and when they have taken the content, they have used this content to make the subject matter or study material for their students. When these 3 press went to the court against Delhi University, the court clearly said that using a content for fair use will not amount to infringement of copyright of the original creators. Here, the concept under section 52, that is where exceptions have been given regarding the fair use of the content. But as it is mentioned, there is no clear guidelines as to what contents will actually be treated or what use will be dealt as such that they are fair dealing of a particular online content being available. The challenges of this particular open educational resources to the copyright are lack of judicial precedents ensuring copyright protection for digital contents, due to which challenges are being faced by the creators. There are even challenges in the scope and application of provisions of fair use or fair dealing in the digital context. With regard to the same, the section 107 of US copyright law, actually in a decided case, they have said that, the court has actually said that it should be decided based on every cases and gave a 4 guidelines regarding the purpose and the character of the work, nature of the copyrighted work, amount and substantiality of the portion being used, effect on the potential market force are to be actually taken into consideration while it is being decided that whether fair dealing of a particular content is being done or not. And even the AI generated contents, which raises a complex question about authorship, ownership and the application of copyright laws. The existing copyright laws may not adequately address issues related to digital content, which causes the legal uncertainties and challenges posed by emerging technologies to the original content creators. The suggestions that I would like to give from my side is that the legal provisions should be amended to define that in the work which is completely created by an artificial intelligence, AI generated autonomous works, who is to be regarded as the author of that particular work. There should be a clear provision regarding them, and even the section 52, which gives an exception on the infringement of the work, should be set a specific limit over what the contents can be used. A recognized copyright society should be established for monitoring the users that exceed the proposed fair dealing and the collective licensing limits. Finally, I would like to conclude my topic with the digital learning technologies as have emerged and became a part of our life, which has made the learning procedures so easy for us, should even include the basic guidelines with regard to how much content should be used and how they are to be dealt such that the creators' works, the original work of the creators, are not being so infringed. Thank you for giving me this opportunity.
Thank you, Kaveri Shukla Garu. And now the other presenter is Miss Prabhati Sir. Her topic is ethical use of artificial intelligence in legal education. I request Madam to present her paper.
Jai Jagannath. I am from Odisha. After a big patience, after a lot of waiting, finally I got chance to present my paper here, and with a warmth and heartfelt thanks to the Honorable Chairman Sir, Honorable Madam, President Madam, and their beautiful 2 daughters, and also the very collaborative team of the Tirupati, Dr. Ambedkar Global Law Institution, Tirupati. Really, I would like to again pay my thanks to given me an opportunity to present my paper here, and I would like to start my deliberation, my contribution with a line, a beautiful line by my father, that the past is a cancel check, the future is a promissory note, and the present is cash in hand. So use your present to modulate your life very politely and very useful, because already we lost. Future is there, we don't know what will be happen there,
but present is in our hand and that is in cash in our hand. So definitely we should utilize our present, and my subject is that the ethical use of AI in legal education. And let me introduce again myself, that I am the assistant professor from Odisha, a very leading institution, that Sanjay Memorial Technological Institution, a 44-year-old institution, and I'm very proud that I'm representing Odisha today here, the neighbor state. Really, I'm very much proudful. And let me please go to my subject because there is a limitation time. So, that is ethical use of AI in legal education, where exactly we can say the now artificial intelligence has become a part of our life, like an essential part of our life. We can if we can relate it, you can make a relation between a water and a fish. Exactly, the human life become like a water and fish. A water can live without fish, but a fish cannot live without water. Exactly, the human being now become like a species of water and species of artificial intelligence that cannot live without water now. That cannot live without artificial intelligence. The man is very much dependent upon now the artificial intelligence. Whatever may be the situation, whatever may be the conditions, definitely we depended upon our mobile. So, just my suggestion is that whatever may be the condition, whatever may be the benefits you are getting from the AI, but please, something do from your heart, something write from your heart. Which can you write? Yes, use your brain. Why you are so depending? Because AI is the production of the brain of the human being. It's not the AI is a master of the human brain. The human brain is the like the mother of the AI. We can say that the mother is a mother, the child is a child. When a child can become a mother of another one, but not her own mother, right? So we should do something else, but not focus upon the AI and let them lead us. Don't let them lead us. Please, is my request. So there is a line I have reflected in my abstract, that is the creator, that AI is a tool to assist human. The AI is a tool to assist human, not to replace humankind. The creator of AI is the human being, but when the AI start to consume the brain of human, it is like the thought, iron is destroyed by its own rust. Is it? The iron is destroyed by own rust. So that's the thing I need to clarify in my abstract. And also, this thing also we can say, my paper is depend upon that. So let me introduce my introduction. In the last decade, the use of artificial intelligence in legal education has expanded significantly from the personalization of curriculum to the automation, assessment, and administrative tasks. AI provided various opportunities to improve the legal process. However, these innovations also raise serious ethical questions, especially regarding confidentiality, fairness, and transparency. Moreover, artificial intelligence and legal ethics is changing many industries around the world. AI helps lawyers work faster and smarter by doing tasks like researching laws and checking context through understanding of the potential benefit and ethical consideration tied to the use of AI in legal decision making can be trained through a review of relevant literature and wide perform design. So, my significance of the topic, because time out, so just I
Please
would
conclude
like,
yourself.
The advantage of AI in legal education and legal decision making is significant, but there are serious ethical issues that must be resolved before it can be fully implemented in the judicial system. A significant hindrance lies in the absence of transparency and comprehensibility in AI system. Whereas, just one case law I need to discuss, that is in Thane versus US Copyright Office,
that US courts have consistently ruled that works generated purely by AI without significant human creative input cannot be copyrighted in the United States, reinforcing the human authorship requirement. So only the core principle of ethical AI, that 4 point is there. One is fairness and non-discrimination, and transparency and explainability, see, accountability and responsibility, and privacy and data protection, and human oversight and control, and safety and security. Let me conclude. Please don't copyright anything. Something please write from your heart, and something try to be very own, not based on the copy and paste. Please, thank you. Thank you for giving me chance.
Thank you very much, madam. Because the time is very short, I request the other presenters to confine to 3 to 5 minutes only. I request Madhavi to present her paper on artificial intelligence, hallucinations and professional ethics, humanize the problem when agglomeratic lie.
ఎస్ అని వచ్చింది. ఇంకో రకంగా మధ్య పెడితే నో అని వచ్చింది. అంటే నేను చేసిందల్లా నా దగ్గర ఈ వాట్సాప్
A very good afternoon, everyone. The topic that I'm going to present is AI hallucination and professional ethics. Humanize the problem when algorithms lie. Today, I invite you into a world where the law, the very symbol of truth, is confronted by something profoundly unsettling. A machine that speaks with confidence, even when it is wrong. This presentation is not just about the technology. It is about the trust, about the truth, and the future of justice. What do you think would have happened when a lie looks more perfect than truth? Now imagine a courtroom where a judge is overworking, a lawyer racing against the deadlines, and a machine actually beautifully producing judgments that never existed. Ladies and gentlemen, this is not the fiction that I have narrated. It is the living reality that is happening in India right now. And one thing which is more likely to be blamed off for this is AI hallucination, which in short is false facts generated by the AI generative systems, which could be happened due to multiple reasons. Could be caused due to confusing or misworded prompts, or incomplete or inaccurate data which is provided to the AI, leading to the fabricated case laws, citations and precedents which are reaching to the courts. I guess I'll not be wrong if I say this. AI is transforming Indian legal practice, but it is also rewriting the reality. Where courts started using AI for transcription and translation, lawyers relying on AI for research and drafting, which surely does provide some fabricated data. We celebrate AI for its speed, we celebrate AI for its efficiency. But we often forget one thing, that AI does not understand the responsibility. It only predicts, and sometimes it predicts wrong. At the heart of this study is one question, that is, when a machine lies, then who must tell the truth? It is us. And to be more specific, my objectives were to examine how AI hallucinations threatens the legal ethics, and to analyze legal Indian judicial incidents where AI-generated false citations entered the court records. To answer these questions, I employed a qualitative doctrinal research method to analyze the Indian court precedents, judicial speeches, and comparative international cases. Coming to the Indian incident, the Bakai Trust case, where in December 2024, Income Tax Appellate Tribunal in India have passed an order basing on 4 judgments. 3 of them were Supreme Court judgments, and 1 was a High Court judgment, which actually never existed. And it was later actually withdrawn. Whereas in Mata vs. Avianka 2023, a US judgment, where lawyers were sanctioned for citing 6 AI fabricated case laws. This shows how legal system was deceived by an algorithm, where truth was replaced by probability. But the thing is, justice cannot run on probabilities. Moving on to the findings, which shows that Indian courts have recognized the threat. Yet, no AI-specific ethical rules exist in India. India's fragmented case law system increases the risk, where judgments being passed every day by Supreme Court, 25 high courts, and thousands of tribunals and subordinate courts. Moreover, India lacks a single official legal database where all the cases are kept intact in one place. Increasing dependence on legal practitioners on AI is a concern. Actually, the danger is not the machine. The danger is our blind belief on that machines. The recommendations flows like this. Starting from the law schools, where students should be taught how to use AI and also should be taught how to re-verify the information that they have extracted. And every lawyer should actually manually verify everything that they have taken from the AI so that they can put it before the court is actually doubly checked. In courts, ethical AI use guidelines should be introduced. Citation verification should be made mandatory. Punishments for unverified AI use in courts should be imposed. Though we cannot control how AI behaves with us, but we surely can control how we behave with it. With this, I would like to conclude it by saying that AI hallucinations are not technical errors. They are the ethical wake-up calls. Imagine if lawyers stop verifying, if judges stop questioning, and if students stop thinking, then one day the law may speak with a voice that is not human, that is not truthful. The future of justice depends on a simple promise. That is, let the machine assist and let the humans decide. Because the lawyer's duty to re-verify is non-deligible. Thank you very much.
Thank you, Madhavi. There are only last two participants are there. Only 3 to 5 minutes only. Now I call Asir Ahmad to present his paper on impact of technology on marriage and intimate relationship.
yesterday కూడా ఇది వచ్చింది నేను దాని లాలో మీరు ఎలా కనెక్ట్ చేయగలరు
In the world which ruled by the screens, the strongest relationships are those that still knows how to look into each other's eyes and find love. A very good afternoon to the respective dignitaries and the faculty members and my dear friends. My name is Asir Ahmad. I am from BCom LLB final year from Dr. Ambedkar Global Law Institute. Today I am presenting and my topic is impact of technology on marriage and intimate relationships. Marriage and intimate relationships are built on communication, trust, and emotional connections. In the digital era, technology has entered every aspect of our personal lives, sometimes strengthening our relationships, and the same technology sometimes silently weakening them. This presentation explores how the technology shapes modern marital and intimate relationships. My objectives of the research paper is on screen. How technology reshapes intimacy and communication, benefits and risk of marital stability, digital influence on trust, privacy and conflict, psychological, social and cultural impact, framework for healthy tech integrated relationships. For solving my research paper, I have used doctrinal methodology and comparative research. Now, I would like to take you back into the history of marriages. Prior to the 20th century, the marriages are so simple, and the involvement of the technology into the marriages and intimate relationships were very negligible. And the marriages and intimate relationships were unharmed by the technology. Moreover, the post-20th century, there is a rapid growth in technology, telephones, televisions, and internet introduced to the world. The impact of technology is on both positive and negative way. I would like to go with the positive influence of technology first. Technology helps in staying connected with people through text, voicemails, etc., and strengthens everyday communication. Tools like video call, shared apps helps couples separated by the separated by work and staying connected with each other. Technology helps in sharing digital spaces like calendars, budget talks, and music, etc. Now, I would like to explain the negative impact of the technology on the marriages. Emotionally disconnect. The couples who are emotionally disconnect, even though in the relationships, due to couples may be physically present but emotionally absent by scrolling or browsing, which leads to the loneliness within the relationships. Exposure to highlight reels create pressure and comparison, leading couples to feel the reality is inadequate. Social media comparison culture nowadays destroying the relationships and bringing unpleasant things to the marriage. When the argument becomes text-based, losing the nuance of the tone and the facial expressions increases misunderstandings. And the digital snooping and the surveillance. Nowadays, checking a partner's messages, call logs, or locations is common, but it reflects insecurity and erode trust regardless of justification. Moreover, the technology-driven infidelity, quiet conversations and emotional sharing outside the marriage can lead to the betrayal. Betrayal can unfold entirely through messages and social platforms without using physical meetings. I would like to conclude my presentation by saying that technology is a powerful force that must be navigated with a maturity, intention, and awareness. Maintaining balance, digital boundaries, and meaningful offline communications is essential for sustaining healthy connections. Thank you so much for giving me this wonderful opportunity.
Thank you, Ashir Ahmad. And the next participant, KL Bhargavi, her topic is Law and Social Impact.
Yes, good afternoon to one and all who are all present here. This is Bhargavi from 9th semester of this college. As today's my topic is law and social change. These are the subtopics I want to say today in this seminar, but there is no time to say, just I will, within 5 minutes I will conclude this. Law, already you are law students, so law means rules, regulations where the state government enforced for human conduct. Social change, changes that are made and adapted for adaptation of the laws which are made by the legislations, parliament. Relationship between social change and law. There is, it is an interdependent connection between social change and law, and also it is a dynamic thing which is made. It impacts on social structure like customs, traditions, ethics, norms, values, everything. The changes which are made from past to present, at present means abolition of social evils, which are like abolition of sati system and also child marriages and untouchability mentioned in Article 17 of the Indian Constitution. And also fundamental rights, it's a main part thing. Part 3 of the Constitution says about it. Everyone knows this. Protection of their fundamental rights and protection of
and promotion of equality, justice and welfare, empowerment of women and weaker sections of the society. Women empowerment, nowadays women empowerment is more. You also know that all men and women are treating equal. All are doing in every situation, in every sector, women are equal with the men. These are the theories. There are 4 theories: historical school, sociological school, Marxist theory, functionalist theory. Limitations, there are more limitations, but these are the 3 main limitations of this resistance from society. That means objections that are formed between the society. Lack of awareness to the people like villagers, etc. Poor implementation of the law. That means wrong provisions of the law. And in conclusion, law plays a vital role in social transformation. Social acceptance and proper enforcement are essential. Law and social change together ensure progressive society. Thank you for giving this opportunity. As for this seminar, I am concluding as where law leads the way, social change here is to stay. But my point of view, my conclusion is when a society changes the law, it signifies maturity. When a law changes the society, it signifies development. Thank you.
Thank you, Vargavi. See, one more last participant came. Just we will give 3 minutes time only, because otherwise we should not disappoint him. With the permission of the chair and co-chair and other dignitaries, just 3 minutes we will give.
It's okay.
Guganeshwaran, his topic is criminal justice oriented approach.
Very good afternoon, one and all, and dignitaries, and my seniors of this college, and my faculties, and my friends. This criminal law is not like civil procedure. Civil law is more effect of personam between 2 persons, but the criminal law is but citizen versus state and non-citizen also. This criminal law touches our life directly. Under Article 21 of Constitution of India, it touches life and liberty directly. There is 3 major criminal law will be there, which is CRPC, IPC, Indian Evidence Act, as we know, before 2023. Why the CRPC is established? This criminal law directly touches a person's lives and liberty. That's why CRPC 1973 made out to criminal procedure should be interfered only by this criminal procedure code. That's why CRPC established. Due to time concern, I will be go very fastly. That's why, and we all we know, criminal case start from FIR, which is called First Information Report. AIR 2014 SEC criminal page number 181, Lalita Kumari vs. State of Uttar Pradesh. This case judgment, which shows clearly under section CRPC 157 of BNSS 173, register of FIR is mandatory when the information is clearly disclosed as a cognizable offence. The police cannot delay or refuse register on the ground of conducting enquiry first. This ensures prompt commencement and investigation, protection of victim, stationery and constitutional rights. If prima facie case is made out, what is prima facie case? What is prima facie case? At the first appearance, at the first impression, it is called prima facie case. Also, it is one of the circumstantial evidence until suspect prove. 2 types of offence will be there: cognizable and non-cognizable. cognizable offence under section 2, subclass 1, subclass F of BNSS. It is terrific offence which is conclusion. Mahatma Gandhi, he is a father of nation, so called. In this independent country, we have independence to do crime also. Thank you.
Very good.
Thank you very much, Guganeshwaran. With the permission of the chairman, sir, and also co-chairperson, chairperson, we are concluding the sessions. The 6th session is completed. Now I request.
They're already. Right, sir.
Now there is a small program for 5 minutes. There is a felicitation to Professor Pankaja Madam Garu. I request Professor Pankaja Madam Garu to come on to the dais. A small felicitation from Dragli.
What is this Dragli?
I request the chairpersons also please come on to the dais. There is a facilitation to Krupa Sagar sir, Justice Krupa Sagar sir, and also Ramakrishna Garu, Professor Ramakrishna Garu. Please come on to the dais. There is a small facilitation from Dragli. I request Krupa Sagar sir and also Ramakrishna Garu to come on to the dais. Give you a big hand. And Pullareddy sir also, I request Pullareddy sir to come on to the dais. I request Srinivas Garu to come on to the dais. Just please come. This is as a token of gratitude. Madam Pankaja Madam worked in this college and then she elevated to the Mahila University and also Delhi University. Now she is working in Chennai. So this is a small token of gratitude from the Dragli. Give a big hand to Madam. Claps, claps, claps. Arey, what are you doing? Claps, claps, claps. Thank you very much, Madam, for coming here. Yes.
Yeah. Good afternoon to everybody. I owe a lot to this institution. And Dr. Tipareddy sir, he gave me the first opportunity to teach in the college. And when it was established in 1991, and I started teaching, and it is my credit to announce in public that apart from one principal, Sambasivarao sir, and I happen to be the first teacher being appointed in that college by Tipareddy sir, and he is very magnanimous. He is a role model employer, I can say, and we felt that it is our family. And coming back to our family, I also feel that this invitation immediately I accepted, and I was waiting for this for the invitation. And from Ambedkar Law College. Earlier it used to be Ambedkar Law College, and this is the first platform where from there I went to Delhi University. All my academic developments and achievements I owe only to Tipareddy sir and this institution. Okay, sir. I am very happy to be a part of this seminar, and we will meet again, once again. Yes.
Thank you, madam, as you are the family of the Dragli. Then there is a session for food. I request the resource persons and the paper presenters, please go to this ground floor, and student volunteers, please accompany this chairpersons and co-chairpersons and student volunteers. All students be here, don't move. I request the resource persons, chairperson and co-chairpersons, please join for lunch. Participants also, that is paper presenters, please also move. Paper presenters. Next, paper presenters. I request paper presenters to go downstairs. Paper presenters, please move. Paper presenters, please move. Fast, fast, fast. Shortage of time. Paper presenters. Paper presenters. Student volunteers, please tell them to rush. After lunch, all should have to assemble here at 3 o'clock. Sharply you should be here at 3 o'clock. Now, the hostelers have to go to hostel. Their food is prepared in the hostel only. Hostelers have to go to hostel. Yes, hostelers. No hostler is there? Yes, tell them to go. Hostelers have to move. Go in a line, go in a line. Go in a line, make a line. Go fast one after the other. You should show the discipline. Day scholars have to go to food court. Day scholars have to go to food court ground floor. I request all the day scholars in a queue, you have to go to food court ground floor. And you should be assembled here at 3 o'clock sharply.
Yes, yes, okay.
బాబాయ్ ఫోన్ చేశారా? బాబాయ్ ఫోన్ చేశారా?
సినిమా పాటలు సోని కరెక్ట్గా అడుగుతుంది. గాలి ఎప్పుడు వస్తాను వంట వంట అదే కొత్తగా చూసాను దూరం నుంచి బాగా ఏంటి ఏం చేసుకుంటారు
Hello, how are you? నాకు రాదా పాట హే గణప హే గణప హే నటప హే త్రిభువనప హే గణప హే నటప హే త్రిభువనప హే హే కిందకి వినిపిస్తుంది బయట వాళ్ళు కూడా వస్తుంది మేడం దీన్ని ఆపేయాలి మేడం ఫస్ట్ తిరుజవరాల తిత్తి ఈ తరళమైన నీ తారహార మధురే తిరుజవరాల తిత్తి ఈ తరళమైన నీ తారహార మధురే తిరుజవరాల తిత్తి ನೀರಜಾಕ್ಷಿ ಅಲಿಗೆ ವೇಳ ಮುಡಿವೆಲ್ಲು ಮುಡಿವಂತ సరే చాలు సతసైన్యాలు నడిపే తీరుడైనా వసుధావాని మిదిలావే మది వెలుక బలుకు పలుకులెరుగగలడా నీలి మేఘములలో ధరణి తేజం నయనాంతరంగములలో మనవాసం
బాగుంటుంది సాంగ్
ఓకే
మనం కూడా ఫోటోస్ తీసుకుని మీరు ఎట్లా ఆడిటోరియం దగ్గర లేదన్నారు ఇది ఫుల్ పట్టు తీసుకున్నాం మేడం
ఓకే మేడం
అక్కడ మీరు కూర్చోండి చైర్ పర్సన్ very nice person. And yes, yes. As listening and it's dealing with the days, very excellent. Guys, dealing with the yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir.
ఒక మంచి మెసేజ్ లైవ్ ఉందో లేదు చూస్తాను
Public trust. Professional ethics.
హలో హలో ఆడిటర్లో ఉండా ఇప్పుడే పైకి వచ్చాం మళ్ళా కిందికి రావాలి ఎవరు ఉన్నారా అమర్ బాబు స్టేజ్ కాడికి ఇది లైవ్ పోతాను లేదు చూస్తాను
బాగున్నాయి సార్ వెరైటీ కలర్
Moral standard. Moral standard.
లైవ్ రికార్డ్ అయితే ఉంది
రామని చెప్తున్నా నేను చెప్తా తెలీదు రాస్తున్నారు రాస్తుంటే వేరే తెచ్చుకో ఏంటి రాశారా వేరే వాళ్ళు ఏదో ఒక రాష్ట్రం మళ్ళీ మనం ఇంకా గడిపో కాడి పెట్టేస్తాడు ముసలి అంటే పుస్తకం పుస్తకం
మైక్ లేదు కాబట్టి సరిగ్గా వినపడలేదు మాకు. మైక్ తీసుకుని ఎవరు మాట్లాడారు?
నాకు రాదు పాట సరే
హృదయము కత్తమని నీ రూపు బింబమని తెలిపేను హృదయం నీకు సొంతమని బింబాన్ని అందించా వేరేది లేదు సఖి అంతే. హలో హలో చక్కని తల్లికి చాంగుబల చక్కని తల్లికి చాంగుబల తన చక్కెర మోవికి చాంగుబల చక్కని తల్లికి చాంగుబల తన చక్కెర మోవికి
All of you, please settle down. All the volunteers. Distinguished guests, esteemed resource persons, academicians, student participants, print and electronic media brethren, all faculty members, Dr. Ambedkar Global Law Institute, my dear students, and everybody present over here. A very good afternoon to everybody, and I heartily welcome you to all to the valedictory session of the two-day national seminar on navigating the future of law, innovation, ethics, and excellence. Now, I would like to invite the chief guest of this valedictory session, Honorable Justice Retired High Court of Andhra Pradesh, Dr. V.R.K. Krupakar sir, to kindly please come on to the dais. Now, student volunteer will give bouquet to the sir. I take immense pleasure in inviting Dr. Aluri Ramareddy Garu, Bar Council of India member, Executive Vice Chairman, Bar Council of India member trust onto the dais. Please welcome sir. Now, I would like to invite Professor Dr. S.V. Pullareddy Garu to come on to the dais. Former Registrar, Rayalaseema University, Kurnool. Now, I would like to invite Professor Ramakrishna Garu on to the dais. Please welcome, sir. I would like to invite Founder President, Dr. Ambedkar Global Law Institute, Aduri Sharadamma Garu, to come on to the dais. I request Honorable Chairman, Dr. Ambedkar Global Law Institute, Founder, Chairman and Director, Dr. Tippareddy Garu, to come on to the dais. I wholeheartedly invite Dr. Vijay Kumar Behra Garu, Principal, Dr. Ambedkar Global Law Institute, Tirupati. I would like to invite Honorable Convener of this today national seminar, Dr. A. Ashwini Madam, onto the dais. Now, I would like to invite the chief guest of today's function, Dr. V.R.K. Krupakar sir Garu, retired Judge, AP High Court, to address the gathering.
Very happy good afternoon. A champion of legal aid and an expert of gynecology, together delivered of a baby called, like Bruce Lee. For some time we were unable to actually understand the acronym that the children were actually pronouncing here. Dragli. A 2 days very sumptuous seminar and a delicious lunch just now went by, and an agitated heart because my flight is scheduled. I shall speak before you. మిగతా వాళ్ళందరిలాగా కాకుండా లా చదివే వాళ్ళకి there is one thing that is wonderful that they must realize. They are the only, the very few professions are there where you are rewarded for your words. So throughout your career, if you wish to be in the legal profession, it is the ability of usage of words that you write or you speak that brings rewards to you. In the morning session, you have heard one of the wonderful speeches of the guests here. And a chief guest, by its very name suggests, he is chiefly a guest. A guest has no limitation, relevance or irrelevance, only for a judge or a lawyer, but not for a guest. So whatever I believe that could convey some sort of a pleasurable meaning of your own careers, that would be achieving the target. I would like to present to you two small examples. Both of them are real. There are two friends in America. One of them is a lawyer, a good lawyer for that, and a champion of human rights also. And the other friend, his friend, is a businessman. On a business trip, he had gone to China. And in China, for some indecent act in public place, on such allegation, he was arrested. So he was put in jail. And he contacted his American lawyer friend. And immediately the American lawyer friend, who was in practice for 20 years, he flew to China. And the designated day for their meeting, the lawyer thought that it would be appropriate because the friend is in jail, he cannot otherwise meet him. It was on that day where the court scheduled hearing was there. So he attended the court proceedings and the remand prisoners were brought. Case after case, the judge has to hear and dispose of. It was at that time, under the control of the security, the under trial prisoners were there. The American lawyer wanted to speak to his friend so as to render legal help to him. All good intentions, a wonderful support. He went and was just about to physically reach the prisoner. Immediately he was arrested. He was taken to prison. Dear friends, it took 34 days, and finally, on the intervention of the President of United States of America, this man was released. The lawyer man was released. What is the moral? The moral is here. The law in China was anybody approaching a prisoner commits a grave crime. No, I just wanted to serve him a cup of coffee or wanted to convey my greetings or some such thing. Your intentions do not matter. So it's like an automobile accident. If you don't walk well on the road, you are hit, that's all. No, sir, I'm a very good boy, it doesn't matter. So what exactly is the law in this AI గురించి అన్ని గ్యాడ్జెట్స్ గురించి చదువుతున్నాం గ్లోబల్ విలేజ్ అని ఇప్పటికి చాలాసార్లు చదివేసి ఉంటారు సో మనందరూ అర్బనైట్స్ విలేజెస్ ఈజీగా కాంకర్ చేయొచ్చు అన్ని బాగానే ఉంటాయి బట్ ఫైనల్లీ వాట్ యూ హ్యావ్ టు రియలైజ్ ఈజ్ నేను ఎక్కడికి వెళ్తున్నాను ఏం చేయబోతున్నాను అన్న దాంట్లో మరొక మోరల్ ఒకటి ఉంటుంది ఇంపార్టెంట్ ప్రిన్సిపల్ దట్ విల్ కమ్ అప్ ఎ లిటిల్ లేటర్ అండ్ ద సెకండ్ వన్ is this. There were three people, all of them were given long sticks. Each one was holding these sticks in their hands. The first man was asked to leave it, drop it. He dropped it. It went up. The second man was asked to drop it. He dropped it. It went down. And the third man was asked to drop it. He dropped it, but it just stood there. The great lateral thinking professor, Edward D. Bono, tells us why something appears very either amusing or confounding to all of us when three people holding similar wooden sticks, when they drop them, each of these sticks behave differently. దీంట్లో కానీ మొదట్లో తెలుసుకున్న స్టోరీలో కానీ ఉన్న ఇంపార్టెంట్ ప్రిన్సిపల్ ఏంటంటే ఈచ్ వన్ ఆఫ్ us యాక్ట్ with an a priori assumption, an assumption which we believe is the only possible assumption. American lawyer thought, like in America, in a public court, meeting a prisoner is no offense. The way he is educated in a system gave him a stubborn perception of law, that law could have been similar anywhere in the world, which is not true. The other example De Bono was citing to us is an assumption. What really confounded us is that when I narrate this story to you, the usual possible assumption that you hold in your minds is all of them are on the same plane. No. The first man was under the water. When he dropped the stick floated upwards. The second man was on the ground, that is earth. When he dropped it, it went down. The third man was in space. When he dropped it, there was no gravity. It just stood still there. So here the assumption, what misled us was our own assumption, not because of lack of knowledge. When I say that he stood beneath the water, dropped the stick, you would very well say that the stick would flow upwards. So what really misguided us is our own assumption. So knowledge, while you actually acquire, you must acquire while being cautious. What exactly is the assumption that this creates? What exactly is the principle that is thought to be conveyed? And then while we'll having our informal discussions with my esteemed friends, from whatever wonderful speeches that were given by all the participants, a few topics came up for our dialogue among us. Though I am not here actually to say any of them to me, or too many of them, or too much about them, just I would like to say one or two and leave it there. Ethics, morals, all these things are explained. And professional ethics, wonderful papers were presented. And then the age-old question, the question is, truth shall be upheld. That's what exactly it is said. And truth is justice, that is also said. And law and justice. When you read law and justice, remember, law is a fact and justice is only a perception. Justice is only a perception. I'll tell you one example and I'll come back. The example is this. There is a street. It was at about 4 o'clock in the evening. On both sides of the street, commercial establishments were there. And on left side of the road, a boy was standing and taking a cup of tea. And on the right side of the street, a man was just waiting for an auto rickshaw to come so as to travel somewhere. It was during that time, a car came. A gentleman came down from it. He went to a footpath where another man was standing. He stabbed him to death and boarded the car and left the place. The man who was waiting for the auto rickshaw is an eyewitness to it. The man who was taking a cup of tea is also an eyewitness, both in the broad daylight with their eyes open or actually looking at the street, and they witnessed it. And then when they were interviewed by the investigation agency, certain details are to be asked, because devil lies in the details is what they say. That someone came in a car, got down, stabbed someone to death is something that is fine. ఎట్లాంటిది ఆ కారు, ఏ కలర్లో ఉంది, ఇట్లాంటివన్నీ సామాన్యంగా ఉండే ప్రశ్నలు చాలా అవసరంగా ఏర్పడతాయి. అది ఏ కారో చెప్పలేనంటే కార్కి బస్సుకి తేడా తెలుసా అంటే తెలుసు అంటే వచ్చింది కారా బస్సు అంటే కారో బస్సు కూడా చెప్పలేను సార్ అన్నావు అనుకో. Would anybody actually grant you any merit? No. So a few details are required. So the man who was consuming his tea, when he was interviewed by the investigation officer, he said that it was a black color car, sir. And the man who was actually waiting for the auto rickshaw on the other side of the street, he said that it was a white color car, sir. So black and white there, you can't actually, మిగతా కలర్స్ అయితే కొంత డిఫికల్టీ ఉండొచ్చు, అది ఎల్లోనా ఆరెంజో చెప్పలేకపోతున్నాను సార్ అని. బ్లాక్ అండ్ వైట్ సర్టన్లీ. ఇందులో జరిగింది ఏమిటి? The criminal knows how human brain takes an assumption. Finally, the discovery was this. లెఫ్ట్ సైడ్ పార్ట్ అంతా కార్కి బ్లాక్ కలర్ వేశాడు, రైట్ సైడ్ పార్ట్ అంతా కూడా వైట్ కలర్ వేశాడు. నా కారు అంతా ఒకటే రంగులో ఉంటుంది, మీ కారు అంతా ఒకటే రంగులో ఉంటుంది, అందరి కార్లు ఒకే రంగులో ఉంటుంటాయి కాబట్టి ఒకటే రంగు వాడచ్చు, అసలు కార్లన్నీ ఒక రంగే కలిగి ఉంటాయి అన్నది మన అజంప్షన్. సో దోస్ హూ హ్యావ్ యాక్చువల్లీ స్టడీడ్ హ్యూమన్ అజంప్షన్స్, ఇందాకనే ది లాస్ట్ స్పీకర్ వాజ్ టెల్లింగ్ ద బెస్ట్ ఫ్రీడమ్ ఈజ్ ఎంజాయ్డ్ బై ద క్రిమినల్. సో దిస్ జెంటిల్మెన్ హ్యాస్ కమిటెడ్ దిస్. అయితే వీటన్నిటికీ ఎందుకు మనకి, వై డు వి రియలీ know all these stories? Because lawyers are to tell these stories in the court. Stories of human agony. Should you come and cry representing a wife as against a bullying husband? Should you come and cry in the court, or should you actually present it? And then should you present it like a news reader, like Shanti Swaroop, whether it is an earthquake or a marriage ceremony, without showing any feeling on the face? My lord, the man was coming and beating. Should you say it? Would it be palatable to you? As a student in the classroom, would you like your teacher speaking like a robot? No, not exactly. So, a few things like this, Law and Modern Mind, and so many other good, very good books are there, which give you an important insight into the way a lawyer is expected to look at. And now, with reference to the conversation that we were having with our friends, while truth is justice, the question was like this: after you become a lawyer, in the event, as lawyering is only one occupation that you can take up, if at all that is your pursuit. A lawyer interviews his client, say for example a crime, and he is to defend his client. Lawyer believes he holds a lot of morals. Love your neighbor, never your neighbor. ఇలాంటివన్నీ చదువుకున్నాడు పాపం. సో ఎవరికి హాని చేయకూడదని చదువుకున్న లాయరు వాడి దగ్గరికి వచ్చిన మొత్తం మా క్లయింట్ ఏమో, సార్ నేను వాడిని పొడిచి వచ్చాను సార్ అని చెప్పాడు. నౌ ద డైలమా ఈస్, షుడ్ ఏ లాయర్ యాక్చువల్లీ డిఫెండ్ ది క్లయింట్ ఆర్ నాట్? And I have taken this example to essentially present to the young students the distinction between ethics and morals. Morals is what you believe. Ethics is what your profession tells you to behave. So this dilemma wonderfully answered by an American jurist telling the lawyers, right Baba, this is the man who is your client. He said the facts and circumstances, finally said that he stabbed him also. And then that stabbing somebody is an offense or not, is it for your grandmother to say? Is it for your mother to say? Or is it for a lawyer to say? Or is it for a judge to say? That he deserves punishment is one, that he has to be punished and he is punished is the official business that is to be rendered out. So let us leave it to the judge. Let him judge whether he stabbed or not. So not simply because your client has stated to you certain things, you do not pass a moral judgment on him. Even if you hold a moral judgment, your professional ethics demand and and the client lawyer privilege commands you, you should not divulge it. You should not divulge it. So once you enter into your profession, these are some of the important things that you must notice. We often come across another ethics, that is conflict of interest. Conflict of interest about persons holding high positions. We are not about those topics. They are very academically relevant. They give you excellent strength, theoretical strength to you. But how do you translate it in terms of your real life? In real life, what happens is that you have got umpteen number of cases reported. One example I suggest to you is, a man was into practice, wonderfully practiced, and then he became a public prosecutor, and he demitted his office, and then commenced back his practice. So as a lawyer, you will defend a criminal. As a prosecutor, you prosecute a criminal. And once again, you become a lawyer, you defend the criminal. రోజుకో మాట మార్చొచ్చా, ఇలా ఇష్టం వచ్చినట్టుగా చేయొచ్చా అన్నది మోరల్ అయి ఉండొచ్చు. But legal ethics, they permit you. And then the question was, after he became a lawyer, when he wanted to defend a client, the objection raised by the other party was, at one point of time, he was a prosecutor in one of the cases against this very gentleman. Now, how do you, public prosecutor గారు మర్చిపోయారు, వయసు వల్ల కొంత మతి మరపు వస్తుంది, వయసు వల్ల ఆ వ్యక్తి యొక్క ఫిజికల్ ఫీచర్స్ కూడా మారిపోతాయి. In terms of innocence and sincerity, it is there within the heart and mind. But in terms of reality, as a fact, it was not so. ఇవాళ మీ దగ్గరికి ఒక క్లయింట్ వస్తాడు, మీతో మాట్లాడతాడు, ఫీజు ఏదో చెప్పారు చివరిలో, అది చెప్పి అబ్బో అంత భరించలేము సార్ అని వెళ్ళిపోతాడు. మీరేమో క్వాలిటీ రిక్వైర్స్ లాట్ ఆఫ్ ప్రైస్ అయ్యా, ఐఎమ్ వెరీ క్వాలిటేటివ్ లాయర్. అయిపోయిన తర్వాత ఇంకెక్కడికో వెళ్తాడు. వెళ్ళిన తర్వాత ఆపోజిట్ పార్టీ మీ దగ్గరికి వస్తాడు, మీకు ఎంత కావాలంటే అంత చెప్పండి సార్ ఇస్తానని తీసుకున్నాం. చూస్తే ముందు బ్రీఫ్ చేసిన వాడు ఒక పార్టీ, మీరు బ్రీఫ్ తీసుకున్నవాడు మరొక పార్టీ. నేను ఎక్కడ సంతకాలు పెట్టుకోలేదు, సంతకాలు పెట్టించుకోలేదు, నేను ఎక్కడ ఏం చేయలేదు, ఇవన్నీ అంటే ప్రొఫెషనల్ ఎథిక్స్ ప్రకారం ఏమై ఉంటుంది? ప్రొఫెషనల్ ఎథిక్స్ ఈజ్ నాట్ ఏ పేపర్ టు స్టడీ, రైట్ ఎగ్జామ్, get good marks, and get out of the college. No. Professional ethics are some mantras that you must imbibe within yourself. So what is good, what is bad, these things shall always be kept in your mind. And then as you are going to your profession, you must be aware, the transformation from the studenthood to lawyer is a very important thing. Bar Council of India's journal, it used to publish wonderful articles. One among them was, this was in 1990s, transformation of a law student into that of a lawyer. ఏమిటి తేడా ఉంటుంది అనేది. In the classroom, while a concept is under discussion, one or two important rulings are taken up. They are threadbare read and dissected, and as students, we are trying to lend our comment on it. This is right, this is wrong, it could have been like this, it could have been like that. But once you become a lawyer, is it possible every day? No, ఆ జడ్జిమెంట్ అసలు తప్పు సార్, అట్లా ఉండకూడదు, నేనైతే నా ఇట్లా ఇస్తానంటే ఇంటికి వెళ్ళి ఇచ్చుకో, ఇక్కడ కాదని చెప్తారు. What is there in the judgment is the law. You like it or not, you have to follow it. So ఇక్కడ మనం చదివిన ఫోరెన్సిక్స్, అక్కడ మనం చదవవలసిన అప్లై చేయవలసిన ఫోరెన్సిక్స్, దే ఆర్ స్లైట్లీ డిఫరెంట్. And then two things you will find. All wonderful books written elsewhere in the world, the authors in their forewords would write, they were all teachers. We gained so much which enabled us to write these books only because of our interaction with our students. So before you complete your degrees here, your teachers must feel that they are so much benefited by interacting with you. It is that interaction which is very valuable, very precious. ఇంట్లో అనవసరంగా ఆర్గ్యూ చేస్తే కేకలేస్తారు, మార్కెట్లో అనవసరంగా ఆర్గ్యూ చేస్తే కేకలేస్తారు, కోర్టులో సరిగ్గా ఆర్గ్యూ చేస్తే తప్పట్లు కొట్టి డబ్బులు ఇస్తారు. సో ఎక్కడ ఆర్గ్యూ చేయాలి, ఎక్కడ ఆర్గ్యూ చేయకూడదు, ఏది ఆర్గ్యూ చేయాలి, ఎవరితో ఆర్గ్యూ చేయాలి అన్నవి ఏ విధంగా ఉంటాయి, ఎక్కడ రాసి ఉంటాయి, అవి ఎక్కడ రాసి ఉండవు కదా. Somebody was writing, Justice Narayan Kurup, he writes that people have said that they dissected the body, did not find the God. The other man was telling, used the telescope, scanned the entire sky, did not find the God. Did not find the soul within the body, did not find God in the clouds. ఆ డిసెక్ట్ చేసిన బాడీలో, అటాప్సీ చేసిన బాడీలో సోల్ కనపడలేదు అని అంటే మనిషికి ఆత్మ లేనట్లేనా, మనస్సు లేనట్లేనా? సో దెర్ ఈస్ అనదర్ డైమెన్షన్ టు లైఫ్. సో దట్స్ వాట్ అంబేద్కర్ లా కాలేజ్ స్టాండ్స్ ఫర్, దట్ కంపాషన్, హ్యూమనిజం. While you read black and white, learn the hard way all the important principles and notions of law and justice. All of them are finally, they must culminate in manufacturing, in delivering a wonderful citizen, useful for himself and useful for the entire humanity. And I profusely thank Dr. Tippareddy for still keeping me in his memory and in his book and calling me here. And I'm glad that I'm here. Thank you very much.
Thank you, sir. Thank you for your insightful words. I would like to extend my sincere gratitude on behalf of the seminar committee of this today national seminar and also on behalf of the entire faculty members, Dr. Ambedkar Global Law Institute, Tirupati. Now, I would like to request Honorable Chairman, sir, and other dignitaries to felicitate the chief guest of today's valedictory session, Dr. V.R.K. Krupasagar Garu. Sir, please. Let us give a huge round of applause. Thank you, sir. Thank you for spending your valuable time with us. Our honorable chief guest is leaving, so let us again extend our gratitude with huge round of applause, please. Thank you, sir. Thank you so much.
పిలవమని చెప్పింది లాస్ట్ బట్ నాట్ లీస్ట్ అని చెప్పండి పిలవండి పేపర్
Where is he? With the permission of the chairman sir and also the other dignitaries, there is only one participant left out. Not to discourage the participant, this paper presenter, a special request is from the dignitaries. 5 minutes, only 3 minutes you have to complete. His name is Surya. Law and social changes topic. I request the Surya to present his paper.
அனைவருக்கும் வணக்கம். There are lots of multilingual peoples mixed here, so I'll go through English. It will be more convenient and easier to understand for each and everyone. Warm welcome to the honorable guests, students and lecturers here. Let's get into the topic. Today I am going to talk about law and social change in India. It defined as constitutional vision, judicial activism and contemporary challenges. Before I get into the topic, I will introduce myself. I am Surya, studying BA LLB Honors, studying first year at Dr. Ambedkar Global Law Institute, Tirupati. Exploring how Indian courts and legislatures are reshaping society in the 21st century. Abstract is, law in India has always been involved not merely as an instrument of control. By combining doctrinal and sociological method, the method of paper argues that law has created important new rights. It includes that law can be an effective engine of social change only when supported by the accessible institutions. The objectives are, the paper pursues 5 irrelated objectives to explain the constitutional design for social transformation, to identify and analyze major legal inventions. In key sectors, there are general justice, caste and reservation, children's rights, LGBTQ rights, and emerging domains. The analysis of constitutional foundation and environmental rights, gender justice and political empowerment, caste atrocities and reservation, children's right and POCSO Act, LGBTQ rights, and privacy and dignity. The conclusion is, the Indian experience shows that law can be both a driver and a product of social change. The conclusion therefore argues that law and social change only then can law fulfill the political as a genuine engine. Inclusive and sustainable social change. It's my 4th day in this college and it's my first day. So thank you for having me here. So special thanks to Vinisha Srinidhi ma'am for supporting me. Thank you, sir. Thank you all.
Thank you very much, Surya, because not to disappoint the last participant, because we have given 166 participants, they presented the papers, in that is the 167th one. So that is why we have given the opportunity. Now, as per this valedictory session, I request Professor Dr. Vijay Kumar Behera, Principal Garu, to address the welcome address.
Thank you, sir. for giving me this opportunity. Good evening. Andarki namaskaram. Vanakkam to all. ଆଉ କିଛି କିଛି ଓଡ଼ିଆ ଭାଇ ଭଉଣୀମାନେ ଅଛନ୍ତି ସେମାନଙ୍କୁ ମଧ୍ୟ ନମସ୍କାର. Thank you. Always keep smiling so that we'll move forward happily. Honorable President Ma'am, Honorable Chairman Sir, our most revered Pullareddy Sir, and the special invitees, Dr. A. Ramireddy Sir, Ramakrishna Sir, esteemed participants, esteemed colleagues, invitees, distinguished guests, representative from media, both electronic and print media, and my dear far-sighted legal luminaries. I deem it an honor and privilege to participate in these valedictory sessions. I know how to express the thanks to each and everyone whose participations and involvement, due to their participations and involvement, today successfully, I think, today we successfully completed 2 days national seminar. All students, I have already shared these things in different occasions. And I would like to share these things in August gathering that our Honorable Chairman Sir is having a golden heart. A great social philanthropist. When we decided we will conduct a national seminar. And my colleagues, they came to me, they expressed their desire. Sir, why not we are going to conduct, let us conduct one national seminar. Immediately with their plan, along with them, we went to meet Chairman Sir. So Chairman Sir wholeheartedly said, yes, go ahead. When you are going to conduct, tell me the date. Don't think this, that, you go ahead. From that day onwards, we are today here. And it was the brainchild of the Honorable President Ma'am, Honorable Chairman Sir. I'll tell you, since the day one onwards, if I will not share a few words about our Honorable President Ma'am, everybody should know. She is the guiding force. She is the embodiment of love and inspiration for all of us. Nobody will deny that. Nobody will deny that. She is a guiding force. She is a source of inspirations. Whenever Honorable President Ma'am will visit the college, she will use to guide each and every, even students, even faculty members, even to me. For what? For the benefit of their individual benefit, how they will excel in their life, how they will successfully develop in their life, and for the growth of these institutions. Nobody will deny that. It's my candid opinion and pragmatic approach. So much obliged, President Ma'am, for your support and guidance. There is a famous saying that every successful man, there is a hand of a woman. And if our chairman sir is today this level, only for President ma'am. Only for President ma'am. Only for President ma'am. In addition to that, I will tell one thing. In addition to that, if today we are here, now the last part of this seminar, another two young and energetic mind, two sharp brains are there who are always watching what is going on and where it is, where is the lacuna, where is the loopholes, where we are failed in our duty. I am frankly telling. There is nothing to hide this one. And they are none other than Honorable President Ma'am, Gayatri Ma'am, and our young and energetic Prasastha Ma'am. Two sharp brains, two young and energetic brains are there. Always, they are also working as a guiding force. They will call each and every moment, go there and attend that work. So, why I am telling this? We are an employee. From outside, they will say you are an employee. But here, inside this college, we are living as a family members. Dr. Ambedkar Global Law Institute family. No discriminations. No discriminations. We are sharing our love and affection towards each other. That is our credit. And from where we got Honorable President Ma'am. You help each other. If you want to succeed in your life, ready to extend your helping to each other, then only a day will come in your life, you can succeed. There are so many things which we are facing daily in our daily life in college, but coming to this seminar, this seminar is not another seminar, but is a celebrations of intellectual. Celebrations. All the intellectuals, those who are a galaxy of intellectuals, those who are on the dais and of the dais. Of the dais. So of the dais, they are here. They came here to share their ideas, thoughts. They conducted a research on the topic and shared their ideas. That's why. So, and also with this, Honorable Chairman Sir already instructed, get ready for next program. It is not the last. Started. It just started. So move forward with full confidence and engage all the faculty members, all the students for these academic activities. And in this regard, I will fail in my duty if I will not say a few words about my students. Those who are tirelessly, they are ready, they helped us, extended their help for the successful of this program. With this, let me stop here for today. Thank you, all the participants. Kindly keep in touch for the future program. Thank you all for giving me this wonderful opportunity. Jai Hind, Namaskar.
Thank you, sir. Thank you for your valuable words. Now, I would like to call Professor Dr. Samaya, sir, to give the rapporteur's report.
Respected Honorable Dr. V.R.K. Krupasagar Garu, a retired judge, High Court of Andhra Pradesh. Respected Dr. Alluri Ramareddy Garu, Advocate, Member of Bar Council of India, Executive Vice Chairman, Bar Council of India Trust. Respected Professor S.V. Pullareddy Garu, SK University Anantapur, and Professor Ramakrishna Garu from Goa, and respected Dr. R. Tippareddy Garu, Chairman, Dr. Ambedkar Law Institute, Tirupati. Respected Dr. Aduri Sharadamma Garu, Founder President, Ms. R. Lakshmi Prashasta Garu, Secretary, and Dr. R. Lakshmi Gayatri Garu, Vice President of Dragli, and respected Professor R. Vijay Kumar Behra Garu, Principal, respected Professor Dr. Ashwini Garu, Convener, Professor Dr. Srimati D, Co-Convener, Sri G. Dheeraj Srinivas Garu, Co-Convener, and all other esteemed members. And also respected chairpersons, co-chairpersons from various universities, academicians, faculty members, teachers, research scholars, and my dear students from various colleges and also from Dragli. Good afternoon, all of you. Now, the 2 days, the program you are witnessing here, Dr. Ambedkar Global Law Institute, Tirupati, has conducted the first 2-day national seminar on the topic Navigating the Future of Law, Innovation, Ethics and Excellence on 13th and 14th December 2025. Through hybrid mode for sharing knowledge, ideas and perspectives on 16 sub-themes. That sub-themes are law and social change, environmental law and sustainability, the impact of technology on marriage and intimate relationships, cyber security and data protection, innovative access to justice initiatives, and the future of legal education and legal profession, pro bono and social responsibility, professional ethics and accountability, restorative justice, a shift in judicial approach, new criminal law, a justice-oriented approach, bail reforms and decriminalization, artificial intelligence and the future of human rights and social justice, ethics and use of artificial intelligence in legal education, artificial intelligence and intellectual property rights, the risks of artificial intelligence, hallucinations and the lawyer's duty to verify information, and the last, technology and future of maritime law. This program of this 2-day national seminar grandly inaugurated by Dr. in this Ambedkar Global Law Institute by lighting the lamp at 10 o'clock on 13th December 2025 by the dignitaries. Now, in this seminar, the Honorable Chief Guest of Professor Ramabhatla Venkatarao Garu, Vice Chancellor, India International University of Legal Education and Research, Goa, along with Honorable Justice Dr. V.R.K. Krupasagar Garu, Retired Judge, High Court of Andhra Pradesh, Professor Dr. Tata Narsingha Rao Garu, Vice Chancellor, SV University, Tirupati, and Professor D. Surya Prakash Rao Garu, Vice Chancellor, DSNL University, Visakhapatnam, along with other dignitaries, released the souvenir in the inaugural session consisting of 202 abstracts. So this is a high figure that the 202 abstracts were published in the souvenir. Finally, the Honorable Chief Justice, Professor Dr. Ramabhatla Venkatarao Garu, Vice Chancellor, India International University of Legal Education and Research, Goa, has delivered a wonderful, insightful and thought-provoking keynote address to the audience. Regarding the technical sessions, as I said, the 16 sub-themes were divided into 6 technical sessions for presentation of the papers through online as well as in person simultaneously on 13th as well as 14th respectively. Total 166 papers were presented by faculty members, research scholars and also students from various universities during these 2 days. And here there are 68 online presentations were made and 98 offline presentations, that is in-person presentations, were made in these 2 days, and total 166 papers were presented. For this task, we have that the eminent chairpersons and also co-chairpersons, eminent judges, professors like Honorable Justice Dama Sheshabdi Naidu Garu, Honorable Justice V.R.K. Krupasagar Garu, Professor D. Surya Prakash Rao Garu, Professor S. Pullareddy Garu, Professor Ramakrishna Garu, Professor Chola Mudimannan Garu, Professor MSV Srinivas Garu, Professor Meena Ketan Sahu Garu, Professor Madhuri Garu, Professor Sita Kumari Garu, Professor P.V. Pankaja Garu, Professor Balaji Garu, Professor Dilshad Garu, Professor Shaktivel Garu, Professor Someshwar Rao Garu from various universities from Delhi, Andhra Pradesh, Chennai, Telangana, and also from Orissa and other parts of the India, chaired the technical sessions and delivered keynote address in each technical session. Particularly, Honorable Justice Dama Sheshabdi Naidu, Senior Advocate, has delivered a wonderful keynote address in the morning session today you have witnessed. Regarding the technical performance, all technical and technical resources were readily available and conducted the sessions smoothly and successfully in these 2 days. The participants, we have supplied the feedback to the participants, and these participants' feedback was very positive and supportive in all sessions, and they felt very happy regarding infrastructure and refreshments which we provided in these 2 days. Finally, this seminar has successfully achieved its objectives by successful presentations and sharing research knowledge under various sub-themes. It provided valuable insights into the seminar topic, navigating the future of law, innovation, ethics and excellence, and encouraged participants for further recommended studies in the relevant sub-themes. In conclusion, this seminar has reaffirmed the law must remain dynamic, inclusive, and forward-looking by embracing innovation ethically while safeguarding justice. We can ensure that legal systems continue to serve as an instruments of positive social change and continuing excellence in our life. The participants expressed their gratitude and expectation to meet in the next seminar. Hence, the team of the seminar committee, subcommittees, as well as the teaching staff and the entire team of volunteers who are assisted in the seminar to conduct the next seminar as an international seminar. Hence, Dragli proposes to conduct international seminar in the year 2026 with the cooperation of all dignitaries, vice chancellors, judges, and the honorable judges, and also the professors and the academicians from various universities in India, so that our chairman or Tippareddy Garu's one of the dream will be fulfilled in the year 2026. Thank you very much to all the dignitaries, teaching faculties, research scholars, students and media, press and non-teaching staff for cooperating for conducting of this seminar successfully in these 2 days. Thank you one and all.
Thank you, sir. Now, I would like to invite Professor Dr. Pullareddy Garu, former Registrar, Rayalaseema University, Kurnool, to share his experience and thoughts with us.
Good evening to you all. We are happy that we have come to the conclusion stage after a very meaningful intellectual exercise for the last 2 days. At the outset, let me congratulate the army of Dr. Tippareddy and Dr. Saradamma. The army includes the faculty members, who I understand might have spent lot many days and nights in preparing the theme and inviting the people from different colleges and universities for the presentation of the papers and arranging everything in an order and organizing this kind of mega seminar. I call it as a mega seminar because I have seen many seminars organized by the universities wherein I have not seen not more than 50 or 60 papers coming, but more than 200 papers have come, and it is a very huge exercise behind the curtains. So I cannot but congratulate and appreciate the teaching faculty under the command of the management. Without their support, it will not be possible. So the very helpful, cooperative, empathetic management that you have is a blessing. And most of the resource persons, when they were telling that we were the teachers in the beginning of our career, so the institution has provided a very good launching pad for many senior professors in the country. I wish that the present faculty also, although I don't wish that all of them should go, but because it is, many people will come, people may come and go, the institution survives. Like the river Thames, men may come and men may go, water will flow, and the river continues to flow. So that is not a problem. I am very happy to hear that this institution has provided such a wonderful launching pad for many professors. And most importantly, the student volunteers, the army, at least the army of volunteers, wherever we go, when we enter into the campus, 2 lines, when we go to the dining hall, when we come to the hall, so many people helping the guests and others. So I see a sea of humanity and hospitality here. I must congratulate and thank each and every one of the student volunteers teams. Coming to the seminar, and before coming to the seminar, I was a most conventional teacher for about 36 years. I rarely used chalkpiece and blackboard in my class. I just come and speak on the topic of the day and leave the hall. I never used any technology. I don't know how impactful my teaching is, but that was how I started my career, ended my career. Therefore, I came with a kind of hallucination, a bad kind of consequences that may emerge out of the emergence of artificial intelligence and all. I was thinking as to what will happen to my hard work for the last 35 years of learning, teaching and researching and all. We studied Baden-Hummer for jurisprudence, for judicial process, Julius Stone's law on legal reasoning, and introduction to the judicial process by Cardozo, Robert Cross Dr. President and all, what will happen to all these books and my learning for such a long period of time? I was thinking, will this become, all this become obliterated, or whether my learning becomes inadequate, what should I say, irrelevant after the emergence of artificial intelligence? I was also thinking, I had some questions about the future of very legal system itself, starting from the future of a law teacher, future of a law researcher, future of a law student, future of a lawyer, future of a client coming to the court, future of a judge and a prosecutor and all. I was thinking at the first instance whether for me as a human being, with fundamental rights, human rights, and right to privacy and all, whether the space for my human rights, more importantly, the space for my privacy, will it shrink or will it expand after the emergence of artificial intelligence? I was thinking whether the clients in this country, litigants in this country will get a qualitative justice after the emergence of, with the use of artificial intelligence, whether it will be whether legal system will be able to provide a better qualitative justice than what it was before its emergence. Because everything is what is after artificial intelligence and before artificial intelligence. Whether it will be more, whether my lawyer services will be more efficient, more meaningful after the artificial intelligence. Whether our judges will be able to use the artificial intelligence so as to render a speedy justice, meaningful justice, and justice which is more qualitative than what it was before. That was the only concern for us. After all, people come with some problems and solution is to be provided. And solution is to be provided with the help of, now, with the help of artificial intelligence, we have to find the facts, not only from the client now, but also from the digital media. So how it will help to find facts that will help the lawyer as well as the judges and prosecutors, how it will help to trace the law that is suitable to the fact situations, how it will help to analyze the law, how it helps to apply the law, how it helps to render justice. So everyone, every stakeholder in the legal system should be benefited. And ultimately, the justice is to be done to the people in cheap manner, in an efficient manner, in a timely manner. Because these are the difficulties in our legal system now. There is a lot of delay in rendering justice. The quality is shrinking. Quality of justice is shrinking. Quality of legal services are shrinking. Therefore, if the artificial intelligence helps in solving the problems in the legal system, the crisis that is existing in the legal system, we're all thankful. But there are difficulties also. Let me conclude by saying that artificial intelligence is like a ruling horse. Not ruling horse. Unruly horse. It is an unruly horse. Once you astride on it, you don't know where it will take. So it all depends upon the rider who controls, regulates, and then make the best use of this unruly horse. Tame it and use it for the benefit and balance it, because we cannot avoid it. At this stage, no technological advancement can be avoided. We have to accept it, use it with our immunity, with our intelligence, and humanity and help the society, help ourselves in the legal system. Thank you for giving me this opportunity. Thank you all.
Thank you, sir. Thank you for sharing your experience with us. Now, I would like to invite Professor Dr. Ramakrishna Garu to share his experience with us.
Very good evening to one and all the dignitaries on the dais and off the dais. It gives me an immense pleasure to be here, maybe for three reasons. The first reason is I'm standing here in front of my teacher, Dr. Pullareddy sir, and talking to you, delivering a lecture. The second one is again, I'm speaking in front of you where Professor Tippareddy sir is here. He is my former boss, who is also a mentor for me. And the third reason is, this is like a coming to home. I worked here from 1994 to 96. My formative years are here. Learned a lot of leadership qualities from Tippareddy sir and learned a lot of humanity from Pullareddy sir. And today, if I say any little success that I achieved in my life, all that I owe to my teachers and my mentors. And I hope it would be the same for the rest of the people who are all sitting behind. So instead of talking about this seminar, because many people spoke about it, I want to speak on three things. The stakeholders of this entire seminar. The first, the college. Second, the teachers. The third, the students. Now, the students are actually the first. Okay? If there are no students, there is no need for teachers. If there are no teachers, there is no college. Okay? So the college is there, teachers are there because the students are there. So my first thoughts are to the students. Now you have joined in this college. You are in different years. I was just interacting with some of the students. I heard that your classes will get over around 2 o'clock. Is that right? Or 4 o'clock? And what are you doing in the rest of the evening? So please understand, when you join in the law college for 5 years or 3 years, your life as a lawyer has already started and it began and start running. So therefore, when you are in the law college, it doesn't matter whether you got a gold medal, whether you have first class, how many certificates you have acquired, it doesn't matter. What matters is what did you learn, how much you learned, whether you could able to apply what you learned in the law college in the legal profession. So therefore, think today, if you are not already decided, what are you going to do after you complete your LLB? Am I going to be a lawyer? Am I going to be a criminal lawyer? Am I going to do an LLM and become teacher? Am I going to corporate practice? What am I going to do? Think about it. Discuss with your friends, discuss with your teachers, discuss with your family, but decide fast. And then start molding your career into that. That's very important, which we never did. Now, many legal luminaries, including the judges, would come to your college and say, we never attended the class, but we are today at this level. True. I did my LLB in 1987, joined, finished in 1990. It was true that time. But all my colleagues who did not attend the class, never sat, never learned, carried 5 years the files of the seniors, started learning. I don't think that is what the legal profession expecting today. As a law student, you need to understand today law colleges are not law colleges, they are lawyer colleges. When I studied law, it is a law college. means I study some law, remaining techniques I will learn from the profession. Today it is not. At least 80% of the skills that a lawyer required to practice in profession need to learn in the law college. Learn how to research, learn how to extract cases, learn how to read cases. Tomorrow you go to a lawyer's office and your lawyer asks any case. Those days we have to run for the books. Today no, a click away. But you should know how to research, how to search, what commands you have to give, whether you are using LexisNexis, whether you are using Manopatra, Westlaw, any platform. How quickly you are able to get it. That's very important. So the skills that a lawyer require, your communication skills. I am very happy that the student came and said, it is my first day and I am making some presentation. That's the courage. You learn, communicate. The most of the skills that a lawyer required could be acquired in the college. So when a teacher tells you make a presentation, seminar presentation, don't go to ChatGPT, Google, use it properly and come and start reading. You are reading for the purpose of the marks. But I remember when we were doing LLM, we went to the polarizer and said, sir, after doing LLM, I want to become a teacher. So give us one class, we want to come and teach. Because those days we didn't have all these moot courts, client counseling competitions, ADR competitions, nothing was there. We just sit in the class, teachers will come, give information, remember, by heart, write exam, pass somehow, and go to court. It's a complete disappointment because what we learn, what we are supposed to do, there is a huge gap. So the law colleges are trying to build those gaps today. Now, turning to the teachers. Now, one thing that I always understood as a teacher, our performance in the classroom are threefold. The pedagogical 3D intervention I used to call it. One, we teach law in text. That's what every law college, every teacher does is teach the text to you. What contract act is, what constitution says. But that doesn't sufficient to make the present lawyers. The second dimension of law teaching is teaching in context. So if I teach freedom of speech, I should also teach the freedom of speech in a context. In a case of where some social media post go viral, what happens whether I have a speech or not? A movie is banned, I should talk about it. When somebody teaching contract today should necessarily talk about the meltdown of Indigo, the contract, that I purchased a ticket, now you are not able to provide me the travel. So what are my recourse? So that's in context. The third and the most important thing is that law in action. How in reality the law works. That's where the clinical teaching or experiential teaching is required for us. So if I teach a person a contract but they don't know how the contracts are entered, I just give you a simple example. All teachers, of course I teach contract, I generally say A offered B 20 lakhs and B accepted. It's a contract. In reality that doesn't happen, right? There will be at least 10 to 15 days you would be back and forth negotiating to each other. So offer, counter offers, so many things. So if you don't understand how the law works in action, that's very important. So as the law teachers, and also today I had heard several presentations. Now my request for all of you is, of course you made a good attempt. But remember, either you are a student or a teacher, the only mantra is either perform or perish. Today, situation is like that. When I became a teacher, my first class is a disaster. I studied my law in constitutional law for 2 years, my specialization. Same subject was given, read whole night, went to the class. In 10 minutes, my class is over. I am blank. I just walked out because I didn't have any experience of public speaking before going into the college. I went straight away to my principal and said, sir, I may not be suitable to teach. He said, don't worry, it happens and all. But today, if you become a teacher and come to me and I am your principal, if you say that, I will not be so kind. I will say, please resign and get out. Perform and perish. Because things have changed. You cannot expect somebody would wait so long. So that's why as a student, as a teacher, as a lawyer, we need to update ourselves. There is nothing that we can do it. So therefore, when you are writing, for example, for the teachers, there is a sword hanging on our head. If you don't publish so many, no promotion next. API score, academic performance indicators. So many publications, so many points, etc. So we are under the tremendous pressure to perform, in addition to teach. But please remember, when we are writing articles, simple questions. Why are we writing? How we are writing? To whom we are writing? These are the questions that we need to ask. Are we adding to the information? Are we adding to the literature? Are we creating something new? So that is what expected. Now coming to the law colleges, the most important aspect. Now I am expecting, of course I have seen Ambedkar Law College that time. It was called as Ambedkar Law College, it was in RS Gardens. How leaps and bounds it has improved. And the name of the Ambedkar aptly put, I actually asked sir, why did you put Ambedkar as a name? Because usually when private colleges, they're starting, either they put a very fancy name or they put their family name or somebody's name. So sir said that Ambedkar's name reminds constantly about what he stands for. So he said, Constitution is as good as its people. The bad Constitution gives good result if people are good. A good Constitution will give you a bad result if the people are bad. Okay. So therefore, the colleges now, we are expecting the colleges not become a factories of lawyers, but to transform this legal education into a justice education. What I mean by justice education is that the law colleges should inculcate the spirit of constitutional values. If you read from 2018, the Supreme Court has started with a new doctrine of what we call the constitutional morality. And time and again, majority of the judges are talking about constitutional morality to prevail over your social morality. So that means your social values, your religious values, your personal values doesn't matter once you are under the democratic country where run by a constitution. So if you look at democracy as a religion, like a Hindu religion, democracy is also a religion. So its Bhagavad Gita is the constitution. So therefore, as a constitutionalist, teachers, students, and the lawyers, judges, and the administrators are bound by that constitutional morality. Okay. So in the last, because sir has started with the AI, and we have heard so many things about AIs. Now, I always believe that machine is supposed to reduce our burden. That's why when cycle is invented, instead of walking, we preferred cycle. Then the bike came, then we have flight, etc. It doesn't mean that we should not walk, right? We still walk. So AI becomes your digital secretary. AI is not your master. AI is your digital secretary or your digital servant. And AI is dumb if you are dumb. You ask dumb question, it will give you dumb answer. If you ask beautiful question, it will give you beautiful answer. That's why I believe Socrates would have been the best user of AI today if he is alive. Because he used to ask questions. He never taught anybody. He always says nothing can be taught, but everything can be learned. So he used to ask right questions. Therefore, I am not discouraging you to use AI. As sir has already said, you cannot uninvent AI today. You cannot say, I will not use phone. Impossible. But important thing is how do we use? So learn AI, master AI, use proper prompts, cross-check. I think the last presentation that one of your student has beautifully presented about AI. How do we rely on AI is, actually speaking, people like me are more beneficial by AI because we already have some idea about what is right, what is wrong. So if the AI gives me information, I'm able to understand whether it is correct or not. That is where the students has to be little more careful, because when AI gives you information, it looks authentic, please verify. So therefore, AI is there here. If you don't use, you will perish. Okay? I have seen that everybody thinks that the Gen Z is the most techno-savvy, but they are the worst. That's my experience. You are very good with reels and WhatsApp messages, Instagrams. But technology is not that. It is much more. So use AI to reduce your work. I remember when we were doing LLM dissertation, on one topic I want to know whether there are any number of articles. We used to go to the library and we used to pull down hundreds of books. And we used to check on the first page, the second page, there used to be a table of contents. And then the librarian used to complain to the law department that the law students are coming and putting hundreds of books down and he has to rearrange it. He has complained that time. Of course, the department stood with us. But today you don't require that. If you know correct prompts, 5 minutes you will get 200 articles. But you should know what you are doing. So this is what I tell you, there is no supplement for your hard work and sincerity and honesty. And please don't believe that not attending class is cool. Not attending class, of course we know, as a young student I also did that. Going against the establishment, going against the rule is something cool. But in reality what will happen is, after 5 years you turn back, you wasted 5 years. So start doing internship, go to the local lawyer's office, sit there, learn, join in legal aids clinics, do participate all the activities, think why they are asking you to do it, and use maximum. That is what. And today you don't require actually a teacher to teach you to pass examination. Remember, to pass examination you can read by heart and pass, but that's no use. That is okay for BA, BCom, BSc, where you are going to do a clerical job, but not for as a lawyer. So learn from the law college, learn from your teachers, learn from the net. That is what my message. And finally, sir, thank you very much for giving this opportunity. And it's a really wonderful experience. As Polarity sir said, I will put in a very mild way. You are trying to kill us by your generosity and your love and affection. And it is very overwhelming for us. Anywhere I go, somebody is asking, intruding into my privacy, where am I going? Please, thank you very much for your love and affection. Thank you very much.
Thank you, sir. Now, I would like to invite the special invitee of today's valedictory session, Dr. Aluri Ramireddy Garu, Member, Bar Council of India, Executive Vice Chairman, Bar Council of India Trust.
I am not a last speaker. Certificate also waiting for you. The students are by forcefully sitting because of the last Sunday. Since 2 days, your hard work. Whenever doors open, you are ready to go. They are waiting for you. Now, I am not a professor. I don't want to speak lengthy. Just I will need to try to appreciate some of the program since 2 days. My friend, Chairman of the college, R. Pupad Garu, Founder, President of the college, Dr. Saradam Garu, Vice President, Gayatri Prasastha, Secretary, Lakshmi Prasastha, my friend, Professor Pulla Reddy, and my friend, Professor Ramakrishna, and Principal, Professor Lavanya, Ashwini Madam, and my advocate friends, other faculties of this college, and various professors and research scholars of throughout the country. And my dear students, vanakkam to everybody and good evening. Since today's a wonderful program, yesterday opened by Professor R. Venkatrao, Vice Chancellor of Goa International Law University, run by Bar Council of India. And another Vice Chancellor, Surya Prakash Rao, Sanjeeva National Law University, Visakhapatnam. I am the Executive Committee of the university, and our Vice Chancellors, and Justice Kripasagar, and Justice today's morning, Sheshadri Naidu, and all other luminaries. I am very happy to say the program. Just I read the 2 minutes because other programs there were waiting. Already time was too late. It is a matter of great privilege to me to offer the valedictory address to this today national seminar on navigation, the future of law, innovation, ethics and excellence, standing here in the presence such eminent personalities of like judges, professors, and truly an honor. As a member of the Bar Council of India, I personally appreciate the efforts of this college and the dedication of its patron, Sri Tippareddy Garu, and his family. As a friend, Sri Tippareddy, for over 50 years of my long journey friendship, I feel immensely happy and proud witness to success of this program. This is the milestone creating a history, the first of its kind, entire Rayalaseema, the first, the best 2 states of Telugu states organized by the private law college. The seminars never conduct this type of college in private government colleges. I have seen since 38 years, only private college can conduct this type of seminar. I appreciate the team of Tippareddy and like the army of Tippareddy. I know how deeply he is committed to improving legal education and how much personal interest he takes in every aspect of this college. His sincere involvement is clearly reflected in a smooth and meaningful way. The seminar has been conducted. He stood as an inspiration of me also. Because our college, women faculty, 3 members and students are participating here and participating in this conference, and I appreciate all the participants also. I must wholeheartedly appreciate the management, principal, IQAC team, faculty members, and student volunteers for your meticulous planning, from the inviting such distinguished guests to organizing hybrid mode sessions. Every aspect has been handled with discipline, dedication. Even of this level required teamwork, patience, and commitment, and all of you have displayed the beautiful but wonderful. The coming to theme, this conference touched 3 important pillars: innovation, ethics, and excellence. In today, fast-changing legal world with the technology, digital codes, AI, and the new social legal challenges, innovation is no longer optional. Our system must adapt, transform, and move forward. But innovation without ethics can never sustain. The dignity of the legal profession comes from moral values, professional integrity, and respect for justice. This seminar rightly reminded all of us that ethics is the foundation on which all innovation must stand. And finally, excellence. As a hero, Mahesh Babu said, in a film, is not a destination, it is just a journey. Excellence is a teaching and research and the practice and the service to the society. I am very happy that the sessions over the past 2 days have brought meaningful insights on these aspects, especially with the guidance of our honorable judges and honorable professors and vice chancellors. Vice Chancellor and legal experts and legal researchers. I am sure that the student and young advocates here will carry this message into their future careers. To the students, I want to say your future in law will be bright when you balance innovation with ethics and ambition with excellence. Use every learning opportunity this institution gives you. Before I conclude, I wish you to place once again my deep appreciation for the excellent team of organizers of the unit untiring efforts, dedication under the leadership of Sri Tippareddy Garu. His constant encouragement has made this institution place of quality and values. We are all fortunate to have a patron who treats legal education as a mission, not just as an activity. Thank you, Tippareddy, for inviting me and giving me this honor. My best wishes to the college for many more such meaningful academic activities. I wish you great time to all the students, teachers, various parts of the legal humanities, scholars and everybody, but Ambedkar Law College, thank you very much. Thank you once again. And in this institution, I am since starting, I am along with Tippareddy, and I have done the AIB Center in Tirupati. Up to 1990, there is no laws at AIB Center in Tirupati. Only Visakhapatnam is there. After I became a Bar Council of India member, I started this Tirupati as a AIB Center. Last year also, I recommended and started Vijayawada also AIB Center. So throughout South India, only 3 centers in Andhra Pradesh, and there is no state 3 centers of AIB centers. That is my teamwork of Bar Council of India, and I always ready to legal education. Thank you very much. Thank you once again for giving the opportunity.
Thank you, sir. At this moment, I would also like to recall that the beginning of this national seminar was in the gracious presence of the Honorable Special Invitee, Dr. Aluri Ramireddy Garu, who launched the brochure of this national seminar. Thank you, sir. And we are also very happy to have you in the valedictory session as well. Now, I would like to call Honorable Chairman, Dr. Ambedkar Global Law Institute, Tirupati, Dr. R. Tippareddy Garu, to address the students.
Good evening to all of you who are on the dais and off the dais. And my dear students, almost this seminar is coming to an end. And I hope and trust the paper presenters have actively participated and presented their papers. Thereby, our students also enrich the knowledge which the resource persons and the papers presenters have given. And you know, this topic for seminar, Navigating the Future of Law, Innovation, Ethics and Excellence. We are trying and researching a new law basing on the development of the technology like artificial intelligence and digital technology. Before that, we have to examine even the present law, to what extent
it is satisfying the needs of the people. And even the legislative authorities who are considered to be the top section of the society, who are passing the legislations, are not following the law. Even though the Constitution says. That also should be examined by the research scholars under the guidance of the resource persons. The topmost professors are there in our country. Even as a budding lawyer, Mr. Ramkrishna worked as a law teacher in our institute, but now has become a senior-most professor. And even Professor Polarity has become one of the topmost professors in this country. And Madam Pankaja, Madam Sita Kumari, and Professor Syed Basoor, those who have worked in our institution have become topmost professors in this country. And there are many more like. And I hope and trust even our the budding faculty members who have joined, who are working for the last so many years. And very particularly also joined just over 10 months, 1 year back also. They have now the best future. Because in this legal profession, there is no end, only sky is the end. As much as you acquire knowledge, you can grow. There is no shortcut in this legal profession or in this legal education. As Justice Felicitation Naidu was referring, if I want to work for 5 hours per day, I have to spend 15 years or 13 years, he was referring in the morning. So he thought he wanted to work for 15 years and reach the top level within 3 years or 5 years, as he said in the morning. So he is a guiding master, a very good speaker among the judges in this country. Only by his hard working he has come up. There is no godfather, either from his village or from his family or from his own relatives. He has come up to that level only by his sheer hard work. He was, after all, a small bank employee in Andhra Bank. In the S University campus itself, he was working and he was unknown to anyone, even to the university staff members. The moment when he has completed his law graduation in our university and where he started legal profession, within 4 or 5 years, his name has come up. The moment when he has gone to High Court of Andhra Pradesh, the combined Andhra Pradesh, within 3 or 4 years, he was recognized by so many eminent senior advocates that, oh, there is one advocate by name Felicitation Naidu who has come from Tirupati and practicing the High Court. He is considered to be the future topmost advocate. That's what I heard from my friends who are practicing there. My own students are there. Hundreds and hundreds of students are practicing all over this state. And even when he worked in Kerala as a High Court judge, all my friends who are there in Kerala used to say that your state has sent the topmost judicial officer to our state. I feel proud of it. And that too he is from our university. I felt very happy of listening to my Gurujis also. The Gurujis also told me
that your person from Andhra Pradesh, Mr. Seshadri Naidu, is considered to be the excellent judicial officer, excellent judge of our Kerala High Court, they said. I felt very happy. So likewise, I wanted to see each and every one of you to reach the top level by hard work. One or two may get chance to become top lawyers, but the many people will become top lawyers only by sheer hard work. Read well. Read all the journals. Of course, use the latest technology also. There is no problem. See, the technology is created not by anyone. It is only by human agency. I can tell you. No need of fearing artificial intelligence or digital technology or any other technology. These are all created by human beings and with our minds only. You can only use that. You are not going to use anything out of it by using the latest technology, but you will save the time. Whatever intelligence is uploaded, like a computer, whatever information is uploaded to the computer, whenever you want, you can download a hard copy. Likewise, the entire technology which is being used now, even for our legal profession, is being created by the top intellectual advocates or professors. We need not worry and don't think that we are going to lose by using the technology. You will gain. I hope and trust. I hope and trust. But you can minimize the time, and within no time you can present an article, within no time you can prepare the case and present your arguments before the court. By development of technology, of course, during the Corona period also, the technology is being used. When we were discussing with our Professor Ramakrishna Garu, he was telling they face a lot of problem for teaching the students during Corona period. And they use the latest technology, somehow they could teach the students. Then immediately I too said that all my teachers also have uploaded these YouTube channels, created YouTube channels and sent to the students during Corona period, and they prepared well, they wrote the examinations well. So the development of technology is being used. There is no wrong in it. It is created by us. We need not worry at all. But my sincere appeal to the research scholars and to the students, read the journals well, because availability of material is very easy. And we used to sit in the library for hours together and collect the information with a lot of time consuming and by spending a lot of amounts. When I was writing my thesis in LLM, I spent nearly 3 months to sit at Trivandrum to collect the information regarding the legal protection of agrarian workers in Kerala state. But now, within 1 hour, you can get the entire information, the same information which I got nearly 35 years back. So it is a time saving. And my appeal to the research scholars, you kindly write some articles wherein the legislators are failed to follow the constitutional morality. Where is the constitutional morality? As in case of anti-defection laws. The MPs who are elected by us, the MLAs who are elected by us, are jumping like frogs from one well to another well. Is it not? Is it not? What action is being taken by the authorities? Though the power is vested on them, why the power is not exercised? Why the law is not used? That you have to question. Even the existing law is good. But of course, we should also strive for the new law, for solving the latest developments basing on ethics. You have to create an excellent law coupled with ethics. Then only the law can be accepted by the public. So my appeal to the senior, research scholars, I think all our resource persons who have come here from different parts of this country have also, I think, explained to all the paper presenters where they have gone wrong, how to write articles, what is the methodology which you have to follow. So kindly follow all these things and adopt all these things and come up with the best papers for the next national moot court national seminar which is going to be held in 2026. We are going to have it. And we are also trying now to go for Faculty Development Program, FDP, it is called FDP. Because we have lot of senior professors who worked here, and we have a lot of young and dynamic faculty members who are working now, and keeping in view of their developments and keeping in view of the availability of senior faculty in our hand, we want to go for Faculty Development Program also. In addition to that, so as to make our students as the best citizens or best lawyers in this country, we are going to hold either international or national moot court competitions either in March or April 2026 for the benefit of the students. And it is for the students to take this opportunity to prepare well, to read well, prepare well, and participate in all the competitions which are going to be conducted by the organizing committees of our college, because we have a lot of committees constituted for different activities. Moot court committee is there, seminar committee is there, legal aid committee is there, and the general committee is also there. Likewise, we have divided so many committees. So kindly use this opportunity, since you are studying for 5 years or 3 years. Utilize this time in a proper way and come up in your life. My Guruji and my teacher, when I was studying BSc, he said, if you work hard during your student days, you will enjoy in the rest of the life. If you enjoy during your student days, you will suffer in the rest of the life. This is what my Guruji taught to me when he was dissecting a frog when I was attending the practical painting class in BSc. So my dear students, kindly study well during the student days and enjoy in the rest of the life. Enjoy means enjoy with the academic spirit. Update your knowledge every day. If a teacher, law teacher or an advocate is not studying the up-to-date cases, he will become an old fellow, old lawyer. That is the reason why nowadays, see, there are so many senior lawyers, especially in the rural areas, who do not read the latest case laws, who do not read the latest textbooks. They will give only the old books and always they will open it and file the cases. I have seen. But nowadays, though these young lawyers, the budding lawyers, are far better than the senior advocates I have seen. So with this, my dear students, I have to say thanks to all the resource chief guests, Professor R. Venkatrao Garu and Honorable Justice Felicitation Garu and Sagar Garu and Honorable Vice Chancellor Tata Narasimha Rao Garu and Surya Prakash Rao Garu in absentia. And Alur Ramareddy Garu, the member Bar Council of India, and he is my cousin brother. And Dilshad Sheikh Madam Garu, Balaji Garu, the resource persons, and my dear friend S.V. Polarity Garu, Mr. Professor Sektivel, and Dr. Madam B.B. Pankaja Garu, and Dr. Sobeswara Garu, Madam Sita Kumari Garu, and Professor Dr. Meena Ketan Sahu, and Professor Dr. M.S.V. Srinivas, and Professor Dr. Ramakrishna Garu is actually an encyclopedia of, is what I could guess when I was discussing with him for about 15-20 minutes. He was having a lot of material, then immediately I thought I have to steal from him. And immediately he has sent to me also certain things. And Dr. Petkam Saridhar Madam Garu in his absentia, Indira Priyadarshini Madam, and Cholaraja Mudumandan Garu, and all other resource persons, and my dear research scholars, paper presenters, and my dear students, and the press. I am very happy that you have made this function as a great success. And my heartfelt thanks to each and every one of you. Thank you, and all. Thank you.
Thank you, sir. Before moving on, I would like to share one thought. Distinguished guests have taken the word army of Dr. Tippareddy. I would like to share that army is known for its discipline and army is known for its character. But whenever you see, if you understand the hierarchy in the army, if the commander is good, the entire platoon will be good, the entire battalion will be good. The discipline and the winning or the success of the battalion, either in the war or in any field, will be dependent upon the commander and his plan and his thoughts. Here also, since the day one of the thought, when we thought of organizing a national seminar, since day one we got all the support in every stage and at every point. We got the support of our Honorable Chairman, sir, and I would like to also share that we have 4 commanders here. One is Dr. R. Tippareddy, sir. Second is Founder President Shardama ma'am. The third is Vice President Gayatri ma'am. Fourth one is our Secretary Lakshmi Prasad ma'am. We have 4 commanders, and the entire success goes upon these 4 commanders of Dr. Ambedkar Global Law Institute. So thank you, sir. Thank you, everyone. And before now, I would like to call Dr. Samaya sir to take over the meeting.
Time is there. You ask to state me on the
Okay.
His friend Mr. Govardhan
Okay, I will tell.
Through his college secretary
Yes.
and principal.
Now there is a small announcement. These 2 days, Professor V. Srinivas Rao Garu, Srinivas, Principal of Mahatma Gandhi Law College. Now there is a small felicitation to our Chairman, sir, by the Chairman of Mahatma Gandhi Law College, Hyderabad, Gangula Govardhan Reddy Garu, Chairman. He, on behalf of him, the Principal and the Secretary of that Mahatma Gandhi Law College, they are felicitating our Chairman, sir, R. Tippareddy Garu. I request this
secretary and also the principal to facilitate our chairman, sir.
Respected dignitaries on the dais, my dear faculty members, research scholars, press and media. This is Dr. Srinivas, Principal, Mahatma Gandhi Law College from Hyderabad. It is my privilege to felicitate your Director Sir, Dr. R. Tippareddy Garu, on behalf of Mahatma Gandhi Law College, Hyderabad. Our relation with your college and with your Director Sir is since 30 years, 30. In the year 1990, our Mahatma Gandhi Law College, this Dr. Ambedkar Global Law Institute, and another Sri Vijayanagara Law College in Anantapur were established on the same day. Till that date onwards, till today, and in future also, all these three pillars in the state of Andhra Pradesh and Telangana will continue forever with your kind cooperation. Because of our flight timing, sorry for interruption in the middle of the proceedings. We were permitted to leave this premises to the airport for the flight at the 7 o'clock. Sorry for interruption in the middle. Thank you and all. We wish to organizers, dignitaries on the dais and off the dais, and let us meet very shortly in the year 2026 itself for any occasion, either for international or national seminar. Thank you one and all. Thank you.
Just would like to quickly take 30 seconds to congratulate the management and the entire team at Dr. Ambedkar Global Law Institute. This program has been a tremendous success, and a lot of credit goes to the months of planning that the entire team, including the students, faculty, has put in. Also want to say that the event was flawless, and someone would not believe if they are telling that they are organizing it for the first time. So kudos to everyone. You guys deserve a loud round of applause.
Thank you very much, Gangula Sai Prasad Reddy Garu, Secretary of the Mahatma Gandhi Law College, and Professor Srinivas Garu for felicitating our Chairman Sir R. Tippareddy Garu. Now, a small bit I forget to tell. The moment a seminar is going to be conducted in this college, our Chairman Sir constituted a committee in the name of Seminar Committee. Under the Seminar Committee, 12 subcommittees were constituted, and these 12 subcommittees worked under the able guidance of Gayatri Madam, Prashasta Madam, Sharadamma Madam, and also our Chairman Tippareddy Sir. Like anything, right from that day one of starting to today, and we made it grand success of this 2-day national seminar. Particularly, special thanks to Dr. Srimati Madam. She in charge of the online sessions. Without any interruption, the online sessions were successfully conducted. Thanks to all student volunteers, and they work like the soldiers in every subcommittee for completing this session. And thanks to the rapporteurs and also all faculty members of this college who tirelessly worked for the grand success of our 2-day national seminar. Thank you one and all, and thank you to all our chief guests who graced the occasion in these 2 days, and thanks to all students. Finally, to give an opportunity to the participants, opportunity is given to 3 participants to say few words, the experience, what you had in these 2 days. Those who wanted to tell, please raise your hand or come here so that we will give opportunity to you. Outsiders first. Outsider participants first. Paper presenters, yes. From where? Okay. Maunika. So one student by name Maunika from Anantapuram, and then we give an opportunity to share her experience in these 2 days.
Good evening to respected dignitaries on the dais and off the dais. Before I would like to give a review on the seminar, I would sincerely and gratitudely thanks to my chairman, sir, Ram Reddy, sir. Thank you, sir. Without you, we are nothing here, sir. Your leadership and discipline made us to come here. Not only sir is motivating us for the seminars, but also for the moot courts in the national level. And even today, 8 teams were selected for the Guntur moot court competition. Every single day, sir is motivating us very much to go to the next states or next districts to perform. And I would like to thank you, the respected faculty members, Soni Madam, Ramya Madam, and Teja Madam, for your dedication and motivation for us to come here. And I would like to represent, I should have to represent, this is not a praising word, but the lovely people standing here and there, I have seen them from 2 days, they are standing like this only. Thank you for all the students for your service. This is not a praising word, but you really did well. Maybe we would meet in our college also. We'll do the same. And also for the faculty members, madam, many of your names were I don't know, but you helped us a lot. Thank you for that. And coming to the seminar, I learned a lot. Thank you for every person for having your valuable time, because time is value, that I am not taking your time, but also taking the life from you. Your 5 minutes life was dedicated for me. Thank you for everyone for having your valuable time for me. Thank you. This is Monica from Sri Vijayanagara Law College.
Thank you, Monica, for sharing your experience in these 2 days. That's the next student, Faiza from SPMVV Tirupati.
Good afternoon, everyone. Myself, Faiza. I am from SPMVV University. This is my first experience from my first year. I never stepped on the dais, and after 4 years, I came out of this, and I am conquering from my stage fear, and this is my first experience. And coming to the organizing committee, 5 out of 5. I'm not going to prolong this. I'm going to say in 2 marks answer. Organizing committee, and also the teachers who encouraged us, and also abstract the procedure they kept for us, and everything was 5 out of 5 from my side. Thank you. Thank you, everyone.
Thank you, Faiza. And any other participant, paper presenter wants to share your experience, then it is welcome. Only one more participant we will give opportunity. From our college, we give. Are you coming? Yes. So Bhargavi from the Dragli want to share her experience.
Yes, this is Bhargavi from final year from Dragli itself. Actually, I'm having stage fear from 5th year also. I'm having stage fear. Actually, I'm a black belt in karate. When I came here now, it will be like I'm shivering. I'm dancing like anything. My legs are dancing. So, ma'am, everyone taught us some encouragement they given. Ashwini ma'am, Julie ma'am, Srimati ma'am, everyone. Thank you for giving this. Thank you so much.
Thank you very much. Now, the last program is meant for certificate presentation. Before that, we have one ambassador in our college, the young and dynamic principal. We have to take. Thanks to our principal,
for coordinating this seminar as a successful event in these 2 days. And give you a big hand to our principal, sir. Yeah, let me reply. They gave me all this credit, but there is a famous saying, nothing impossible to a willing heart. The sky is limit for those who dare to dreams. हमने सपना दिखा, आज करके दिखाया. हमने सपना दिखा और करके दिखाया. विश्वगुरु रविंद्रनाथ टैगोर ने लिखा था, सपना देखो प्रवाल द्वीपे तुलबो आमी बाड़ी. प्रवाल द्वीप में जाके घर बनाने के लिए सपना देखो, तुमको एक दिन मौका मिलेगा और वहां जाके तुम एक ना एक दिन घर बनाओगे. लेकिन you should have that dream in our mind, in our heart. And हमने सपना दिखा, उस सपना को साकार करने के लिए जो जो रास्ता था उस रास्ते से हमने गुजरा. और मैंने जैसे बोला, in the absence, 2-3 sharp brain. I will not say about our honorable chairman sir now. Honorable President ma'am, and 2 sharp brain, 2 young, energetic and dynamic brains, Prasasta madam and Gayatri ma'am. So it is not my credit. It is not my credit. I will like to give this credit to my esteemed colleagues who proved themselves and their efficiency, their talent, कि हम भी किसी से कम नहीं, हम भी किसी से कम नहीं. We are great. We Draglians are great. Top to bottom, we are great. I told you, we are living here as a family members. We all are great. So it is not my credit, but as a leader, I am not a leader. The great leader is with us, under whose able guidance we all are doing. In these connections, I like to say one from Mahabharata. I like to quote, which is you will find in regional Sarala Mahabharata, not in another Vyas Mahabharata. Do you know the Belal Sen? Who is Belal Sen? Son of Ghatotkacha, grandson of Bhima. So Lord Krishna wanted to, before Mahabharata, he wanted to, if he will enter this war, one day he will take, because he has that magical power of an arrow. With this, he will kill each and everyone, and one day he will take to complete this Mahabharata. Before that, Lord Krishna, do you know, he asked him, he went, I want a dana from you. I want dana. What type of dana? I want your sacrifice. What is that? Your head. Your head. And wholeheartedly, he asked, I am ready to sacrifice my head. What do you want to give? No, I will keep you here during this battlefield and you will observe what is going on. कहने का मतलब यह है, हम सब करते रहेंगे, हम सब करते रहे, आज इसी मुकाम पर पहुंच गए, लास्ट फेज ऑफ दिस सेमिनार. लेकिन उसका पीछे कुछ लोग जो हैं, मैंने जो बोला, I want to give this credit to my young and energetic soldiers, my young and energetic esteemed colleagues. It is not my credit, because we constituted under the able guidance of Honorable Chairman sir, we constituted different committee, we divided, and we told them, it is your duty. Take care of from day one onwards, you take care of all work. Whatever you want, you just come to us and inform us. We are ready to extend our helping hand. So it is the credit of all the members from top to bottom who were involved in these 2 days to successfully complete this national seminar. So it is not my credit. The credit is
goes to each and every members of Dr. Ambedkar Global Law Institute family. Thank you very much for giving me this opportunity. I feel proud as a principal of these institutions. Thank you. Jai Hind.
Thank you, Ambassador sir. Now this last program is meant for presentation of certificates. I request the seminar convener, Professor Dr. A. Ashwini, to call the name of the participants and then the certificates will be issued to them. As and when the name is called, you please come and take the certificate.
Ah. Mm. Ah. Yes. Much awaited moment has come for the presenters, and for convenience and easy distribution, I request all the presenters to be ready to collect your certificates from all the dignitaries on the dais. And may I request Srimati ma'am to join me? Yes, sure. We will call. கூப்பிடுங்க, நானும் கூப்பிடுறேன். சரி. Gopavarapu Vaishnavi, I request the dignitaries to hand over the certificates to the presenters. Kindly make quick move, ma. I request all the presenters to make a quick move to collect the certificates. Yuvasri, Vasanta Kavita, A. Raju,
నేను పిలుస్తాను, మీరు ఇచ్చేసేయండి. రెడ్డి పూర్ణిమ.
You stand there instead of student. You stand there.
Kumkum Harini, Mohan Rao, Kiran Kumar, Gangavarapu,
ఈ సర్టిఫికెట్లు ఇచ్చేసేయండి.
Kaushalya K, Guganeshwaran, కొంతమంది ఇవ్వచ్చు.
Guganeshwaran,
ఇటు నుంచి అంటే దిగమన్నా.
వసంత కవిత,
తీసుకో.
డి సోనియా, కుంకుమహరిణి, డి సోనియా, ఏ రేఖా అసిస్టెంట్ ప్రొఫెసర్, M. Sethu Ramachandran, A. Amrita, Kota Nahappa Sai Priya, Magdalene Raja, Samyukta Reddy, P. Swaruparani, Swagatika Panikargi, Sai Manasa,
Sony Jona.
Soni Jona, Sangavarappu Tejasri, Santoshi Kumari, Binnu Anil Pillai, where is he? M. Prabhakaran, Julie ma'am, K. Maunika,
Surendra, Assistant Professor Surendra.
Assistant Professor Surendra, E. M. Adira,
Ainapanurti Swati.
Swati, it's not yet. And Srimati Duraraj,
Vijayalakshmi Raju.
Vijayalakshmi Raju, Vinisha Srinidhi,
Two certificates.
T. Kirti Reddy, K. Haripriya,
Srikant Babu.
A. Srikant Babu, hey. Ganta Vasavi,
Ramesh Chandra Behra.
Ramesh Chandra Behra,
Reshmi.
Reshmi,
Chandini, yes.
Srishti Sandhani,
Venu Priyanka.
you, Reshmi ma'am.
Navyasri. K.
Venu Priyanka, Sujana, Navyasri,
Sujana.
Murli Mohan Raj, illa,
Devadanam.
M. Devendran illa,
Okay, ma.
Yashaswini,
Hanita.
Hanita,
Mariam Mannen. Megha Mariam.
Meha Mariam,
Kaveri Paka Manjaya.
Kaveri Paka Manjaya,
Two certificates for them only. Two certificates.
Kalpana,
उनका है उनका रम्या रम्या
Ramya,
रम्या रम्या okay
Prithviraj. With the permission of dignitaries, I want to receive my certificate with two gurus of my life on the stage. One is my academic guru and one is my professional guru. And my academic guru is Professor S.V. Pullareddy Garu, who was my guide for PhD. And my professional guru is Aluri Ram Reddy Garu, as I was working as assistant professor in his Vijayanagar College of Law. I want to receive certificate from both the gurus who were on the same stage. It was my happy moment actually. And my chairman sir always was very cooperative and encourage us to visit any seminars. If I call him, sir, I was having one seminar in Jaipur, I was having one seminar in Tirupati, he always says, yes, please go Ramya, please go Ramya. That was the encouragement he gives to us. And 2 days back I visited the seminar in Jaipur regarding tourism and heritage development through GIs. I just came before 2 days only. Again I visited this seminar. I was very happy and I thankful to all the organizing committee, especially Srimati Madam. I think we disturbed her since many days, asking many doubts and all. And the admin member Karthik, he received well, and Subramanian sir, and all other organizing team and students especially. Thank you so much. The next one is Prithviraj. Sudhagar Reddy.
Tilochan Lenka. K. Shravani. Tilochan Lenka.
Unnara?
Sabji.
Shravani. Kirtana Dasari. Nikita Reddy. Kameshwari. Samson Ravikumar. Calista. Mohammed Ismail. Rajeshwari. Kameshwari. Vishnu Vandana ma'am.
R. Latif. A. Ramachandra. Parvatalakshmi. Irendo okate. Parvatalakshmi K. Rahul. Rendo okate.
Parvatalakshmi and Rahul.
Hemlata R. Parvatalakshmi, yes.
Together.
Rahul ka set me
R. Hemalata.
Sharanya.
Sharanya.
Surya. Mohan.
R. Surya.
Mohan.
Billa Mohan Rao.
Nirupama Chandrasekhar.
Nirupama Chandrasekhar.
Mavia Sheikh.
Mavia Sheikh. Sheikh Fauzia Nasrat,
Sai Jyotika.
Gopanna Sai Jyotika,
Bharani. Prabhati Suar. आइए, प्रभाती सुआ. आप भी आइए.
Bharani,
प्रभाती सुआ.
Prabhati Shah,
शेषगिरी राव. शेषगिरी राव.
Sheshagiri Rao,
वेद संहिता.
Veda Samhita, Kunkuma Harini, Billy Anil Pillai, Chandrasekhar Mishra,
Shirin Abraham.
Sharon C. Abraham,
Professor Ambika.
M. Ambika, Don.
Committee.
Kartika, M. Shrikar,
Akshay Kumar sir.
Akshay Kumar,
Akshay Middleton.
Yes, please. Help.
I congratulate all the participants and for your better future and keep on researching. Thank you.
Now, there is a small felicitation to our resource persons. Felicitation to resource persons. First, Professor Dr. S.V. Pullareddy Garu. A small felicitation to Professor Dr. S.V. Pullareddy Garu. I request our chairman sir to felicitate Professor Dr. S.V. Pullareddy Garu as a token of gratitude on behalf of the Dragli. A small felicitation by the chairman of Dragli. Give a big hand to Professor Pullareddy Garu. A small felicitation to Professor Pullareddy Garu. Claps. A small memento from on behalf of this our Dragli. memento presentation by our chairman sir to Professor Pullareddy garu. Claps, claps, claps. Give a big hand to our Pullareddy sir. Because 2 days he is the first person who reached Tirupati 1 day before the seminar. Thank you very much, sir. And next, the other professor who all the way came from Delhi, Goa, that is Professor Dr. Ramakrishna Garu. Professor Dr. Ramakrishna Garu, small felicitation to Ramakrishna Garu. Sir is from VM Salgokar College of Law, Goa. He was busy in these 2 days as a resource person. Thank you very much for spending the time with us for these 2 days. Next, Dr. Cholaraja Mudimannan he acted as a chairperson, assistant professor, Campus Law Center, University of Delhi. I request Srimati Madam to come on to the dais. Convener Madam. Okay. So there is a small felicitation from the Dragli to our resource person, Dr. Cholaraja Mudimannan. Thank you, sir. There is small memento from the Dragli. Thank you, sir. Thank you very much for spending 2 days time with us and also as a chairperson and also co-chairperson in the technical sessions. Thank you, sir. Over, sir. And now the other last special thanks to Dr. A. Amrita, A. Rekha and also I. Vedavani on this is the special occasion committee. They arranged all these bouquets and mementos and all these things timely. They arranged without any problem. Now I request felicitation to Ram Reddy sir. Please come on to the dais. There is a small felicitation to our Ram Reddy sir by the chairman Dragli, by the chairman Dragli family. Felicitation to our honorable BCI member. Thank you very much for spending time with us for these 2 days. And also sir has inaugurated the brochure also. Special thanks to sir on behalf of this Dragli. K. Madhavi. K. Madhavi is there? Madhavi, yes. Our next vote of thanks, sir.
KL Bhargavi.
KL Bhargavi. Now the final vote of thanks by Reshmi or Assistant Professor. I request Madam Reshmi to present her vote of thanks.
I will take only 5 minutes. Okay, so please be patient.
मेरे बारे में ज्यादा बोल देगा.
Our revered founder, President Dr. Aduri Shardama, today's chief guest in absentia, our guiding light, the founder, chairman and director, Dr. Atippa Reddy sir, our principal, Dr. Vijay Kumar Behra, distinguished guest, distinguished resource person, seminar committee convener, Ashwini ma'am, vice president of our institution, Dr. R. Lakshmi Gayatri, secretary R. Lakshmi Prashasta ma'am, esteemed speakers, faculty members, and my dear students. As we reach the culmination of the national seminar on navigating the future of law, innovation, ethics, and excellence, it's my privilege, on behalf of Dr. Ambedkar Global Law Institute and the seminar committee, to propose this word of thanks and express my sincere gratitude to everyone who contributed to the resounding success of this event. We are truly honored by the presence and invaluable contributions of our distinguished chief guest, guest of honor, keynote speakers, and all the resource persons who shared their profound knowledge, insight, and expertise over the past 2 days. Your thought-provoking sessions were the cornerstone of our seminar. We extend our sincere thanks to all the delegates, academicians, legal practitioners, research scholars, students, paper presenters who came from various parts of the country to participate actively in the discussion and contribute to the rich intellectual discourse. The success of this seminar truly lies in your engagement and enthusiasm. We are grateful to the authors whose scholarly articles and papers feature in our souvenir. Your research enriches the literature on the future of law. And even of this magnitude requires meticulous planning and execution. I wish to express my heartfelt appreciation to the organizing committee and all other subcommittee members, my fellow faculty members, and administrative staff for their tireless effort, dedication, and teamwork. A special note of thanks to our dedicated student volunteers. Your energy, enthusiasm, and hard work in managing logistics and countless other tasks have been instrumental in the smooth conduct of this seminar. Last but not the least, we thank the media partners and all other well-wishers for their support and coverage. As we disperse today, we carry with us new ideas, strengthened networks, and a renewed commitment to navigating the future of law with integrity and innovation. Thank you all once again for making this national seminar a memorable and impactful experience. Thank you all.
Actually, few more presenters are missed out. I just call the names. C.H. Meghana. At least just say. C.H. Meghana. Srujana. Mansa. Kalaimagal. Srivardhini. You please go to that room, we will write. Srivardhini. Mehak Nizamuddin. N. Pravina. R.V. Taruna and B. Sandhya. Taruna and Sandhya. Sadhana. మా వాళ్ళ పేర్లు కూడా చెప్పు. భాగ్యలక్ష్మి డి. బాలా జయకుమరన్ డి. సర్టిఫికెట్ తీసుకోండి. అజీర్ అహ్మద్. జ్ఞాని Madhavi?
సర్టిఫికేట్ ఇష్టం కదా తీసుకుంటే ఆల్రెడీ గివెన్ తేజ సాయి తేజ ఎస్ Now, finally, I request all the teaching faculty, students to stand up for national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जाए तव शुभ आशीष मागे गाहे लव जय माता जनगण मंगल जय हे भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request all the students, please sit down. First, we allow the teaching faculty and also our resource persons first. And after their leaving only, you have to move. I request all the students be seated. Be seated. Then after leaving our resource persons, teaching faculty, then you have to move. I request the volunteers to coordinate with the students.
Thank you, you called me. Great.
Hello, check. Sir.
My dear students and faculty members, tomorrow is an emergency meeting in the college. And due to emergency meeting, all the classes are suspended. Thank you.